17, one sentence only. That's 156. Page 156, para 17. Therefore, my lord, when this Honorable Court was considering this notification had come into force and it was brought to the kind notice of the Honorable Court, that was not directly under challenge. If the appointment of the guest lecturer under the impugn notification at so and so has come to an end, impugn notification dated 38/2024 is to fill up the post of guest lecturer of the academic year 24-25. It is appropriate to direct response 1 and 2 to ensure that only those who fulfill the minimum qualification as prescribed by UGC guidelines are selected.
Yes, comply with this order. Whatever selection that you make should be in line with the order passed by this court.
Please, madam, we have already given instructions to the.
AG is directed to accept notice for respondents 1 and 2. Shauri for respondent number 3. In view of the order passed by this court in WP number 23600 of 2023, dated
No, my lord, this is dated 5/9, my lord.
5/9.
5/9/2024.
5/9/2024. The respondents 1 and 2 shall ensure that the directions contained therein shall be followed while finalizing the recruitment of guest lecturers as per the notification dated 38/2024.
24, my lords.
Yes.
Now, my lord, they have published a guest faculty candidates list where they have added everybody without qualification also, my lords.
Now I passed an order that they have to comply.
That
My
was
lords,
also-
without, let them not publish.
Also,
That notification also was
Sunday
considered.
had moved an application.
Yes,
That
showing
also
the-
that was considered. That was.
And sought for a
Yes.
clarification that
Modification.
your lordship has said. That
Follow it.
state has said that that list is not a
Same
list.
order
list,
passed in
total
your
list.
case also.
Please.
We have directed the state government to look
Follow
into that order and follow it. While
Please, my lord,
finalizing-
without following it, they have issued a
That list is
list,
not
my
a-
lords.
Still not finalized.
We have made a submission that
11/9.
it is only list of
Please.
candidates.
Still not finalized.
That your lords may kindly hold. Let them not finalize, my lords, without adding the list, because
No, no,
11/9,
Bardi country, don't
Please.
finalize without following the order passed by this court. Anta. If it's only a merit list,
please, don't limit list.
if it's only a merit list, then they have to declare the provisional select list based on the order passed by this court.
Please, my lords.
Then a finalist,
Please,
then appointment,
Please, my lords.
then reporting.
Please, my lords. Now let them not render it infructuous because the holidays will come, my lords.
I told the directed the state government to.
There is
look
an
into
order.
the order.
There is a continuation order after this order.
Oh, there's-
Because Mr. Surya has moved interim
Yes,
application.
I remember, I remember.
ಅದು ನೋಡಿ ಅವ್ರು.
Grateful,
Grateful, my lords.
For orders matter, serial number 5. Vipaksha
30th,
PH.
30th, definitely
Not
he is
pressing
coming.
this application, my lord, sir.
Monday.
It was filed for extension of.
IA 1 of 22. Filed by the petitioner is
Monday.
not present.
Yeah, we are looking at
It was
October,
rejected.
that is what.
Yeah.
Okay. September 1st, he says that the tournament is
Serial number,
Srinivasa,
serial number 6, Srinivas K.
Lord, I appeal to the petitioners. My lord, but on the last occasion, this honorable court had prima facie expressed a opinion. Why don't you create a supernumerary post
yeah.
in respect of these two candidates, my lord? I have intimated the institute regarding this opinion you expressed by this honorable court. My lord, now the chief administrative officer has requested some more time to place it before the governing council committee and the financial committee, this view, and wait for their decision, because director is
For
not
the
there, he is
respondent-
suspended.
Learned counsel for the respondent number 3 submits that the respondent number 3 is examining the order dated 29/2024 passed by this court. Full stop. He therefore requests for time.
Respondent two, my lord.
Respond 2, not 3 now.
Two.
He therefore requests for time. Liston yavat. Do you want it?
After vacation, any day.
Take whichever date you want.
24th,
ಇಲ್ಲ ಅಷ್ಟು ಲಾಂಗ್ ಬೇಡ ಸೆಕೆಂಡ್
24th, because vacation,
Aye.
24th.
I displayed the calendar. I told we take whichever date you want. Still you waste time.
serial number 7, Chetan A.
Third week, any day.
ಅಲ್ಲಿ ಥರ್ಡ್ ವೀಕ್ ಅಂದ್ರೆ ಗೊತ್ತಾಗ್ತಲ್ಲ ಡೇಟ್ಸ್ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ ರೆಡ್ ಲೈನ್ ಇಸ್ ಹಾಲಿಡೇ, ಗ್ರೀನ್ ಇಸ್ ರೆಸ್ಟ್ರಿಕ್ಟೆಡ್ ಹಾಲಿಡೇ, ಬ್ಲಾಕ್ ಇಸ್ ವರ್ಕಿಂಗ್ ಡೇಸ್. ಸೊ ಇಫ್ ಯು ಕೆನಾಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಹೌ ದ ಕ್ಯಾಲೆಂಡರ್ ವರ್ಕ್ಸ್ ಐ ಆಮ್ ಎಕ್ಸ್ಪ್ಲೈನಿಂಗ್ ಇಟ್.
No, my lord.
ಮತ್ತೆ 3 weeks ಅಲ್ಲಿ ಇದೆ. ಥರ್ಡ್ ವೀಕ್ ಅಂದ್ರೆ ಪಿಕ್ ಎ ಡೇಟ್ ಆಫ್ ಯುವರ್ ಚಾಯ್ಸ್ ಮಿಸ್ಟರ್.
Lord, for the petitioner in this case, My lord, kindly, my lord, on 18th January 2024, notices were issued to the respondent number 2 and 3. Kindly peruse order sheet dated 18/1/2024, my lord. But now that has been listed for non-compliance of, non-payment of PF for paying
Yaar Chetan yaar. You are
Ma-
Chetan.
petitioner, madam, petitioner.
What about this process to R2 and R3?
It was already been complied, my lord, that was paid on 10th of January 2024.
Adenaಗಿದೆ? Check what has happened to that process.
No. Meanwhile, in the last date of occasion, it was listed for awaiting notice for respondent number 2 and 3, my lord.
ನೋಡ್ರಿ ಇದೇನಾಗಿದೆ process ಕೊಟ್ರು. ಹಾ? ಏನಾಗಿದೆ? ಚೆಕ್ ಮಾಡಿ ಪಾಸ್ವರ್ಡ್. Yes. Satish K.
Serial number 8, Satish K.
Lord, for vacating, it's as good as hearing, Lord, it may be called after vacation, Lord.
Yes. Who has filed this application?
My lord, the state has filed this application. my lord. So they're asking for time, my lord, kindly have it on 22nd of,
The learned senior counsel representing the petitioner submits that hearing on the application for vacating stay would invariably result in hearing the petition on merits and therefore praised.
kindly have it on 22nd of,
List on 22nd October.
please.
24, my lord,
ಯಾವತ್ತಾದ್ರೂ ತಗೊಳ್ಳಿ
24.
24th October.
Interim order may be actually.
Interim order granted early is extended till the next date.
Serial number 9, Vijay Gowda L. Serial number 9.
Appear for petitioner, my lords.
What about process?
My lords,
Process.
process good.
PF.
Paid, my lords.
Huh?
Paid, my lords.
R2 to R6.
Yeah. My lords, paid, my lords.
Huh? Where's the acknowledgement for having paid the process? You know what is the meaning of process?
Yes, my lords.
Where have we paid?
Counter, my lord.
Okay, when have we paid?
1 week back, my lords.
Huh?
A week back, my lords.
Do you have an acknowledgement for having paid the
A
process?
colleague has it.
1 week time is granted to do the needful.
Serial number 10,
Great.
Pushpalata Y.
My lord, I'm appearing for respondent number 1. I'll undertake to file an wakalat.
Or
Respondent number 1,
what's your name, madam?
Nikita,
No, whose name should appear in the cause list?
Sudanwa DS.
Mr. Sudanwa DS submits that he has appeared for he has filed appearance for the respondent number 1. Office is directed to check, verify and show the name of Mr. Sudanwa DS as the counsel for respondent number 1. List on date.
Maybe Tuesday, October. Serial number 11, Virupakshaya PH.
Huh?
It's only remind, my lord, in this
I no, first let them file whatever they want to file response if they have.
oblige.
Mr. Virupakshaya,
That's hearing for the petitioner.
list after service of notice to respondent number 5.
I have filed wakalat and also statement of objections, my lord. Maybe heard, my lord, it's a small matter, my lords, wherein.
Filing my statement of objections, I'm
Lord.
updating for the respondent number 1 to 4, my lord.
Yes, what is the case?
Petitioner is the group C employee, my lord. She has completed her tenure. I have produced the biodata of the petitioner in annexure R6, page number
Copy of the
32.
I
my lord.
let him argue.
Okay.
Yes, what is your case?
My lords, the petitioner, my lords, is working, my lords, as junior engineer, my lord.
When was he posted?
My lords, if your lordship kindly peruse annexure A, my lord,
Annexure A.
dated 31/7/2024, my lord. The petitioner, my lords, at serial number 1, my lord, Soumya. She is, my lords, working as junior engineer, MC Raste Shake, Karya ಮತ್ತು ಪಾಲನ ಉಪವಿಭಾಗ, ಮಂಡ್ಯ ವಿಭಾಗ. She is posted, my lords, to the place of Lokesh Chavan to Kottati Shake, Karya ಮತ್ತು ಪಾಲನ ಉಪವಿಭಾಗ, Kottati, ಮಂಡ್ಯ ವಿಭಾಗ, my lords. This order, my lords, is passed on 31/7/2024, my lord. My lords, on the same day, my lord, if your lordship kindly peruse annexure C, my lord. This, my lord, is passed by the first respondent authority, my lords, on 31/7/2024. On the request, my lord, made by the respondent number 5, my lord. My lord, if your lordship kindly peruse serial number.
No, on the same day it was passed.
On the same day, my lord. In fact, if your lordship kindly peruse, my lord, serial number Ravi Chandra, my lords, serial number 139, my lords, at page 34. This, my lord, this is not an order of transfer, my lords. However, it is approval, my lords, for transferring, my lords, the fifth respondent in place of the petitioner. My lords, if your lordship kindly peruse page 24, my lord. It says, my lords, ವರ್ಗಾವಣೆಗೆ ಅನುಮತಿ ನೀಡಲಾಗಿದೆ. My lord, at serial number 139, my lords, the respondent number 5.
Some general transfer ಓದಿ. 2024
ಸಾಲಿನ ಸಾರ್ವತ್ರಿಕ ವರ್ಗಾವಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಸರ್ಕಾರದ ಆದೇಶಗಳ ಅನ್ವಯ ಈ ಕೆಳಗೆ ತಿಳಿಸಲಾದ ಕಿರಿಯ ಇಂಜಿನಿಯರ್ ರವರುಗಳನ್ನು ಅವರ ಹೆಸರಿನ ಮುಂದೆ ನಮೂದಿಸಲಾದ ವೃತ್ತಕ್ಕೆ ವರ್ಗಾವಣೆಗೆ ಅನುಮತಿ ನೀಡಲಾಗಿದೆ. My lords, in the last column, my lords, it says ವರ್ಗಾವಣೆ ಕೋರಿರುವ ಸ್ಥಳ. My lords, at serial number 139, my lord, page 34. That is, my lord, Ravichandra, that is the respondent number 5, my lord. He requests, my lord, the transfer to the place of the petitioner, my lord, MC Road Shake, ಕಾರ್ಯ ಮತ್ತು ಪಾಲನಾ ವಿಭಾಗ, ಮಂಡ್ಯ. My lord, the first respondent authority, my lords, approves, my lord, grant sanction, my lords, approval for transferring, my lords, the fifth respondent in place of the petitioner herein, my lord.
Yes.
In terms of this approval, my lord, Annexure D dated 9/9/2024, my lord, page 42 is passed, my lord. Now, my lord, the respondent number 5, my lords, who is working, my lords, as junior engineer KPTCL TLM Mandya Shake, my lords, has been posted in place of the petitioner. And the petitioner, my lords, by virtue of posting, my lords, the respondent number 5 in place of the petitioner, she is now posted, my lord, to the place of respondent number 5. My lord, Annexure C, my lord.
Yes, how many times do you give this benefit
no.
of posting to respondent number 5?
No, my lord, I'll make the submission. My lord, as per the general transfer order, my lord, on the same day, the one more transfer order is passed by the CESCOM, my lord, based on the request made by the petitioner. That was the mutual transfer, my lord. After that, my lord, when.
Annexure A is a mutual transfer.
Yes.
Yes, my
Yes.
lord, it is a mutual transfer.
ಯಾವುದು?
Lokesh, my lords, Lokesh Chavan, my lord.
Lokesh and Soumya together has done the mutual, requested for the mutual transfer. ಈ ಕೆಳಕಂಡ ನೌಕರರನ್ನು ಅವರ ಹೆಸರಿನ ಮುಂದೆ ನಮೂದಿಸಿದ ಸ್ಥಳಕ್ಕೆ ಸ್ವತಃ ಕೋರಿಕೆಯ ಮೇಲೆ mutual transfer. On the same day, we have done transfer, my lord, and the general transfer was also there. Then we have sent a clarification for the general manager of the HR, human resources of the CESCOM, my lord. I have produced my statement of objections. The HR has directed the SC, my lord. The general transfer has to be taken into applicable and this will be withdrawn, my lord.
No, but how can you withdraw it after it is done? After this man is, Lokesh has been moved out.
Since my lord, she has she is a C group employee, my lord. She has completed her tenure. She was working in the same place from 6 years, 5 months, my lord.
See, the transfer guidelines dated 25/6/24
Yes, my lord.
do not permit mutual transfers, correct?
Yes, my lord.
Does it permit mutual transfers? It does not permit mutual transfer. You
Yes.
have permitted mutual transfer, right or wrong, you have done it. So once you have done it, where's the question of revisiting it by saying that under general transfers, we are going to send you out? ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
General transfer ಅಲ್ಲಿ ಸೌಮ್ಯಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಕೊಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಸೌಮ್ಯ ಕೊಡ್ಲಿಲ್ಲ, ರವಿಚಂದ್ರನ್ ಕೊಟ್ರಿ.
ಸೌಮ್ಯನ್ ಜಾಗಕ್ಕೆ ರವಿಚಂದ್ರನೇ ಕೊಟ್ರು. ನಾವ್ ಅದು ಎರಡೂನು ಇಲ್ಲಿ ಸೆಸ್ಕ್ ನಾವು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದು ಮತ್ತೆ KPTCL ಮಾಡಿರೋದನ್ನ we sent it to the higher officials for the which has to be followed ಅಂತ. The higher official has sent in reply to that, the general transfer has to be followed ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
Right, you please read what is the provision relating to general transfer. ಓದಿ. It will be kept to the minimum ಅಂತಿದೆ. If I remember. Please read. Produce ಮಾಡಿದಿರಾ?
My lords, page 22, my lord,
Sir, B.
Annexure B, my lord.
ಓದಿ.
my lords, clause 6, my lord. ಒಂದು ಸ್ಥಳದಲ್ಲಿ ಈ ಕೆಳಗೆ ಸೂಚಿಸಿರುವ ಸೇವಾವಧಿಯನ್ನು ಪೂರ್ಣಗೊಳಿಸದ ಯಾವುದೇ ಸರ್ಕಾರಿ ನೌಕರನ್ನು ಸಾಧಾರಣವಾಗಿ ವರ್ಗಾವಣೆ ಚಲನವಲನ ಮಾಡುವಂತಿಲ್ಲ.
ನನ್ನ ಸಾರ್ವತ್ರಿಕ ಇದು ವರ್ಗಾವಣೆ ಓದಿ. ಕ್ಲಾಸ್ 5 ಓದಿ.
ಕ್ಲಾಸ್ 5 ಈ ಕೆಳಕಂಡ ಸಂದರ್ಭಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಿಗಳು ವರ್ಗಾವಣೆಗಳನ್ನು ಸಾರ್ವತ್ರಿಕ ವರ್ಗಾವಣೆ ಅವಧಿಯ ನಂತರದಲ್ಲಿ ಮಾಡತಕ್ಕದ್ದಲ್ಲ. ಒಬ್ಬ ಸರ್ಕಾರಿ ನೌಕರರನ್ನು ಸೇವೆಯಿಂದ ಅಮಾನತುಪಡಿಸುವ ಬದಲು ವರ್ಗಾಯಿಸಲು ಚಲನವಲನಗೊಳಿಸಲು ಉದ್ದೇಶಿಸಿದಾಗ, ಹೊಸ ಕಚೇರಿ ಹುದ್ದೆಗಳನ್ನು ಸೃಜಿಸಿದಾಗ ಅಥವಾ ನಿವೃತ್ತಿ, ಬಡ್ತಿ, ರಾಜೀನಾಮೆ, ಹಿಂಬಡ್ತಿ ವಜಾಗೊಳಿಸಿರುವುದರಿಂದ ಮರಣದಿಂದ ಕಡ್ಡಾಯ ನಿವೃತ್ತಿಯ ಕಾರಣದಿಂದ ಹುದ್ದೆಗಳು ತೆರವಾದಾಗ ಅಥವಾ ನೇರ ನೇಮಕಾತಿ ಹೊಂದಿರುವುದನ್ನು ಮೊದಲು ನೇಮಿಸುವಾಗ ಅಥವಾ ಬಡ್ತಿ ಹೊಂದಿರುವುದನ್ನು ನೇಮಿಸುವಾಗ ಅಥವಾ ಯಾವುದೇ ಅನಿರೀಕ್ಷಿತ ಪರಿಸ್ಥಿತಿಯಿಂದ ಉದ್ಭವವಾದ ಹುದ್ದೆಗಳನ್ನು ತಕ್ಷಣ ತುಂಬಬೇಕಾದಾಗ ವಿಶೇಷವಾದ ಅಥವಾ ಅಪವಾದಾತ್ಮಕ ಕಾರಣಗಳ ಮೇರೆಗೆ ಮಾಡುವ ವಾರ್ಷಿಕ ವರ್ಗಾವಣೆಗಳ ಸಂಖ್ಯೆಯನ್ನು ಕನಿಷ್ಠ ಮಟ್ಟಕ್ಕೆ ಸೀಮಿತಗೊಳಿಸಿ ನಿರ್ದಿಷ್ಟ ಪ್ರಕರಣಗಳಲ್ಲಿ ವರ್ಗಾವಣೆಯು ಅವಶ್ಯವೆನಿಸಿದ್ದಲ್ಲಿ ಇಂತಹ ಪ್ರಕರಣಗಳನ್ನು ಚಾಚೂ ತಪ್ಪದೆ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಿಗೆ ಸಲ್ಲಿಸಿ ಅವರ ಅನುಮೋದನೆ ಪಡೆದು ವರ್ಗಾವಣೆ ಮಾಡತಕ್ಕದ್ದು.
ಎಲ್ಲಿದೆ ಮುಖ್ಯಮಂತ್ರಿಗಳ? Now she has been transferred
Yes,
by mutually or whatever.
yes,
She has been transferred. So
It
she
is
is
not
entitled for
acted
a
upon.
minimum tenure.
That order is not acted upon. She has not relieved from that
Relieved from
place.
Whatever
She
it is.
wants to continue in that MC road. That's why, my lord, all these are happening. If she wants to go to Kottatti, that's a different issue, my lords. Somebody else, my lord, then Lokesh may have a locus standi to contest this.
No.
She has continued here from last 6.5 years.
6.5 years. she was there in
And
the
now,
same-
my lords, her transfer, that too, my lord,
Okay.
from this office to that office. Compound
Respondent
Pakkal
can
iro
do it.
office ಗೆ transfer
The
ಮಾಡಿರೋ.
respondent can do it, provided they follow the due process. They follow the due process.
Yes, my
Number
lord.
one,
Here,
please
my
write
lord, only
the-
one submission is this, my lords. Here, the general transfer was made. My lords, perhaps by oversight or I should not be making the submission without, but she, at her instance, another transfer has happened, which is by Chescom.
Oh.
Hence, my lord, then there was an ambiguity, then it's a general transfer time. On the very same day, general transfer is made, you give effect to this is the clarification that is in terms of transfer
The
guidelines.
problem is the annexure A was the first.
No, annexure B was first.
It was, annexure A was the first in point of time.
No, they have filed annexure A as well. Annexure C is also done on the same day.
Same day, my lord.
ಆಯ್ತು, ಯಾವ್ದು ಫಸ್ಟ್ ಅಂತ ತೋರಿಸಿ ಹೆಂಗಿದೆ.
ಅಲ್ಲ, ಎರಡು ಒಂದೇ ದಿವಸ ಆಗಿರೋದು.
ಒಂದೇ
So,
ದಿನ
ಯಾವ್ದು-
ಆಗಿರೋದ್ರಿಂದ ಟೈಮ್ ಅಂತ ಅದ್ರಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಬರ್ದಿಲ್ಲ.
And then you could not have considered the mutual
No.
transfer. See, the general transfer is already taken.
That's why that is withdrawn.
No, my lord, on the same day it was taken, my lord. Even the Sescom do not have a knowledge about the general transfer. This was published, my lord. By the
Like a
evening,
man.
we came to know like that. Then immediately we sent to the concerned higher official, which order has to be followed. my
Madam,
lord.
Chescom, you have accepted a mutual transfer. You have accepted a mutual transfer,
Yes, my-
correct alva?
yes, my lord.
Then it is for the head office to decide who
Yes,
should
my lord.
go.
Head office has decided, we will withdraw the transfer order, mutual transfer, then the general transfer will be applicable. That is also, my lord. She was working where she was transferred on Sescom, my
Yeah,
lord.
why did you allow this mutual transfer is what I am asking you. Why did you allow this mutual transfer? Yes.
Lords,
From
the
how
order,
long you are there?
my lords, at MC Road, my lords, I have completed my tenure.
Ah.
My lords, in terms of this order at annexure A, my lords, I have to, my lords, report to Kottatti Shake, my lord.
No, but this mutual transfer is not placed before the chief minister.
My lord, this is by the appointing authority, my lord, my lord.
Correct. Mutual transfer is not known to the transfer guidelines now. ಮುಂಚೆ ಇತ್ತು.
My lords, this annexure C order, my lords, dated 31/7, is also, my lord, on the request of respond number 5. If your lordship kindly peruse page 24, my lord. This also, my lord, if you, page 24, my lord, the last column. On their request, ವರ್ಗಾವಣೆ ಕೋರಿರುವ ಸ್ಥಳ.
Yes.
However, my lords, while passing this order, my lord, at serial number 139, they don't even appreciate the fact that, my lords, the petitioner is working, my lords, at MC Road, Shake, my lord, where the respond number 5 is proposed to be posted. In fact, this order, my lord, is only, my lords, approval, my lords, for transferring the respond number 5 in place of the petitioner. It does not even say, my lord, that the petitioner is working in the said post.
I don't know why everybody wants to go to O&M.
My lord, at the request of respond number 5, my lord, this order is passed. My lord, the petitioner, she is, my lord, a lady, my lords, she has a one-year-old,
My lord,
one-year-old baby, my lords.
So it's in the
My
same
lord,
building.
Same
Allah,
building.
my
Lord,
lord,
now
same
now-
thing, my lord.
My lord, it is respond number 5, my lord. At his request, this order is passed. My lord, the petitioner, my lord, she has a one-year-old baby, my lord. She has to take care of the baby. Now, by virtue of this order, my lord, at page 42, my lord, she has been posted to the place of respond number 5, my lord, TLM Mandya Shake, my lords, which involves field work, my lords. Now, my lord, she has to take care of the baby also.
TLM is not field work.
My lords, it is, my lords, as per my instructions.
As per the transfer.
Line management. TLM ಅಂದ್ರೇನು? What is TLM?
ಕಾರ್ಯ ಮತ್ತು ಪಾಲನಾ ವಿಭಾಗ.
ಅಲ್ಲ, ಅಲ್ಲ.
Transmission
ಅದು
and
O&M, TLN.
O&M is overseas and maintenance. TLM ಅಂದ್ರೆ
O&M ಅಂದ್ರೆ ಕಾರ್ಯ ಮತ್ತು
TLM.
ಪಾಲನಾ ವಿಭಾಗ. TLM ಅಂತ.
TLM. ಯಾರ ಇದಾರೆ ಕೇಳಿ, ನಿಮ್ಮವ್ರು ಯಾರು ಇದ್ರೆ. Transmission line maintenance.
Yes.
ಏನಿದೆ ಇದ್ರ?
My lords,
And
my
he
lords,
is also.
he is, my lords, it is, my lords, at the instance of respondent number 5, this order is passed. My lord, if the order at annexure A is implemented, my lords, then my lords, the respondent number 5, my lords, could not have been placed in place.
O&M is more work than TLM.
My lord, it is administrative work, my lord. My instructions are, my lord, now,
Tenure there, my lord.
You're a junior engineer in O&M. You know what is a junior engineer in O&M means? He has to be on the field. It's maintenance of lines.
my lord, by virtue of this order at annexure A, my lord, she is posted to Kottati branch, Kottati Shake.
No. Please go back. If you
Lord,
already
the-
completed your tenure,
My lord, I will, my lords, by virtue of annexure A, my lords, at least this order has to be given effect to, my lords. I have to be posted at Kottati at least.
this order is invalid because it is not reserved for the for approval by the chief minister.
My lord, my lords, even the order, my lords, at annexure C, this is also, my lords, not approved by the honorable chief. It is only on the request, my lords, of respondent number 5.
General transfer.
My lord, it is approved.
Please, general transfer. Please read.
My lord, it is-
Guideline 4. Guideline 4 ಓದಿ.
It is according sanction, my lords, to transfer the respondent number 5 in place of the petitioner.
Yes, Barkul.
It is only on their request, my lord, and also without considering that I am working, my lords, in that place. This order is passed, my lord.
Rule 5.3 ಒಂದ್ಸತಿ ಓದಿ. Read 5.3. ವಿಶೇಷವಾದ ಅಥವಾ ಅಪವಾದಾತ್ಮಕ ಕಾರಣಗಳ ಮೇರೆಗೆ
Please.
ಮಾಡುವ
ವಾರ್ಷಿಕ ವರ್ಗಾವಣೆಗಳ ಸಂಖ್ಯೆಯನ್ನು ಕನಿಷ್ಠ ಮಟ್ಟಕ್ಕೆ ಸೀಮಿತಗೊಳಿಸಿ ನಿರ್ದಿಷ್ಟ ಪ್ರಕರಣಗಳಲ್ಲಿ ವರ್ಗಾವಣೆಯು ಅವಶ್ಯ ವಿಧಿಸಿದಲ್ಲಿ ಇಂತಹ ಪ್ರಕರಣಗಳನ್ನು ಚಾಚು ತಪ್ಪದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಿಗೆ ಸಲ್ಲಿಸಿ ಅವರ ಅನುಮೋದನೆ ಪಡೆದು ವರ್ಗಾವಣೆ ಮಾಡತಕ್ಕದ್ದು.
So, ನಿಮ್ದು ಮ್ಯೂಚುವಲ್ ಟ್ರಾನ್ಸ್ಫರ್ ಎಲ್ಲಿದೆ? ಮ್ಯೂಚುವಲ್ ಟ್ರಾನ್ಸ್ಫರ್ ವಿಶೇಷವಾದ ಕಾರಣ ಅಂತ ಅನ್ಕೊಂಡ್ರು ಕೂಡ ಇಟ್ ಶುಡ್ ಬಿ ಪ್ಲೇಸ್ ಬಿಫೋರ್ ದಿ ಚೀಫ್ ಮಿನಿಸ್ಟರ್.
My lord, that order, my lords, even, my lords, the person who is posted in place of the petitioner, Lokesh Chavan, my lords, he is not agreed, my lord, and also petitioner, that has been given effect to, my lords, and my lords, the
Yes.
impugned order, my lords.
See, this is the way you people indulge in being in one place, to be in one place.
My lords, if this order is given effect to, my lord, then, my lords, at least I have to report at Kottati village, Kottati Shake, my lord, Kottati branch. Now, my lords, by virtue of the order, my lords, at annexure C,
Now this is no order, annexure A is no order. So therefore, as per the general transfer, you hand over charge to the respondent number 5.
That annexure is withdrawn by the already, my lord, that cannot.
Barkul. The petitioner has challenged her transfer in terms of the order dated 9/9, in terms of the order bearing number so and so dated 9/9/2024. Passed by the respondent number 3, na?
2, my lord.
Respondent number,
2. General manager, Pradhana.
madam, this 9
Respondent number
September
3.
is
In here,
respondent number 3.
Yes.
Next para. The petitioner was posted as a junior engineer electrical O&M subdivision, MC Road, Chescom, Mandya during April 2018. Full stop. After completion of her minimum tenure at the said post, comma, the petitioner and another junior engineer made a request for mutual transfer, which was accepted by the respondent number 3 on 31/7/2024. And the petitioner was transferred to Kottati branch, O&M subdivision, Kottati, Mandya. Full stop. Later, the respondent number 2,
1 month.
respondent number 1 initiated process for general transfer in terms of which, comma, 226 officers were transferred. One of them was the respondent number 5, who was transferred and posted at
Item number 139.
MC Road branch, O&M subdivision, Chescom, Mandya. The respondent number 3, in terms of the impugned memorandum, then transferred the petitioner to the place of the respondent number 5, and the respondent number 5 was transferred and posted to the place of the petitioner. Full stop. Being
In
agreed with the
fact, I have
same,
taken charge also.
the petitioner is before this court. Next paragraph. The learned counsel for the petitioner contends that the petitioner was initially transferred and posted on 31/7/2024 as the junior engineer at Kottati branch O&M subdivision, and therefore she was entitled to continue for the minimum tenure of 4 years as prescribed under the guidelines issued by the state dated 25/6/2020, state government dated 25/6/2024. Full stop. He contends, it is contended that the impugned order of general transfer is at the behest of the respondent number 5 and not guided by any administrative exigencies. Full stop. It is therefore contended that the impugned order of transfer being tainted is liable to be set at naught. Next paragraph. The learned counsel for the respondents 1 to 4 submitted that the order posting the petitioner at Kottati branch O&M subdivision, Mandya, on wide annexure A dated 31/7/2024 was withdrawn
On 6/9/2020.
on 6/9.
2024.
6/9/24 in view of the general transfer undertaken by the petitioner respondent number 1, in terms of which the respondent number 5 was posted at MC Road branch O&M subdivision, Mandya, where the petitioner was earlier posted. Full stop. She contended that in view of the general transfer, the respondent number 5 is now posted, view of the general transfer to so and so, and in view of the petitioner completing the minimum tenure at her earlier posting, the impugned official memorandum is issued, posting the respondent number 5 to the place of the petitioner. She contends that the impugned official memorandum is therefore just and proper and does not violate any of the transfer guidelines and therefore does not warrant interference. The learned counsel for the respondent number 5, on the other hand, contends that the petitioner has been working in the as a junior engineer at MC Road branch O&M subdivision from the year 2018 and had completed her minimum tenure. However, in order to avoid the transfer, in order to avoid she being transferred, she and a person named Mr. T. Lokesh Chauhan requested for a mutual transfer. As a result, the petitioner was transferred and posted at Kottati branch, while Mr. T. Lokesh Chavan was posted at MC Road branch. Full stop. He contends that this was a ploy to continue to remain in the same office. Full stop. He further contends that this mutual transfer is not permitted under the guidelines, transfer guidelines dated 25/6/2024. And the same was not approved by the Honorable Chief Minister and thus was not given effect to. Full stop. He contends that the respondent number 5 has already taken charge at MC Road branch, and hence this petition does not survive for consideration. Next, I have considered submissions of the learned counsel for the petitioner and the learned counsel for the respondents. Next para. The petitioner was indeed transferred and posted at Kottati branch, O&M subdivision, Kottati, in terms of the order dated 31/7/2024, passed by the respondent number 3. However, this was a request, however, this was a transfer based on a mutual request by the petitioner and a person named Lokesh Chauhan. As per the guidelines, transfer guidelines dated 25/6/24, any such mutual transfer should be escalated by the respondent number 3 and placed before the Honorable Chief Minister for approval. Since that is not done, the order accepting the mutual transfer of the petitioner and Mr. T. Lokesh Chauhan is still bond and was not given effect to. However, on the same day, the respondent number 1 has taken out proceedings for general transfer of all those persons who had completed their minimum tenure at their respective posts. The petitioner, having completed her minimum tenure at the MC Road branch, was liable to be transferred. In that regard, the respondent number 5 was transferred and posted to the place of the petitioner at MC Road branch, followed by the impugned order dated 9 September 2024. In terms of which, the petitioner is posted to the place where the respondent number 5 was posted, and the respondent number 5 was transferred and posted in place of the petitioner. Full stop. Therefore, there is no error committed by the respondent number 1 in giving effect to the general transfer and transferring the petitioner out from the Mandya division,
MC Road branch.
MC Road.
MC Road branch, O&M division, Mandya. It is also stated that the officers of both MC Road branch, O&M division, and the PLM division of the KPTCL are located in the same building. Full stop. In that circumstance, the petitioner cannot have any grievance over a transfer. In that way of the matter, this writ petition lacks merit and is dismissed.
My lords, I make one request, my lord. But considering the fact that petitioner, my lords, has a 1-year-old baby, my lord, I'll make representation, my lords, to any other, my lords, place that may be considered.
Well, if the law permits, do it.
Lordship may kindly observe, my lord.
I will not make any observation. Yes.
List number 2 for orders matter, serial number 1.
The B.R. Srinivas Gowda.
Yeah, Srinivas Gowda.
My lord, I am for the petitioner.
Ah.
My lord, I am seeking it should be passed over at 2:30. Because
2:30.
my senior, he has gone to pay that 2,000 imposed on him, 2,000 rupees imposed on him that he went to bar.
I will not insist on the cost provided you argue the matter.
he, pass over, my lord, please. I'm seeking 2:30, he will come and argue.
Pass over.
Oblige, my lord.
Serial number 2, Vishwanath MS. Vishwanath MS.
Petitioner, my lord.
In the office objections is state. Not MS.
In respect of,
You are not served a copy.
We have
Okay,
served, my
sir.
lords, we have not, sir, we have not produced the acknowledgement. Receipt matra hakidvi. We have
Copy
served,
ಕೊಟ್ಬಿಡಿ.
you have not received the copy?
Objection
We've
ಸಿಕ್ಕಿಲ್ವಾ?
received-
the statement of objection, no?
have
Is
received-
there with,
Learned counsel for the petitioner submits that he has received copy of the statement of objections filed by the respondents 3 and 4. In his office objections raised on the statement of objections is complied. Ready, na? Ready?
yes,
Yeah,
some medical in reimbursement of rupees 61,000 rupees, my lord.
yeah.
During the COVID period, it was in peak, my lord. The petitioner's son met with an accident in Mandya, my lord. So he tried to admit the relevant hospital is recognized by the government, but he failed to get the hospital, Your Honor. Finally, he succeeded to admitted in Aditya Hospital in Mysore, my lord. He got treated, but for expenses incurred, he filed an application to the authority, the respondents, but respondent number 4
When was he admitted?
on 5/6/2020, my lord.
Yes, madam.
That's the government is
Sir,
to.
my lord, our all files has taken by the register of judicial. Now letter ಬರ್ದಿದ್ದೀವಿ, kindly return back ಅಂತ 5 times.
It is, their copies ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ, ನಮ್ದು ಮಾತ್ರ ಇದೆ.
ನಮ್ದು
ಅವ್ರ್ದು
ತಗೊಂಡೋಗಿ
ಇಲ್ಲ.
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರು.
ಆಯ್ತು, ನೀವು ಪ್ರೋಸೆಸ್ ಮಾಡಿ ಕಳ್ಸಿದ್ದೀರಾ?
ನಾವ್ ಕಳ್ಸಿದೀವಿ. They have said there was no emergency situation that we could reimburse ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ಅವರೇ ಹೇಳ್ಬೇಕು.
You are bound to reimburse it if the.
File ಇಲ್ಲ,
hypothesis-
my lord.
Huh?
Files has taken by the register of judicial. ನಮ್ದು ಎಂಟರ್ ಒಂದು 200 ಫೈಲ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ. And we have written letter also. ರಿಟರ್ನ್ ಮಾಡಿ ಅಂತ. ರಿಟರ್ನ್ ಮಾಡಿಲ್ಲ ಅವರು. 2-3 times ಫೋನು ಮಾಡಿದೆ, ನಾನು ಮಾಡಿಲ್ಲ.
Yes, madam.
Wherever, in the
If you have the
beginning.
files, why don't you return to the government?
No, my lords. Wherever the Registrar General was a party, in the previous occasions, my lords, the government only would appear. Now there are separate panel advocates, only those files are with us.
No,
These
entire files,
files-
madam, more than 300, 200
I'll
files.
find out. If it's there, I'll do
More
that.
than 300. I have written signature from the register of judicial.
I'll find out.
Yeah, what was he suffering from?
Left,
What was he suffering from?
It is given a right of Windows.
serious right side head, Your Honor.
Multiple abrasion over the left side of forehead,
It was an
face,
accident.
left lateral aspect of forearm, or bilateral knee joint. ಏನ್ ಬಿದ್ದಿದ್ದ ಇದು?
ಬಿದ್ದಿದ್ದು accident ಆಗಿದ್ದು.
Accident.
There was no emergency situation that he had to go to that hospital and not to
Well,
the
Lord,
recognized
on that
hospital.
time, even
That is what.
nobody ready to get admit the patient, my lord.
COVID-19 time. my
Such a
lord.
serious situation, man.
It was in June 2020, then COVID was at its peak.
Yes, man.
ಮತ್ತೆ ಎಲ್ಲ ಒಂದ್ ಕಡೆ ಅಡ್ಮಿಟ್ ಮಾಡಿರ್ತಾರೆ.
ಫೈಲ್ ತರಿಸ್ಕೊಳ್ತೀವಿ.
ಯಾವಾಗ?
ಅವರು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಲ್ಲಿ ಮೇಡಮ್, ಇದು ಫೈಲೇ ಕೊಡ್ತಾ ಇಲ್ಲ ಅವರು.
ತಗೊಳ್ಳಿ, ಯಾವತ್ತು ಬೇಕು ತಗೊಳ್ಳಿ. List on date.
200 ಇದೆ.
22nd October.
Much.
ಎಲ್ಲ ಫೈಲ್
List number 3 for orders matter. Serial number 1, Hiremalton Maheshaya.
The respondent number 2 was directed to the relief order, my lord.
My lord, he's relieved. He's relieved. I have received a WhatsApp.
ನೋಡ್ರಿ.
It's already relieved on 26th. Yesterday was.
ಬರ್ಕೊಳ್ಳಿ. The petitioner has sought for a writ in the nature of mandamus to consider his representation, mandamus by directing the respondent number 2 to consider his representation dated 18/7/24 and to relieve the petitioner and to relieve him from Challakere pursuant to the order of transfer dated 15/7/2024. The petitioner contends that he was appointed as a junior engineer at the
Chalkere.
city, at the town municipality, na?
CMC.
At the city municipality Chalkere. He was thereafter transferred to the municipality at Sira. However, Sira, in terms of the order dated 15/7/24. Nonetheless, the respondent number 2 has not relieved the petitioner to report to duty at Sira. Petitioner is therefore before this court for appropriate directions to the respondent number 2 to relieve him. Next, for the learned AGA, today submits that he has received instructions from the respondent number 2. Respondent 1. Respondent number 2. That the petitioner is relieved with effect from
Yesterday, 26th,
26th,
26/9/20.
26/9/2024. In view of the above, this writ petition does not survive for consideration.
Great.
In memo ಹಾಕಿದ್ದೀರಾ ನೀವು? Appearance ಹಾಕಿದ್ದೀರಾ?
Received it, I'll
The
file
learned
the-
AG is
file the
permitted to file a memo of appearance within 10 days from today. Yes.
List number 1. For fresh matter, serial number 12.
Lots
For hearing on IA.
preferred application
for
early hearing.
Rajaram T.
I appear for the respondent.
Now should we kindly fix some dates so that the matter is very simple. Lord, implementation of sixth pay commission. Instead of implementing the same on 1/4/2018, it was implemented from 1/10/2018. So that all 12 petitioners before the court, they lost certain financial benefits. It's only for 3 lakhs. ಅಷ್ಟೇ ಬರುತ್ತೆ. ಒಂದು 12 ಜನಕ್ಕೂ ಸೇರ್ಕೊಂಡು. Now, my lord, they're all 65, 67 years.
My lord,
This is the fifth pay or sixth pay?
Sixth pay commission.
Sixth.
ಅದರಲ್ಲಿ sixth pay commission, they are supposed to be implemented from 1st April 2018.
Yes.
The same was implemented from 1/10/2018. So that, my lord, all government organizations, my lord, they implemented their pay scale from 1/4/2018. Especially this particular respondent, my lord, they have implemented from 1/10/2018. Yeah, ಒಂದು 3 ಲಕ್ಷ ಬರುತ್ತೆ ಈಗ.
Let him,
Lord, this is a independent corporation. No doubt the government of Karnataka has got 35% share. Government of India has got 30% share and farmers have got 35% share. The very purpose of instituting a corporation that it is independent of the promoters. That's the purpose of corporation. Corporation in its wisdom, looking at the balance sheet, it decided that it will defer implementation of the pay scale, which has been done even in other cases. I'll file the citations, my lord. Even in KSRTC also, this has been endorsed by this honorable court because these are independent corporations. They are guided by the.
In the entire corporation, you applied from 1/10/2018 in respect of all employees.
All employees.
All employees.
All employees.
Please, good, sir. Of course, they have not also, all government companies, my lord, all government organizations, they implemented from 1/4/2018. But it's only this organization.
So,
Yeah.
Suppose if the corporation itself is under loss.
No, my lord, there
They
is
can-
profits. Lordship, I produce the
I
balance
can
sheet.
show the balance sheet.
No,
Very
you
clearly
can
shows that they are
produce the
under
balance
loss.
sheet, showing that they're they're
No,
making
you
the
say-
profits.
You say it is making profit. He
Yes,
says
please.
it's making.
No, I produce the balance sheet. Or produce the balance sheet. Lordship,
The same balance sheet, I will show how it is loss. In the same balance sheet, I'm not going
When
to
the
show. it
balance
here.
sheet is showing the profit.
An operational loss, my lord. They have shown a notional profit because the other income is shown as part of the income. Therefore, there is a profit. Otherwise, there is an operational loss of 9 crores. I would show that, my lord.
Like, Lordship, I mean, exhibit below.
Kindly
Exhibit,
come to page
F
74.
below 74. Where 1,84,46,400. Lord, this is the profit they have made. Lord, now it is only a financial burden of 3 lakhs, that's all.
Kindly come to.
Even if it is 30 paisa,
Please note.
even if it is 30 paisa, it should be according to law.
That's right, Lord. But in the meantime, there is no, they have totally misled this particular, at the time of passing an order.
Yes.
My lord, they have misled this particular, this general body saying that there is a loss. But my lord, I have produced the profit and loss account as well as the balance sheet pertaining to the year 2018 as well as 2019. But that is 74 and 75 pages, lords. Where in not they're making the profits.
Where is the profit?
I'm like, lordship, I can say the 74 lords,
75 one.
Page
74, 74, 75 lords.
Profit for the year 5 and 6
Please note,
is 90 lakhs,
please note,
16,265.
please note.
ಅಲ್ಲ ಇಲ್ಲಿದೆ.
Because of
Item number 5 in page 75, my lord.
Yes, before tax.
Profit before tax for the year ending March 2018, it is showing as 1.25 crores. And for the year ending March 31st, 2017, it is 1.79 crores.
Crores.
But kindly come to item number 2 above. That is just below the first item, second item, other income. Now, other income is 10 crores. And kindly look at the other income in the previous year, it is 7 crores.
So other income is 7 crores and 10 crores.
Please, notes.
Allah, 10, yes, 10 crores.
Ah.
Now, by virtue of this other income, this profit before tax is being shown. Otherwise, there is an operational loss of 9 crores of rupees.
What does it matter? Do you have any cash crunch?
It is, yes.
How do you say that? How do you establish?
ಇಲ್ಲಿ ತಾವು, the representative, the director.
Only means to say that you're not operating the company properly.
ಹೌದು, the company,
ನೀವು
company is under loss. That is the reason they deferred, implementation of the pay scale by 6 months. Now the question is whether the company was, did the company have the authority to defer?
Yes.
It certainly has, because it is a separate corporation. This honorable court also has, and no malafide has been.
Where is the order accepting the recommendations of the 6th pay revision?
Illive.
Where is the resolution of the?
They only produced it. They have produced it.
So there is an exhibit, I mean, annex E, my lord, typed copy is there at page number 73, my lords.
Detailed discussion
Page
has
number?
taken place.
Page number 73, my lords, annex E.
Author, please wait. Yes.
Before that, may I also point out, my lord, page number 74. That is also again balance sheet. Balance sheet ಅಲ್ಲಿ ತಾವು March 2018 figures ನೋಡಿದ್ರೆ, if your lordship comes down to item number 3, current liabilities, the current liabilities works out to 59 crores. Andre, what is the meaning of current liability? Current liability andre the monies that I am due to pay for the purchases made. Only when they are sold, I will be able to make the money.
Yes.
Kindly look at the current liabilities of the previous year. And sorry, kindly come down to current assets, my lord. Inventories. 39 ಕೋಟಿ ರೂಪಾಯಿನಷ್ಟು ಮೆಟೀರಿಯಲ್ ತಗೊಂಡಿದ್ದಾರೆ ರೈತರಿಂದ. Ultimately, they are dealing with seeds. They purchase material from the farmers. They are unable to pay them. And this issue was highlighted by the director representing the farmers in the board meeting. And the board meeting in its wisdom decided, yes, all right, let us defer it by 6 months. And unfortunately, in those 6 months, these people have retired. No malafide can be attributed merely because of that.
Yes.
That is what is highlighted in the board resolution, board meeting, my lord. The representative of the farmers, representative, that is DL Nagaraja, brought to the notice of the board that the financial position of the corporation is not in good condition and the payment to the farmers for supply of seeds is outstanding. This also reiterates the fact that the corporation is unable to clear the dues of the farmers despite a profit being shown in the profit and loss account. The profit shown in the profit and loss account is merely a notional profit. Operationally, they are under loss and they are saddled with the material. They are unable to pay the farmers.
Correct.
Who comes first?
Everybody are benefiting from the farmers.
Everybody is benefiting from the farmers.
Everyone is benefiting. Farmers ಗೆ minimum support price ಕೊಡೋದಕ್ಕೆ ಆಗೋದಿಲ್ಲ.
ಆಗ್ತಾ ಇಲ್ಲ. Whether they get their money or not, their salary should be increased. That is their contention. How can a corporation
Do one thing, you also take the farmers' lands, give them SDA status or FDA status. Ella farmers go give them FDA status, give them salary. You tell them to grow this, they will grow and give it to you.
That is exactly what.
First, FDA status ಕೊಟ್ಬಿಡಿ ಎಲ್ಲರಿಗೂ.
That is exactly the point. The
FDA status, FDA salary. ಅವ್ರ ಮನೇಲಿ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಅವ್ರಿಗೆ ಮಕ್ಕಳಿದ್ರೆ SDA ಕೊಡಿ. ದೊಡ್ಡವರಿಗೆ FDA ಕೊಡಿ.
I am myself a farmer's son, my lord. I know the difficulties in which we were brought up. The last priority is for the farmer. When we take it to the market, I do not know how much money I will get.
That is an unfortunate situation.
That is the
I am also son of a farmer.
So here, one has to have some 35% share is held by the farmers. And the representative of the farmer is saying, kindly pay the farmers first. After that, you think of your salary increase.
Yes,
They say, no, pay my salary first.
Across the board.
Please note.
If the date of implementation of the pay commission, pay revision is applied across the board to all employees on the ground.
Please note.
The company is facing some financial difficulties.
Please note.
What is your justification?
No justification in the sense, my lord,
When the company is making the profits, my lord, it was hidden straight away, they made the submission, the
Company is
company is
not
the losses.
making profits.
It's not making profit.
Please, notes,
The company might earn other income.
please, notes,
It might earn other income. For
Please.
example, it could have rented out its place.
please, notes,
ಬಾಡಿಗೆ ಕೊಟ್ಟಿರ್ಬೋದು.
please.
We do not know.
ಹೌದು.
But my
It
lord,
could
Exactly.
generate income from other sources. No, but you people should generate income for the company to claim the pay revision.
when all the government organizations, they implemented from 1418, Lord, it's only this company, my lord, this company, my
but-
lord, they want to implement.
No, the discretion is vested in the company.
That's
they
right,
can-
man, that's
they
what,
can-
that's right, man.
They can pick a date from when the pay
I
revision
do
can
agree,
be given
but,
effect to.
my lord,
I have
the
citations to support
the-
that also, my lord.
they visited this, on this one, my
Now
lord.
ready now ಮುಗಿಸ್ಬಿಡೋದಾ?
ಅಲ್ಲ, ಬೇಡ, ಇನ್ನೊಂದ್ ದಿನ ಕೊಟ್ಟಿಬಿಡಿ, so
Huh?
I will argue this matter some other day, because my lord, it's only for early hearing.
I have
One
always
date,
been,
one date, Lord, may kindly fix it so that I will come and argue.
I have always been ready, my lord, because
One date may be fixed, man.
ರಾಷ್ಟ್ರ ಚೇಂಜ್ ಆಗುತ್ತಾ?
Swami? No, let me see, I'll apply my mind once.
Don't, IA 124 is filed for early hearing since the petition is not admitted. IA 124 is rejected. List the petition for preliminary hearing in B group as per seniority on. Good, yeah.
need it, I need it.
28th October.
Yes.
28th October, man.
Please, please.
Serial number 13, Srinivas K.
This is pertains to, my lord, absorption into the permanent cadre of, based on the settlement, my lord, that was entered into between the KPTCL and the union. The petitioner, my lord, though my lord is one of the beneficiary of the settlement, his name, though included in the list, my lord, has not been, my lord, issued with the appointment order, in spite of repeated representation.
Appointment order, we have sent a mail, we didn't get any instructions. We have to get it, my lord.
Yavaga, when will you get instructions?
Yes, my lords. Yes.
When will you get instructions, madam?
We are trying to, maybe Monday, my lords.
Learned counsel for the response 1 and 2 seeks time to secure instructions. List on
Monday.
October 40, immediately after reopening.
15th October.
Public.
Serial number 14, Silpa Rani.
For the petition.
This is a case where the works inspector, we have secured 25% and above.
So pardon?
My lord, this is a case where all the post of works inspector came to be abolished except those candidates who have secured 25% above in the examination. They can be selected. That's the point. Last time your lordship was asking me whether an affidavit in terms
in
of
this
the order
case-
is filed or not. In fact,
Yes.
My lord, in this case, you have to file the detailed statement of the objection. And have to, another time you have filed the affidavit, my lord. Second affidavit, 22/9/2023.
The order dated 59/23 says, Director of Municipal Administration was filed an affidavit with annexure H stating the department was not inclined to appoint any of the work inspectors except those who were secured above 25%. He is directed to file another affidavit as to what is the fate of those inspectors who are secured above 25% in the light of the affidavit filed by him. So ಅವ್ರಿಗೆ ಏನ್ ಮಾಡಿದೀರಾ?
After that, have not transaction by this government or.
No, but you must have done something. You have said that you will appoint those work inspectors.
After that, have not instruction for this.
Why you are not done? This order is in 2023. 1 year has gone by.
The department observed. After that, have no transaction between the government and department.
No, but no transaction with the government and department. It's a department of the government.
Government have given the representation concerned department respondent number 2. But they have not respond the government as on today. Now the.
Who is respondent number 2?
Who is urban development.
Director Municipal Administration.
Yes, you said that you will secure instructions from that your department.
Come to this.
Urban development or are you?
Director Municipal Administration.
Municipal administration. ನಿಮ್ಗೆ ಅಡ್ವೊಕೇಟ್ ಯಾರಿದ್ದಾರೆ ಸಪ್ರೇಟ್ ಆಗಿ?
ನಮಗೆ ಅಡ್ವೊಕೇಟ್ ನಮ್ಮ DL ಇರ್ತಾರೆ
ಹಾ?
ನಮ್ಮ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ ಮೇಡಮ್ ಸರ್.
ನಿಮ್ ಸೆಕ್ಷನ್ ಅಲ್ಲ ಆಫೀಸಲ್ಲಿ ಇರೋದಲ್ಲ, ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಅಡ್ವೊಕೇಟ್ ಯಾರು?
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ
Separate.
ಗೌರ್ಮೆಂಟ್ ಇರ್ತೈತೆ.
Yes, Mr. You said on the last date that somebody else is representing. Now he says that you are representing.
ಡೀಟೇಲ್ ಕೊಡಿ ಅಂದ್ರೆ ಅಷ್ಟೇ ಹೇಳ್ತೇವೆ.
ಸರ್ ಇಲ್ಲ ನಾವು ಈಗ ವಜಾ ಮಾಡಿದೆ ಸರ್ ಅದನ್ನ ಈಗ ಲಾಸ್ಟ್
ಅದೇ as per the annexer cell, have to say annexer cell he given to the endorsement of the.
This is 2021. Annexure ill is 2021.
21.
You made a statement before this court that you will appoint 25%. Work inspectors will secure 25% and above. Again, on the affidavit ಹಾಕಕ್ಕೆ ಹೇಳಿದ್ರಲ್ಲ.
After that you have to file the affidavit of the 2023.
ಯಾವಾಗ?
2023 ಅಲ್ಲಿ affidavit ಹಾಕಿದ.
That was not accepted.
So annexer cell you have to give to the endorsement.
Please
After
wait.
that you have to file the affidavit.
Now, what is this affidavit that was filed?
Affidavit has observation of this, please see the para number 6 of the affidavit.
Affidavit was filed on what date?
22/9/2023.
ಏನಂತ ಹೇಳಿದ್ರು ಓದ್.
I respectfully state that the work inspector who had scored more than 25% were initially sought to be appointed. However, the recruitment of these persons would have become financial burden to the corporation. And such the said posts were sought to be abolished by the Public Works Department, and hence proposal for abolition of the draft Karnataka Municipal Corporation Common Recruitment of the Officers and Employee Amendment Rules 2018 was submitted to the government. I further state that the department has already required a good number of engineers, and since the service of these officers recruited is already being utilized by the municipal corporation, the department was not inclined to appoint any of the work inspector except those who have scored above 25%.
ಆಯ್ತು.
So after that, you have challenged the writ petition, my lord. The writ petition, this court have to, writ petition is dismissed. After that, they have to, the petitioner is appeal for the appeal court. The appeal court observation of the writ petition and have to dismiss the writ appeal. They can have to remaining, they challenge the writ
What was
petition.
the order passed in writ appeal? ಎಲ್ಲಿದೆ writ petition order?
Writ petition order annexer writ petition number 3077 of 2019.
ಎಲ್ಲಿದೆ ಅದು?
Annexer ಸಲ್ಲೇ ಹಾಕಿದ್ದಾರೆ.
Page number 29.
Page number
29.
20.
29. Annexure G, madam.
29.
What is the order?
Order the observation of the all relevant point and have to find out the dismiss the writ petition. After that, challenge the writ appeal. Writ appeal also have to dismiss.
But what was challenged in the writ petition?
Well,
The order
those who
date-
have secured less than 25%, they want to operate the list. This court, my lord, based on the cabinet decision, said that you don't have vested right, therefore the petitions are dismissed.
So
We were
this-
respondents
This
in
writ
that,
petition was filed by those candidates who secured less than
less than
25.
25%.
Ah,
Then if your lordships kindly take page 76 in page, the cabinet decision has been extracted by this court.
ah.
In page 76, 48 internal
ಆಯ್ತು.
page.
ಮೇಲೆ ವಿವರಿಸಿರುವ
ಮೇಲೆ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಲೋಕಸೇವಾ ಆಯೋಗವು 87 ಕಾಮಗಾರಿ ನಿರೀಕ್ಷರ ಹುದ್ದೆಗಳು ಸಲ್ಲಿಸಿರುವ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ 25% ಮೇಲ್ಪಟ್ಟು ಅಂಕ ಪಡೆದಿರುವ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಮಾತ್ರ ನೇಮಕಾತಿಗೆ ಪರಿಗಣಿಸಲು ಸರ್ಕಾರದ ಅನುಮೋದನೆ ನೀಡಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಲು ನಾನು ನಿರ್ದೇಶನ ಆಗಿರ್ತೇನೆ.
Yes.
Then my lord, these petitioners have secured less than petition or this. We were respondent here. My lord, the very same affidavit was gone through by this court on 15/9/2023, my lord. If your lordship
Yes, yes, I remember.
yes, and this court directed what should happen to the fate of those who have secured 25%? Not only 6 candidates are there, 2 people have been already got some other appointment.
3P, what has happened to this the abolition? Is there any executive order passed by the state government?
So annexers really have to the observation of this all abolition of the. Please read this.
Both.
ಎಲ್ಲಿ ರಾಜ್ಯದ ಮಹಾನಗರ ಪಾಲಿಕೆಗಳಲ್ಲಿನ ಕಾಮಗಾರಿ ನಿರೀಕ್ಷಕರ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಕುರಿತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಬೆಂಗಳೂರು ಪೀಠದಲ್ಲಿ ರಿಟ್ ಅರ್ಜಿ ಸೋ ದಾಖಲಾಗಿದ್ದು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 19/8/21 ಪ್ರಕರಣವನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿ ಸರ್ಕಾರದ ತೀರ್ಮಾನವನ್ನು ಸರಿಯೆಂದು ಸರ್ಕಾರದ ಆದೇಶದ ವಿರುದ್ಧ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹೋದ ಅಭ್ಯರ್ಥಿಗಳ ವಾದವನ್ನು ತಿರಸ್ಕರಿಸಿ ನಗರಾಭಿವೃದ್ಧಿ ಇಲಾಖೆಯು ದಿನಾಂಕ 6/2/2019 ನೀಡಿದ ನಿರ್ದೇಶನದ ಪ್ರತಿಯನ್ನು ಆದೇಶದ ಪುಟ ಸಂಖ್ಯೆ 47-48ರಲ್ಲಿ ತಿಳಿಸುತ್ತಾ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಪೂರ್ಣಗೊಳಿಸಬೇಕೆಂದು ಸೂಚನೆ ನೀಡಿದ್ದು ಪೌರಾಡಳಿತ ನಿರ್ದೇಶನಾಲಯವು ತೆಗೆದುಕೊಂಡ ತೀರ್ಮಾನದಂತೆ ಹಾಗೂ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದ ಅಫಿಡೇಟ್ನಂತೆ ಹಾಗೂ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ಆದೇಶದಲ್ಲಿ ನೀಡಿದ ಸೂಚನೆಯಂತೆ ವಯೋಮಿತಿಯನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಕುಟುಂಬ ನಿರ್ವಹಣೆ ಹಾಗೂ ಸೇವಾವಧಿಯನ್ನು ಗಮನಿಸಿ ಆದಷ್ಟು ಶೀಘ್ರಗತಿಯಲ್ಲಿ ನೇಮಕಾತಿ ಆದೇಶ ನೀಡಿ ಸೇವೆ ಮಾಡಲು ಅನುವು ಮಾಡಿಕೊಡಬೇಕೆಂದು ಉಲ್ಲೇಖ 1ರ ಮನವಿಯಲ್ಲಿ ಕೋರಲಾಗಿದೆ. ಈ ಸಂಬಂಧ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಹಾಗೂ ಸದರಿ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಕರ್ನಾಟಕ ಲೋಕಸೇವಾ ಆಯೋಗದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋ ಅನ್ವಯ 87 ಕಾಮಗಾರಿ ನಿರೀಕ್ಷಕರು ಅಭ್ಯರ್ಥಿಗಳ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿ ಪ್ರಕಟಿಸಲಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 4ರ ಸರ್ಕಾರದ ಆದೇಶದನ್ವಯ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ 25%ಕ್ಕಿಂತ ಮೇಲ್ಪಟ್ಟು ಅಂಕ ಪಡೆದಿರುವ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಮಾತ್ರ ನೇಮಕಾತಿಗಾಗಿ ಪರಿಗಣಿಸಲು ಸರ್ಕಾರದ ಅನುಮೋದನೆ ನೀಡಲಾಗಿದ್ದರಿಂದ ಕಾಮಗಾರಿ ನಿರೀಕ್ಷಕರ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿ ಕ್ರಮ ಸಂಖ್ಯೆ 1ರಿಂದ 6ರವರೆಗಿನ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಮಾತ್ರ ದಾಖಲಾತಿ ಪರಿಶೀಲನೆಗೆ ಪರಿಗಣಿಸಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಉಳಿದ ಅಭ್ಯರ್ಥಿಗಳು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಹೂಡಿರುತ್ತಾರೆ. ಸದರಿ ಪ್ರಕರಣದ ಸಂಬಂಧ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಕಾಮಗಾರಿ ನಿರೀಕ್ಷಕರು ಮಹಾನಗರ ಪಾಲಿಕೆಗಳಲ್ಲಿನ ಕಿರಿಯ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಸಹಾಯಕರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಯಾವುದೇ ರೀತಿಯ ಸ್ವತಂತ್ರ ಕರ್ತವ್ಯ ನಿರ್ವಹಣೆಯ ಜವಾಬ್ದಾರಿ ಇರುವುದಿಲ್ಲ. ಮಹಾನಗರ ಪಾಲಿಕೆಗಳಿಗೆ ಈಗಾಗಲೇ 125 ಕಿರಿಯ ಅಭಿಯಂತರರು ಸಿ, 133 ಸಹಾಯಕ ಇಂಜಿನಿಯರ್ ಸಿ, 45 ಸಹಾಯಕ ಇಂಜಿನಿಯರ್ ವಿ, 30 ಕಿರಿಯ ಅಭಿಯಂತರರು ವೀರವುಗಳ ನೇಮಕವಾಗಿರುತ್ತದೆ. ಕಾಮಗಾರಿ ನಿರೀಕ್ಷಕರ ಹುದ್ದೆಗಳನ್ನು ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯಲ್ಲಿ ರದ್ದುಪಡಿಸಲಾಗಿದೆ. ಪ್ರಸ್ತುತದಲ್ಲಿ ಕಾಮಗಾರಿ ನಿರೀಕ್ಷಕರ ಹುದ್ದೆಗಳು ಅಸ್ತಿತ್ವದಿಲ್ಲದಿರುವುದರಿಂದ ಮಹಾನಗರ ಪಾಲಿಕೆಗಳಿಗೂ ಸಹ ಕಾಮಗಾರಿ ನಿರೀಕ್ಷಕರ ಹುದ್ದೆ ಅವಶ್ಯಕತೆ ಇಲ್ಲವೆಂದು ತಿಳಿಸಿ ಹುದ್ದೆಯನ್ನು ರದ್ದುಪಡಿಸುವುದಾಗಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ನಿವೇದಿಸಲಾಗಿರುತ್ತದೆ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಡ್ಯಾಶ್ ವಿಚಾರಣೆಯನ್ನು ದಿನಾಂಕ 1/12/21 ನಡೆಸಿದ್ದು ದಿನವೇ ಆದೇಶದಲ್ಲಿ ನೀಡಿರುವ ಆದೇಶದ ಮುಂದಿನ ವಿಚಾರಣೆ ದಿನಾಂಕ ಕಾಮಗಾರಿ ಹುದ್ದೆಯ ರದ್ದತಿ ಕುರಿತಾದ ಸರ್ಕಾರದ ಆದೇಶವನ್ನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಾಜರುಪಡೆಯಲು ನಿರ್ದೇಶಿಸಿದ್ದು ಬಾಧ್ಯತಾ ಭಾಗವಾಗಿರುತ್ತದೆ. This court deems to fit grant some time to the state government to take decision in this regard to abolish the cadre of work inspector under various municipalities and municipal corporation in the state. Since the petitioner have take part in the recruitment process which commenced on 6/4/2016 and a final select list also having been issued, it would be incumbent upon the state government to take a decision in this regard as expeditiously as possible. Any action taken in this regard shall be reported on the next date of hearing ಎಂಬುದಾಗಿದೆ. After that you have to file the affidavit, my lord.
Correct. This is in respect of work inspectors who are secured less than 25.
Less than 25.
Less than 25 ಇದಾಗಿದೆ. Above 25 ಏನಾಗ್ತದೆ?
ಅದು cadre of recruitment of the rule. As the rule 5, we have to observe and selection list of the.
Correct. You made this order saying that in respect of people, work inspectors who is less than 25 will not absorb.
Yes, my lord.
Above 25 will consider.
Yes, my lord.
Correct.
The rule is follow.
What rule?
Rule is 5.
Absorption rules.
Observed rules.
If that is the case, what have you done to these people who are secured more than 25? ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರ ಅಂತ this court has asked you. You have filed an affidavit on
22nd 2020, my lord.
22nd September 2023.
That is.
ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದಿರಿ? Please go to the affidavit.
ಇದ್ರ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿಲ್ಲ. ಅದಕ್ಕೆ court said, what have you done with people who have secured 25%?
However,
up to date.
ನೋಡಿ ಪ್ಯಾರಾ 6 ಓದಿ.
Para 6,
ಹಾ.
next 7.
ಪ್ಯಾರಾ 6 ಓದಿ ಇನ್ನೊಂದ್ಸತಿ.
I respectfully state that the work inspector who had scored more than 25% were initially sought to be appointed. However, the recruitment of these persons would have become financial burden to the corporation and such. The said posts were sought to be abolished by the Public Works Department. Hence, proposal for abolition of the draft Karnataka Municipal Corporation Common Recruitment of Officer and Employee Amendment Rules 2018 was submitted to the government. I further state that the department has already recruited.
2018 rules ಇದೆಯಲ್ಲ,
Yes,
whether
madam.
this has been accepted with the government.
So after that, yeah, one rules is 4/11/2021 is the pass.
ಯಾವುದು?
Next corrigendum, the 4.
Last line of the same affidavit. Except those who have secured about 25%. Even in.
Next, para number 9, my lord, this is affidavit. Para number 9. I respectfully state that the said order passed in WP number 3077/2019 and other connected matters were subject matter in WA number 1162/2021. The division bench of this honorable court by its order dated 12/10/2022 was pleased
This is in
to
respect
dismiss
of
the
below
above writ appeal.
25. Below
Yeah.
25, what you say is right.
Yes, ma'am.
Above 25 ಏನ್ ಮಾಡ್ತೀರಿ?
Alla,
Below
ಅವರು
25
have
what?
not a worker of the corporation.
ಯಾರು?
Below 25.
Below 25 ಬಗ್ಗೆ ಕೇಸೇ ಇಲ್ಲ. You are only concerned about people who are secured above 25%. ಅವ್ರದ್ದು ಏನ್ ಮಾಡ್ತೀರಾ ಅಂತ ಕೇಳ್ರು. And look at this affidavit. It's so carelessly drafted.
Yes, my lord. We'll take the instruction and file the affidavit next year.
So then we'll issue a bailable warrant to the director for not filing an appropriate affidavit. ಬರ್ಕೊಳ್ಳಿ.
You take instruction and you have to.
We'll issue a bailable warrant. This is going on. ಬರ್ಕೊಳ್ಳಿ. Despite the order dated 59/2023.
One chance you have taken after.
Directing the Director
Monday.
of Municipal Administration.
Monday.
No. Director of
Monday
Municipal
you have to file the
Administration
affidavit, my lord.
to file an affidavit as to the status of those work inspectors who have secured 25% and above marks. ಈ marks ಏನಿದೆ?
Marks.
The affidavit filed on 22/9/2024 is absolutely misleading and does not make a categorical statement as to what steps are taken in respect of such persons. Full stop. In that view of the matter, issue bailable warrant to the Director of Municipal Administration
Alan,
to make a categorical statement.
No, my lord.
Sorry,
This
to make a
before
categorical
earlier,
statement.
No, my lord, writ petition is dismissed, writ appeal is dismissed. After that, you have filed to the 2023, you have to file the
Mr.
affidavit.
KGA, that was in respect of those people who had secured less.
Yes, my lord.
Less. These people are secured more. You made a statement that we'll consider appointing them.
About
Now you say that you want to abolish. If you want to abolish, you do it, but there should be an order abolishing those posts.
Yes,
Whether those posts are abolished by an executive order. If it is not done, you are entitled to take steps. Simple. ಏನಾಯ್ತು? To file an affidavit answering the order of this court dated 15/9/2023 in specific terms. List on bailable warrant for a sum of rupees 50,000, huh?
ಮಂಗಳವಾರ.
ಮಂಗಳವಾರ. First October. ಹಿಂಗೆ ಕೇಸ್ಗಳು ನೀವು ಉಳ್ಕೊಳ್ಳೋದು. You could have easily solved it. You could have come and said, okay, we want to abolish it. Produce some documents to say that you are abolished.
Our state of the work inspector, he have observed the department, after he have not worked the any municipality under. So if it is the how to, the government have not take the instruction of the CEO, ಅಲ್ಲಿಗೆ ಅವರು ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ಮೇಲೆ ಸ್ಟಾಪ್ ಮಾಡ್ಕೊಂಡು.
ಕರೆಕ್ಟ್. ನೀವು ಏನ್ ಬೇಕೋ ಮಾಡಿ. ಮಾಡಿದ್ರೆ ಸುಮ್ನೆ ಮಲಗಿದ್ಬಿಟ್ಟು ನೀವು ಯು ಕ್ಯಾನಾಟ್ ಕಮ್ ಅಂಡ್ ಸೇ government adu idu anta. You are supposed to ensure a logical end to this issue. ಇದಕ್ಕೆ ಏನೋ ಒಂದು ಇದೇಳ್ಬೇಕಲ್ವಾ, ತೀರ್ಮಾನ ಆಗ್ಬೇಕಲ್ವಾ, ವೆದರ್ ದೇ ಶುಡ್ ಪರ್ಸ್ಯೂ, ವೆದರ್ ದೇ ಶುಡ್ ವೆಯ್ಟ್, ಬೇರೆ ಕಡೆ ಅಪ್ಲೈ ಮಾಡ್ಬೇಕೋ ಬೇಡವಾ. They also should know their status. You are a model employer, so therefore you also bound to take decisions here quickly.
Yes, ma'am.
Yes.
2017 in the.
Serial number 50.
All our original marks cards are with them.
Then ಅದಕ್ಕೆ ಕೇಳಿದ್ದು.
ಇಲ್ಲಿ 3 ಜನ ಇದ್ದಾರೆ, 2 ಧಾರವಾಡ bench. The entire melody is only 5 people. And the Director of Municipal Administration, page 95, files an affidavit before this court, except the people who have secured 25, the cabinet decision of abolition would apply. Therefore, my lord.
So therefore, what steps next?
Yes. If there is again a cabinet
Taken any
decision,
steps, my lord? After that.
and in terms of section 3 of the Karnataka Civil Services Act, if a rule, my lord, post can be created by means of executive order rule. Now they are held by the rules. Now they must make a rule and abolish the post. That can't be done because of the order passed by this court.
Next.
Serial number 15, Satish K.
15.
My lords, I appear for the petitioners in 15.1.
Huh?
I appear for the petitioners in 15.1.
We are at serial number 15. Not 16. We are 15.
15.1.
Reddy.
15.1, my lordship.
Ah.
It's in 15.1, that in 15.1, but on last 2 occasions, not the state government.
My lord, we are asking for some time, my lord, in this case to file the state, because the challenge is on a welfare act. The Daily Wages Welfare Act, my lord, the provisions of Welfare Act is challenged.
My lords, in fact, they have filed their statement of objections on 20th February.
What is the issue in 15.1?
My lords, we have questioned certain provisions of this Karnataka Daily Wage Employees Welfare Act, my lords. The respondents have already filed objections on 20th February 2020.
Is it regarding the date of?
That's the validity.
One request of this, you have to mention the order sheet of the concerned department manager is present before this student.
Dear madam, serial number 14 ali, what's his name? Mr. Vijay Kumar. What is your designation? Assistant Director is present on February. Assistant Director, Department of Municipal Administration is present. Yes.
Therefore, my lord, we are paying for some time after vacation.
Around the AGS seeks time, list after vacation. Date could have.
Date mechanism.
After 22nd, my lord, any date.
23rd October.
Much obliged.
Serial number 16, Chandrakant R. Gowle.
There's a, my lords, there's a bereavement in senior's family, my lords. Kindly have this on Monday, my lords.
The land council for the response 2 to 6 weeks time. On the ground that there's a bereavement in the family of the council. List on
Monday, my lords.
Obliged.
This Mr. B.M. Arun has been taking time repeatedly.
Yes, my lord. Today is 11th day ceremony, my lords.
No, but it was posted today at his request.
Yes, ma'am, but today is the 11th day. Some rituals are going on, my lords. Monday, my lords.
List on Monday.
Serial number
17, my lords, I pray for weeks time. Need to file rejoinder in the matter, my lord.
Lordship,
Directed me to furnish a document to show that when the petitioner has submitted the representation along with the marks cards, that will furnish, my lord, and
Advocate
so
for petition director.
Lordship, I have,
Create on which intimate a response for the acquisition of additional qualification.
original document ತಂದಿದ್ದು.
Everything is there.
I need, they even not file the objections in the matter.
ಆಯ್ತು ಏನು ಅಂತ ಹೇಳ್ಬಿಡಿ.
We'll file it, my lord, otherwise, my lord, there will be a problem. I will file the material to show that when we have
No, she
furnished.
has got the original file itself. When you have
To
produced
verify,
it.
my lord, that's the reason.
Yes, madam.
1810, we requested the petitioner to submit the marks cards, and on 28/10/2022, petitioner said that she has not received the marks card, and then we wrote to the university and got the marks card.
When did you get it?
Lordship, sometime in the year 2023.
Sometime ಅಂದ್ರೆ ಯಾವಾಗ?
ಒಂದೇ ನಿಮಿಷ sir.
ಯಾವ್ದು? ಯಾವಾಗ ಬಂದಿತ್ತು madam? ಹೌದು. ಯೂನಿವರ್ಸಿಟಿ.
ಇವಾಗಿದ್ದು. 14 February 2023.
14th February.
ಹೌದು.
ಹಾ.
23.
Yes.
I'll file my rejoinder.
Yeah, but
Only
that-
on
ಅಷ್ಟೇ
the
that
basis
is-
of the tippani, my lord, they are, my lord, that not even filed objections to the petition.
Have been
Adu
filed.
tippani, they prepared by the
Objection-
officials.
ಇಲ್ಲ ಒಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದು ಸ್ವಾಮಿ ತಾವು ನನ್ನ ಹತ್ರ ಈ ಇದ್ರದ್ದು
Objection file ಆಗಿದೆಯಲ್ಲ.
ಫೈಲ್ ಆಗಿದೆ ಇದ್ರದ್ದು ಪ್ರಮೋಷನ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಎರಡು ಪೋಸ್ಟ್ ಇದ್ದು ಕೇಳಿದ್ದಕ್ಕೆ ನಾನು ಟಿಪ್ಪಣಿ ಮಾಡಿ ಕ್ವಶನ್ ಕೇಳಿದ್ದಕ್ಕೆ ಉತ್ತರ ಬರ್ಕೊಂಡು ತಂದು ಸಬ್ಮಿಟ್
I'll
ಮಾಡಿ.
place the material to show that, my lord, necessary.
Password.
Password is not possible.
ಸ್ವಾಮಿ ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ.
Urgent ಇದೆ.
Well, urgency there, but the question is, my lord, very legal question is involved. my
ಏನ್
lord.
legal question?
Hello, there was no
Vacate
provision for,
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ವೆಕೇಟ್ ಮಾಡ್ಬಿಟ್ಟು ಎಷ್ಟು ಟೈಮ್ ಬೇಕಾದ್ರೂ ಕೊಡಿ ಸ್ವಾಮಿ.
Password, ನೋಡಿ.
Allah, kindly have it on Monday, my lord. Otherwise, I'll file the rejoinder.
Convince sir.
Allah, I'll file it on Monday.
ಆಮೇಲೆ ನಮ್ ಜೀವ ತಿಂತಾರೆ ಸ್ವಾಮಿ.
ಅವ್ರು ನಮ್ ಜೀವ ತಿಂತಾರೆ. Monday.
Please, my lord.
Monday.
Grateful. Interim order.
Interim order to the next state.
Serial number 18, Srikanth MP.
Yesterday's matter, words, where I sought for transfer, they sought for implementation
You sought for
But,
transfer?
of the memorials of the petitioner from one place to another, saying that project, memorials, is in the finishing stage and is to be
Ah.
completed. They said, my lord, it is done, and your lordship's, memorials, wanted to know,
Is
my
the
lords,
petition
about
tomorrow to ascertain whether the petition addressed the emails dated 19/1/24 and 8/4/24, which are attached as annexures R1 and R2 to the statement of objection? Yes.
lords may have, my lords, annexure R1, my lords, page number 5. Filed, my lords, along with their objections.
Annexure R5.
My lords, page number 5, annexure R1, my lords.
R1
Ah.
in my objection to IM.
Objection to I.
I made a statement, my lord, there are several documents, and that's why, my lords, I requested time. Lords may kindly, along with that, my lords, take, my lords, volume number 2, page numbers 375, my lords.
This volume number 2 of the writ petition.
Yes, my lords.
Ah. 375.
My lords. My lord, the same communication
Ah.
dated 19/1/2024. My lords, about, my lords, the subject, my lords, career growth and professional life on attack, my lords, I have, my lords, address this document, my lords, produce the document also. My lord, the respondents, my lords, are very selective, my lords, in reading. My lords, what they read to your lordships was, my lords, the paragraph, my lords, paragraph number 13, to say
Paragraph number
13, my lords, 13 of the document, my lords, at page number 6.
page number 6.
ಅವರ IN-ಅಲ್ಲಿ ಇದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ, ನನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ, if lords kindly come to that is page number 376 in the writ petition papers. What they claim, lords, by reading this is that the project is completed,
Yes.
but they do not read, lords, further. What I say is, lords, para 14 also. Collectively, lords, they cannot be selective, lords, they have to be collective. Para 14. Decision making by the management in lords, various aspects for commercialization deployment is pending with the present management. The future works planned in continuation of so-and-so is shown as attachment. I have been deliberately isolated from so-and-so as well as so-and-so. Lords, I'll skip 2 paragraphs, go to 17. As discussed during July 2023 amongst us, so-and-so with reference to attachment so-and-so, I requested to kindly reassign MPL testing activities in addition to other existing portfolios without any further delay in order to support deployment of so-and-so without depriving me of my professional life and career growth. We have to deploy. Lords, one submission. Let me read, Lords. Let me read. Let me
clarify, my lord.
No, let me read. Lords, I'll clarify what it is. How selective they are, Lords, I'll clarify.
See, the project is over. It's
No,
only commercial.
That's what I'm
No,
going to produce, my lord. Please.
ಅಲ್ಲ ನಾ ಒಂದ್ ನಿಮಿಷ ಅವಕಾಶ ಕೊಟ್ಟು ನಾ ಹೇಳ್ಬಿಡ್ತೇನೆ. Your Lords may kindly have my application first. My Lords, I have what it is, my Lords, I have clarified. What I want from them, my Lords, I have told them.
Yes.
Your Lords may kindly come to, my Lords, the page number 11, my Lords, in my application. My Lords, may have, my Lords, paragraph number 4, my Lords, in the document, page number 11. As the endorsed project chief investigator, I emphasize that the completion of technical activities does not constitute closure of the project. The closure report incorporating completion of the pending work shall be prepared after final closure review meeting of the PRSG and its recommendations. The final closure report shall be submitted to PRSG. Only upon acceptance of closure report by PRSG along with the recommendation can the project be treated as closed. My Lords, I also say, my Lords, your Lords, kindly see, my Lords, next page, page number 12. I say, my Lords, the third paragraph. Your below email state that I am transferred to so-and-so with immediate effect and that you are asking me to hand over the documents pertaining to sponsor project and the relevant documents files to so-and-so with immediate effect in order to relieve me so that my rightful benefits are being unjustly diverted to others, impacting my career progression through unwarranted harassment. It seems evident that there is a move also to aim silence my advocacy for inclusion of so-and-so in the standards. However, the said transfer at scene 181 mentions that the transfer on completion of the task in hand and handing over of relevant accords shall be relieved. My Lords, your Lords may kindly come to, my Lords, the next document, my Lords. Page starts at 15. At my Lords, page number, in that, my Lords, internal page 3, page number 13. What I say, my Lords, again. I emphasize that the completion of technical activities does not constitute closure of the project. The closure report incorporating completion of the pending work shall be prepared after final closure review meeting of PRSG and its recommendation, and such final closure report shall be submitted to PRSG. On acceptance of closure report by PRSG along with its recommendations only can the project be treated as closed. My Lords, again reiterate. My Lords, the issue is this. My Lords, I am the chief investigator, my Lords, appointed as the chief investigator by the Ministry of IT. My Lords, along with the Power Ministry, my Lord, under which, my Lord, the CPRI comes. My Lord, the project is in so far as testing of meters. My Lord, the software being developed by us, my Lord, is now, my Lord, imported from the European Union, which costs us, my Lord, several euros. In order to, my Lord, as under the Make in India program, my Lord, the project was initiated. I am appointed as the chief investigator. My Lord, another person, my Lord, from CDAC, my Lord, is appointed as the co-investigator. 3 more persons are committed, my Lord, are included in the PRSG, my Lord, which is called as Project Review, my Lord, Steering Group. The committee, my Lord, holds regular meeting. My case was that.
Are you a member of PRSG?
Yes, my Lord. My lords, I am the member of, being a chief investigator. My lords, I am the member of the committee. My lords, it is my technical inputs, my lord, which will decide. And along with me, my lords, from CDAC, my lords, Trivandrum, there is, my lords, co-investigator, who will be, my lords, working along with me. Apart from us, there is one ISC, my lord, Indian Institute of Science professor, CDAC representative, who is, my lords, from Hyderabad. And my lords, one Jamia Millia Islamia University member. My lord, these people, my lords, are there in the committee, my lords, for this purpose. We had a meeting, my lords, on 16th of August 2024. My lords, this issue was raised there. My lords, what is happening is, we came to a stage, my lords, where we completed, we had to implement it. At that time, my lord, the superior wants, my lord, shelve the product, branding it as, my lord, there is copyright violation and other things. The issue was discussed and said there is no violation in the project.
Now the respondents also accept that the project is complete. In this
No,
sense,
that is
only commercial
not
deployment.
commercial, not commercial. That's what I'm trying to say.
That is the
Lords,
latest position, my lord, I want.
ಆಯ್ತು ತಡೀರಿ ಇಲ್ಲ ಹೋಗ್ಬೇಕ ನೀವು
ಇಲ್ಲ.
ಮತ್ತೆ ಇದು ಕೂತ್ಕೊಳ್ಳಿ ವೇಟ್ ಫಾರ್ ಯುವರ್ ಟರ್ನ್.
Please, ಇದು commercialization ಅಲ್ಲ. ಇದು my lord, the CPRI is, my lord, which is under government of India. My lord, we have, my lord, the facility to test the meters. For testing, my lord, the electric meters, my lords, we have my lord, softwares.
Yes.
So that is whatever, my lords, we have done is required to be, my lords, implemented. Now we are at a stage where we say, my lords, the technical work.
Okay, but is this PRSG disbanded? It is not disbanded.
No.
Correct?
Yes, my lord.
It is not disbanded. If it is not disbanded, the entire work of whatever this software, if it is done and only commercial deployment is the one which is pending,
Please.
then for all practical purposes, testing, everything must be over.
No,
Huh?
that is what I am trying to say. My lords, ಇವಾಗ
Testing ಆಗಿಲ್ವಾ? Testing ಆಗದೆ
what is happening is, your lordships, my lords, would appreciate for every software. There'll be, my lords, if there is version 1, 1.1, 1.2, 1.3 ಅಂತ ಬರ್ತಾ ಇರುತ್ತೆ. That is, my lords, it will be ongoing. My lords, considering, my lord, the input we receive from various sources, my lords, we try to improve it. My lord, your lordships, my lords, asked me a question about, my lord, the PRSG, my lords. This is the, my lords, communication relating to the meeting. My lords, sir.
Lord, is good.
Your lordships may kindly have a look at, my lords. Dated, my lords, 18/7/2022. This notice, my lords, scheduling the meeting on 16/8/2024. My lords, item seen the agenda itself. My lords, for two, agenda B about the project terms of reference of PRSG, presentation by chief investigator. My lords, I am the chief investigator. I have to present. My lords, on all the issues, and your lordships can kindly see, my lords, where it, to whom it is addressed to. My lords, serial number 6 is myself. My lord, it is like this, my lords. I do every work till, my lords, development and completion. For implementation, when it comes, my lord, someone else is appointed. If it is implemented, he takes the credit. And, my lords, it is not the PRSG, my lords. The person, my lords, because, my lord, there are several issues relating to copyright, my lords, and other issues are, my lords, there involved with the project. Not necessarily, my lords.
Question of you or they taking credit.
My
You're
lords,
only
chief
an employee in
investigator,
a
I have, my lords, I have.
Then you do your part, you get out. Somebody else will come and finish it.
It is not so, my lords. Your lords may appreciate.
We
My
give
lords,
interim order, some other judge will come and dispose it off.
No.
The other judge say that we'll take-
What I am trying to say is, until we close it, it's not that, my lords, we have to have a meeting. Allow me to close it. You don't, you are not allowing it, that to be done.
Yes, put it.
Document, my lord. On 13,
After, my lords, closure, my lords, definitely I'll move on.
13/8/2024, my lord, she has sent a message, my lord.
No, I think it was 16th of August 2024.
That I will come, my lord. Here, my lord, she has sent a message, my lord, saying that is a sir, that is in the middle, my lord. 6th PRSG meeting, the project completion report is prepared and submitted today. Hope you would like to
see the completion report, please let me know so that I shall share a copy of your reference. Then, my lord, then again, the other particulars, my lord, later, my lord, in page 6, may kindly see. Last page.
Last page.
Last page.
Ah.
First, my lord, the HOD has sent a message. Reference is made to your email dated May 16,
May 26.
2024, and the meeting convened on 16/8/24 for the formal closure of acceptance of the project by PRSG. So on that day, my lord, they have taken since sufficient time has elapsed after the said meeting, no valid reason is found
For
to
the formal closure acceptance of the project by
project by PRSG.
Ah.
So that project report, completion report has been submitted, and that is the only, my lord, formal acceptance.
My lords, it is like we have to get the minutes of the meeting. Then only, my lords, we can do anything.
I think why don't you extend that till this meeting is
closure is there, my lord. That's all I am
we'll
requesting.
fix a date for the closure
They'll also be bound by it, my lords, for
within 15 days or a month. Let the PSRG or PRGSG.
PSR.
Now the problem is, my lord, she has been transferred to the next building of the same compound.
Yeah,
Next building of the same.
that is
compound.
okay.
Please.
See, if she is part of this PSRG or PRSG,
Yeah. There is any concern. For the meeting.
The minutes of the meeting will be given that other persons who is in command of by T. Minutes of the meeting will be prepared by them.
within 1 month, let them do the closure.
31 months passed.
We will come back, my lord, because
Within a
he
month.
says by this time it would have been over, but I will ascertain and report.
Right? That is
Otherwise,
the-
we will.
That is the whole purpose. If she is a part of the team which has developed some software, and if that project has to be complete, and if she has to be there, you can't move her out is what is the,
Is completed actually. Or
He-
proposal is over.
This one says.
Only the minutes of the meeting they have to give. So she's a part of it. So she's not the convener. Convener is somebody else. Normally within 48 hours and government minutes are given. It is 1 month passed. They are not given. Maybe 1 week or 15 days.
and you look at these members of this committee,
Please.
it is only the petitioner, another scientist from CDAC who are active members. The others are special invitees and the chairman of NIT. So they perhaps will not have anything to do with regarding the closure.
No, Jiju is also a
He is a co-chief investigator.
Uh,
So without this lady's presence, how can you shift her to some other place and leave this particular project in disarray?
instructed, my lord, that part is over. Only they will have to give the ultimate this one.
You give a closure to that.
That is from Chennai,
Give a closure to that.
Ministry of Information and Technology. They will have to
Give a
get,
closure to that.
please,
ಯಾವಾಗ ಹೇಳ್ತೀರಾ?
15 days immediately after.
After hearing the learned counsel for the petitioner and the learned counsel for the respondents, this court has noticed that the petitioner was a chief investigator in a project undertaken by the respondent number.
Lords, one.
One.
It is not one exactly, my lords. It is under Ministry of IT. With
the-
association.
Undertaken by the Ministry of Electronics and Information Technology.
Please.
For the purpose of devising a testing tool for smart energy meters by CPRI. Full stop. The petitioner and another co-chief investigator along with special invitees and the chairman from NIT Trichur are the members of the, what is this?
PRSG, my lords,
Members
project
of
review.
Project Review Steering Group. Full stop. The emails dated 19/1/24 and 8/4/24 referred in the order dated 26/9/2024, apparently addressed by the petitioner, indicates the project is complete in all respects, but is still not closed. And for the said purpose, a meeting was scheduled on 16/8/2024. Full stop. The documents produced by the respondents now disclose that the petitioner disclosed that even after grant of sufficient time for formal closure of the project by the PRSG, the same is not done till date. Therefore, to move out the petitioner from the project and shift her to another, and to move the petitioner out of the project would leave the project in total disarray. Therefore, the respondents are directed to secure instructions whether a timeline could be fixed for the PRSG to formally close the acceptance of the project. The respondents may thereafter consider moving the petitioner out of this project to some other location. In order to enable the respondents to secure instructions in the above, regarding the above, list on date.
Second week of.
Take whichever date you want. If you delay it, you will be delaying it. So long as long as you delay it, it will be beneficial to her. If you want to take instructions,
is
come
that-
back on Monday if you want.
No, we have this unit has no control because they are not party also, but we will try, my lord.
Now you represent the central government.
Please.
You please
No,
interact with everybody and find out whether you can fix a date, timeline within which it can be done.
Or already it has been done, or I will ascertain.
Your lordship,
On Monday.
in my lords, I'm told, my lords, nothing has happened.
Let him
Like
write.
immediately
He
after
says
vacation, your lords may have it, my lords, let them come, my lords, with it, and my lords, may have it on 14th or 15th, lords, immediately after vacation.
Tuesday, my lord. I will come back.
Tuesday, Tuesday, yes.
First October.
Tell them, lords, let them not frustrate the.
ಎಲ್ಲ ಇದು
We
ಬರ್ತಿದ್ದೀನಿ ನಾನು.
have not taken any.
For fresh matter, serial number 19, Govind Raj K. Here for the petition.
Lord, petitioner is a society running a high school. Lord, on 30/6/2014 and 30/4/2015. Lord, 2 teachers retired and 2 posts became vacant. My lord, the petitioner approached the authorities, my lord, for getting permission to fill up the posts. My lord, which was not considered. And petitioner approached this honorable court and an order came to be passed as per annexure M.
Take out notice, because AG is directed to accept notice for the respondents. He is directed to secure instructions as to why the request of the petitioner for permission to fill up the 2 vacant.
No,
posts.
my lord, now 1 post is filled up after the High Court order.
To secure instructions as to why permission is not granted to the petitioner to fill up a vacant
1
post.
post, yes.
Of what subject?
English teacher.
1 vacant post of English teacher. This list on ಯಾವ ತರ ತಗೊಳ್ಳಿ
16th, madam.
ಶೇಖರ್ ಬಡಿಗೇರ್.
Serial number 20, Shekhar Badger.
My lord, I'm challenging the appointment of respondent number 6 to the position of a PE teacher in the respondent number 1 institution, my lord. The relevant annexure is at annexure A, page number 10.
Yes.
My lord, now if the relevant paragraph is read in page number 10, my lord, it basically says that she has scored the highest and on the basis of the directions by the Honorable High Court of Karnataka, my lord.
What is it? Please read.
Pardon, my lord.
Please read.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀ ಸ್ವಾಮಿ ಶಿವಾನಂದ ಸೇವಾಶ್ರಮ ವಿದ್ಯಾ ಸಂಸ್ಥೆ ಈ ಆಡಳಿತ ಮಂಡಳಿ ವತಿಯಿಂದ ನಡೆಯುತ್ತಿರುವ ಶ್ರೀ ಸ್ವಾಮಿ ಶಿವಾನಂದ ಸೇವಾಶ್ರಮ ಪ್ರೌಢಶಾಲೆ ತೊಂಡೆಬಾವಿಯಲ್ಲಿ ನಿವೃತ್ತಿಯಿಂದ ಖಾಲಿ ಇರುವ ದೈಹಿಕ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗೆ ದಿನಾಂಕ ರಂದು ನಡೆದ ಸಂದರ್ಶನದ ಪ್ರಕಾರಣ ನಿಮ್ಮನ್ನು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ WP ನಂಬರ್ ಹಾಗೂ ಅಂಕಗಳ ಜ್ಯೇಷ್ಠತೆಯ ಆಧಾರದ ಮೇಲೆ ನಿಮ್ಮನ್ನು ಆಯ್ಕೆ ಮಾಡಿ ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗಳಿಗೆ ಒಳಪಟ್ಟು ನೇಮಕಾತಿ ಮಾಡಿದೆ. So my lord, there is a direction of the Honorable High Court, my lord, and there's also a reference that she has scored the highest.
Yes.
My lord may kindly turn to Annexure C at page number 14. My lord, this is the marks list. Page number 14.
So this annexure A is addressed to the respondent number 6.
Respondent number 6, my lord.
That was the appointment order.
That was the appointment order.
Yes.
My lord, page 14 is the selection list, as you know, with the marks that have been allotted against each candidate. My lord, may kindly see serial number 2. That is respondent number 6 here in, my lord.
Yes.
Who has been appointed by Annexure A. My lord, the first 2 columns marks card not given, and finally, my lord, on the extreme column number 9, she has secured only 5%.
5% is towards interview.
Interview, my lord, but all the other columns also, my lord, may kindly see, you can vary it, my lord, that it is not, she's somewhere on the lower side itself, my lord. Whereas the other candidates, my lord, including myself, that's the petitioner herein, mine is at serial number 4. I have secured 72.93%.
Yes.
And other candidates are also there, my lord, with 71%, 72%. All the other candidates are there, my lord. My lord, I may just take you even to the direction by this honorable court in a petition that was filed by the respondent number 6, Annexure D, starts at page number 19. The operative portion is at page number 22.
Yes.
My lord, I'll read the order operative portion. The petition stands disposed of, directing third respondent to ensure that the selection process commenced with the fourth respondent, inviting application on 31/10/2023 is brought to closure, considering the petitioner's case. And such closure must involve examination of her candidature based on merits and the other candidates as assessed during the process. My lord, but her appointment is just basically based on okay, there's a direction of the High Court to appoint her. It's a misconception, my lord. They have to consider what the other candidates.
So take out notice, Barkut. AGS director accept, issue emergent notice to respond number 1, 2, and 6. AGS director accept notice for respondent number 3, 4, 5. The appointment of the respondent number 6 at the respondent number 1. Void order of appointment dated 29/7/2024 shall be subject to the result of this petition.
My lord, if stay also may be granted, I filed an aye for dispensation, my lord.
Subject to the result, he is already appointed. This lady is already appointed.
Is already appointed, my lord.
Let it be subject to the outcome of this writ petition. Yes. Dispensation.
For preliminary hearing matter, serial number 21, Devi Prasad Shetty.
Petitioner is a retired employee of respondent number 2 society. Petitioner is before this court for seeking mandamus to the director respondent number 2.
Retirement benefits copy ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
Sir, madam.
Copy ಇದೆಯಾ?
Copy, sir.
I have to settle that.
Retirement benefits is not settled.
Even
Consider and pass appropriate orders.
first respondent also directed the society to consider the retirement benefit. First respondent also directed the respondent society to consider the retirement benefits, my lord. Till today,
First and the response is directed the respondent number 2.
Yes, my lord. First,
ಇಲ್ಲಿ ಇದೆ.
Annexure F, my lord, page number 35. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ
ಬರ್ಕೊಳ್ಳಿ.
ಪತ್ರದಲ್ಲಿ
The petitioner has sought for a writ in the nature of mandamus to direct the respondent number 2 to settle the retirement benefits as per his representation dated 16/22. And also as per the direction issued by the respondent number 1 bearing number so and so dated 16/2023. Next para, the petitioner contends that after working for 30 years with the respondent number 2, he applied for voluntary retirement. He was relieved on 10/5/2022. She requested the respondent number 2 to settle her retirement benefits on 16/5/2022 by a representation dated 16/5/22. Following this, the petitioner also submitted a representation to the respondent number 1. Seeking for a direction to the respondent number 2 to settle her dues. The respondent number 1 addressed a communication dated 16/5/23 to the respondent number 2. Nonetheless, the respondent number 2 has not taken any action to settle the dues. In that view of the matter, the petition is before this court seeking for a direction to the respondent number 2. The learned counsel for the respondent, learned AGA, the learned counsel for the petitioner reiterated the above contentions and sought for an appropriate direction. The learned AGA who represents the respondent number 1 submits that if the petitioner has sought for voluntary retirement as per a scheme brought out by the respondent number 2, the respondent number 2 is bound to act in accordance with the scheme. He submits that based on the representation submitted by the respondent number petitioner, the respondent number 1 has addressed a communication to the respondent number 2 to settle the benefits. Full stop. Next para. In view of the fact that the petitioner has availed VRS and was relieved on 10/5/2022, the respondent number 2 was bound to settle the retirement benefits unless there was any inquiry pending against the petitioner. The very fact that the petitioner's request for voluntary retirement was accepted and she was relieved from service makes it beyond doubt that there was no disciplinary proceedings pending against the petitioner. Full stop. If the services of the petitioner were relieved on 10/5/2022, the respondent number 2 ought to have settled the benefits within 1 month. Since that is not done, the respondent number 2 deserves to be directed to settle the benefits as early as possible, at any rate within a period of 3 months, by considering the representation of the petitioner dated 16/5/22 as well as the direction of the respondent number 1 dated 16/5/23. Full stop. It is made clear that if the respondent number 2 fails to settle the retirement dues, the same shall attract interest at the rate of 8% per annum
on submission
from the date the petitioner was relieved from service till the date of payment.
on submission. Society is also decided to already passed a resolution to settle the retirement benefit, my lord, but till today at annexure C.
Yes.
At resolution.
Next.
Serial number 22 urgent, serial number 23. Only
The
party.
petition stands disposed of on the above terms.
Yes. This writ
Mali
of
party
mandamus
sort of-
to consider the representation and make correction in the service records.
Correction in the service record.
Service record, joining date has been.
ಅದು ಇವಾಗ ಹೆಂಗ್ ಚೇಂಜ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಆಲ್ರೆಡಿ ನನ್ ಜೊತೆ ಆದವ್ರದ್ದು ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ, as per annexure F. Basing on the,
Is it seeking for change in date of birth or?
no, joining date ಅಷ್ಟೇ sir. Joining date of service.
Take out notice for code AG is directed to accept notice for the respondent number 1, 2 and 4. Your corporation BBMP. ಮೊನ್ನೆ MC ನಾಗೇಶ್ ರಿಪೋರ್ಟ್ ಯಾರು ಮೋಹನ್ ಕುಮಾರ್ KV ಅಂದ್ರೆ ಬರ್ತಾರ? ಯಾರು ಹೊಸಬ್ರೆಲ್ಲ ಇದಾರೆ, ಓಂಕಾರ್ ಕಂಬಿ ಬರ್ತಾರ? ಮೋಹನ್ ಕುಮಾರ ಅಥವಾ Mr. ಓಂಕಾರ್ ಕಂಬಿ is directed to accept notice for respondent number
5.
3 and 5. Yes.
This number 2 for fresh matters.
ಇದು ಮಾಲಿ ಪಾಟೀಲ್ ದೊಡ್ಡಪ್ಪ 23.
ಅದೇ ಸರ್ ಇವಾಗ ಆಗಿದೆ.
ಆಯ್ತಾ? Okay.
This number 2 for fresh matters, serial number 3. Kurandwad Gopalakrishna
Not
Prahlad.
appear on behalf of,
Yeah.
but the petitioner 1 and 2, my lord, the stenographers.
Lots, I need to take instructions in this matter. I've been asked to appear on behalf of the respondents. So I'll take my instructions.
What is the relief sought for?
My lord, the relief sought for is, my lord, like the petitioner number 1, my lord, joined as a stenographer in the year 2002 and petition number 2 in the year 1997. Your lordships are aware, my lord, the Honorable Supreme Court had passed an order for restructuring of the cadre of stenographers. That, my lord, this Honorable Court, as per Annexure D, my lord, said that restructuring has to be done, which was approved by the government. However, my lord, till today, the restructuring has not been done. And my lord, the seniority list has been prepared, a temporary seniority list, which shows, my lord, the petitioner as, my lord, in, they don't even say, and now they have called for promotion from grade 3 to grade 2, that is as per Annexure X.
I'll take instructions.
Yawaga?
If you lot.
If that is the case, then don't.
Monday or Tuesday, I will take
List
instructions.
on Tuesday.
Yes,
Please.
I'll find out.
You will
My
accept notice or
instructions, to my instructions, it's been done.
this notice bandidi. You receive copy of
Bandidi.
the petition.
Yes, I am.
But now,
Srimati Vidyulata, EV Vidyulata
Yes, please.
is directed to accept notice for the respondents. List on Tuesday to enable her to secure instructions.
yes,
Great.
public.
Yes.
This number 3 for fresh matters, serial number 2, Prakash M. Patil.
List number 3. Prakash M. Patil.
My lord, the petitioner who has been working as a bill collector. My lord, Annexure L, page number 61. My lord, the Adhyaksha has issued a, my lord, note directing my lord, the petitioner not to attend the duty.
Yeah, the note is at annexure.
Annexure L, my lord, page number 61. ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ಮುಂದಿನ ಕ್ರಮಕ್ಕೆ ಕೈಗೊಳ್ಳುವವರೆಗೂ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕರ್ತವ್ಯದಿಂದ ವರದಿ ಮಾಡಿಕೊಳ್ಳಬಾರದೆಂದು ಈ ಮೂಲಕ ಸೂಚಿಸಿದೆ. My lord, the Adhyaksha is not competent to issue this kind of, my lord, report because the secretary is, my lord, has power. Kindly see, my lord, thereafter, my lord, he has made several representation to the PDO as well as the chief executive officer.
Yeah, what is the reason?
My lord, without showing any reason, my lord. Kindly, my lord,
ಈ ಮೂಲಕ ಶ್ರೀಮತಿ
ಜಯಂತಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕರ್ತವ್ಯಕ್ಕೆ ಗೈರು ಹಾಜರಾಗಿದ್ದು ಸದರಿಯವರಿಗೆ ತಿಳುವಳಿಕೆ ಪತ್ರ ಜಾರಿ ಮಾಡಲಾಗಿತ್ತು. ಅದಕ್ಕೆ ದಿನಾಂಕ 15/7/2024 ಸಮಜಾಯಿಷಿ ನೀಡಿರುವುದು ಸರಿಯಷ್ಟೇ. ದಿನಾಂಕ 15/7/2024 ಕರ್ತವ್ಯ ಹಾಜರಾಗುವಂತೆ ನೀವು ಮನವಿ ಮಾಡಿರುವುದು ಸರಿಯಷ್ಟೇ. ಆದರೆ ಈ ಹಿಂದೆ ದಿನಾಂಕ 21/6/2024 ನಡೆದ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ನಿರ್ಣಯ ವಿರುದ್ಧ ಹೋಗಿರುವುದರಿಂದ ಈ ಸಭೆ ಈ ಸಂಬಂಧ ಮುಂದಿನ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳುವವರೆಗೂ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಮಾಡಿಕೊಳ್ಳಬಾರದೆಂದು ಈ ಮೂಲಕ ತಿಳಿಸಿ. My lord, kindly see, my lord, the PDO has also issued notice to the at page number 54 annexure H. My lord, the issue notice, my lord, stating that on 36/2024, the petitioner is absent unauthorizedly. Therefore, my lord, to give the explanation for regarding the notice, I have made, my lord, the page number 55 annexure J. My lord, I detailed, my lord, along with the medical certificate, I made a reply. Without considering my reply immediately, my lord, the annexure L has been issued. But even Adhyaksha is incompetent, my lord, to issue this kind of the note, my lord, because relied upon the judgment of this honorable court, my lord, clearly said that, my lord, the secretary has a power to issue a notice, as well as, my lord, he has a power to keep my lord, the petitioner under suspension. Therefore, my lord, he appointed, the petitioner is appointed on, my lord, compensatory ground. The one appointment is also approved by the chief executive officer.
Yes, how can you pass, how can the workload AGS director accept notice for respondent number 1? Issue emergent notice to respondent number 2, 3,
My lord, Devraj is appearing for, I think.
Devraj.
MS Devraj, my lord.
MS Devraj is directed to accept notice for response 2, 3, 4 and 5.
I sought for interim order, my lord, they are directed the, my lord, respondent. My lord, permit the, my lord, the petitioner to discharge her duty, my lord.
Correct, we can't do it by.
Because, my lord,
It will be like allowing the petition, mister.
my lord, what happened, my lord, they are not paying salary since from, my lord, April. Till today, my lord.
Permit you to go and report back to work and start working, it is virtually like allowing the petition.
At least, my
Can't
lord.
be by way of an interim order.
My lord,
List on ಯಾವತ್ತು ಬೇಕು?
immediately after vacation, my lord, 14th.
ಯಾವ ತರ ತಗೊಳ್ಳಿ?
14th, my lord.
14th.
Much over.
Serial number 3, Srikanth MP.
Lords, the petitioner was appointed, Lords, as lecturer in a law college on 27/1994. But the institution was not aided at that time. She was subsequently, Lords, on 9/12/2006, was promoted as the principal. In 2015, annexure G, my lords, page number 30, the institution was admitted to grantinate. Page number 31, my lords, the first name is that of the petitioner. Her name was approved and was approved with, my lord, the state scale, because as on that day, she was not having the PhD qualification. However, my lord, subsequently, she acquired the PhD qualification.
When?
My lords, that is in the year 2020, my lords, on 12/11/2020. My lords may have a look at, my lords, annexure H. And certificate also, my lords, and annexure J, my lords. Subsequent to that, by annexure K, the government, my lords, was pleased to extend the UGC scale. From that date, my lord, she acquired the qualification. My lords, from the date the order is passed. But from the date she acquired the qualification, notionally, my lords, it was fixed. My lord, that is extended to me, my lords, that is in the year 2021, my lords. After one year, my lords, thereafter, my lords, now the impugned order is passed, my lords, at annexure N, page number 47. They say, my lords, for being appointed as the principal, I should have had the qualification of PhD, and as such, we are withdrawing the fixation itself. Page number 47, my lords, without issuing any notice, without asking me to, my lords, show cause, the order is passed.
So when were you appointed as a principal?
My lords, in 2006. My lord, my appointment cannot be disputed at all because the LLM was the qualification. The government, my lords, rightly, my lords, grants the pay scale only from the date I acquire the qualification. That is from the date of the order, my lords, the financial benefits are given notionally from the date I acquired the qualification in 2021, December. That is sought to be withdrawn, my lords, by this order, without notice, without opportunity. Not the provision they are relying upon, my lords, is of, my lord, the two thousand
No,
sixteen.
this order dated 21/7/23 is recalled.
Yes, that is, my lords, extending the, my lords, UG scale. Your lords may kindly have, my lords, annexure L, page number 42, my lords, the 47, my lords, your lords can see the, my lords, the order date 24/7/2003.
So this, what is this 21/7/23?
Lord, it should have been 24/7, my lords, there is a
It's a typing mistake.
typographical error.
Uh,
What it says, my lords,
What
take
does this annexure N say? Please read.
annexure N, my lords, it says,
Second para.
please, my lord. Dr. M. S. ಸುಧಾದೇವಿಯರು ಅನುದಾನಕ್ಕೊಳಪಟ್ಟ ಸರಸ್ವತಿ ಕಾನೂನು ಕಾಲೇಜಿನಲ್ಲಿ ರಾಜ್ಯ ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿ ವೇತನ ಪಡೆಯುತ್ತಿದ್ದು ನಂತರ PhD ಪಡೆದ ಅರ್ಹತೆಯನುಸಾರ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರ ಉಪನ್ಯಾಸಕರ UGC ವೇತನ ಶ್ರೇಣಿಯನ್ನು ದಿನಾಂಕ 25/11/2021 ನಿಗದಿಪಡಿಸಲಾಗಿರುತ್ತದೆ. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 16 ದಿನಾಂಕ 24/12/2009 ಆದೇಶದ ನಿಯಮ B ನಲ್ಲಿ ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಗೆ ಪರಿಗಣಿಸಬೇಕಾದಲ್ಲಿ ಈ ಕೆಳಕಂಡ ವಿದ್ಯಾರ್ಥಿಯನ್ನು ಪೂರೈಸಬೇಕಾಗಿರುತ್ತದೆ. Number 2, my lord, it's about PhD qualification. Then they say, my lords, next page. ಸಹ ಪ್ರಾಧ್ಯಾಪಕರಿಗೆ ಮತ್ತು ವಿಭಾಗದ ಮುಖ್ಯಸ್ಥರಿಗೆ ಆಡಳಿತದಲ್ಲಿ 15 ವರ್ಷ ಪೂರೈಸಿರಬೇಕು. API ಅಂಕಗಳನ್ನು ಸಂಶೋಧನಾ ಪ್ರಬಂಧಗಳನ್ನು ಪಡೆದು ಪ್ರಕಟಿಸಿರಬೇಕು. ಈ ಅರ್ಹತೆಗಳನ್ನು ಶ್ರೀಮತಿ MS ಸುಧಾದೇವರು ಪಡೆಯದೇ ಇರುವುದರಿಂದ ಇವರಿಗೆ ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಗೆ ಅನ್ವಯಿಸಿ UGC ವೇತನ ಶ್ರೇಣಿಯನ್ನು ವಿಸ್ತರಿಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಹಾಗೂ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 16 ಪದದಲ್ಲಿ ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಿರುವ ಮಾನದಂಡಗಳನ್ನು ಶ್ರೀಮತಿ MS ಸುಧಾದೇವಿಯವರು ಪೂರೈಸಿರುವುದಿಲ್ಲವೆಂದು ಕಾಲೇಜು ಶಿಕ್ಷಣ ಇಲಾಖೆ ಹೆಚ್ಚುವರಿ ನಿರ್ದೇಶಕರು ಇವರು ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ಹಿನ್ನೆಲೆ ದಿನಾಂಕ 21/7/23 ಆದೇಶವನ್ನು ಹಿಂತೆಗೆದುಕೊಳ್ಳಲು ತೀರ್ಮಾನಿಸುತ್ತದೆ. ಅದಂತೆ ಈ ಕೆಳಕಂಡ ಆದೇಶ. No notice, no explanation. Lord, the requirement is, my lords, for appointment as principal, my lords, in terms of the use scale, not for, my lords, where I am already appointed and working.
No, that is okay, but what was the requirement for?
At that time, my lords, LLM, my lords, state scale. That's the reason, my lords, when I was 2015 order, if you lordships kindly see, the order admitting my appointment for granting it.
As what?
My lords, as principal itself. That is, my lords, at page number 31, my lords, order portion of order dated 26/8/2015. First one is a ಪ್ರಾಂಶುಪಾಲರು so and so, my lords, ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿ ರಾಜ್ಯ ವೇತನ ಶ್ರೇಣಿ NET SLET PhD ವಿದ್ಯಾರ್ಥಿ ಹೊಂದಿರುವುದಿಲ್ಲ. If I had that, my lords, I would have been extended with UG scale by them. That was granted only subsequent to, my lords, I acquiring the qualification.
But they refer to some 2009 circular saying that even for the purpose of a principal, you should have had this following qualification.
That is, my lords, under the, for appointment as principal under UGC scale.
Appointment itself could not have been approved.
2006, my lord, that is not correct. My lord, appointment was approved with state scale. My lord, because I was eligible as on the date of appointment.
Problem is, you could not have appointed the approval could not have been given.
My lord, the law is, my lord, the law is, when the approval is made, it dates back to, my lord, the date of appointment. Lord, the question is whether I had the requisite qualification as on the date of appointment or promotion, as the case may be. 2006, that's the reason, my lord, there is no dispute for extending the state scale, my lords, as on the date it was approved, 2015. Because 2006 was my, my lord's promotion.
Promotion as principal.
2006.
Where do I get it?
My lords, may I have a look at, my lords, the order promoting me, my lords, at annexure F, my lords, page number. Please, I'm sorry, my lords, promotion order, my lords, as reader, my lords, annexure E, F as principal, my lords, 2001.
Associate professor in 2006. How could you become a principal in 2001?
My lords, state scale, I was the person available, my lords, I was appointed. Lords, there is redesignation, my lords, may appreciate. The concept of, my lords, associate professor, my lords, professor and others.
Notice, there is some doubt.
Lord, there is, my lord, there is a requirement, my lords, for the interim order. My lords, I can say, my lords, if they pass an order, considered order, my lord, that's a different
Take
issue.
out notice.
Let them, my lords, let them not implement, my lord, this.
AG is directed to accept notice for response 1, 2 and 3. Yavat vacate, when do you want it?
Monday, Tuesday, my lord, the difficulty is, my lords,
If you don't have the qualification, your appointment itself could not have been approved.
it is not so. I can, my lord, demonstrate from division bench decision of this honorable court.
List on ಯಾವ
After vacation,
Yav-
I don't have the file also.
take a date, ಯಾವ್ದೋ ಒಂದು date ಕೊಟ್ಟು. List on
16.
16th. Yes,
Let them, my lords, in the meanwhile, not implement this.
please wait, yes.
And my lords, if I make a request, my lords, in the preliminary hearing itself, my lords, otherwise. ಅಲ್ಲ ಯಾವತ್ತು ತೊಂದ್ರೆ ಆದ್ರೆ ಮತ್ತೆ ನಂಗೆ ಇಲ್ಲಾಂದ್ರೆ at least for consideration.
Mention for
ಅಲ್ಲ,
consideration.
at least for consideration of interim lordships, my lords, post on that day.
Because it might come up before a better judge who will be
ಅಲ್ಲ,
quicker.
my lords, I
faster.
don't run, my lords, the
More relief
difficulty is,
oriented.
my lord, the difficulty
Yes,
is there.
correct, next.
ಅಲ್ಲ,
Number one, list number
your lords may indicate that, my lords, the interim order may.
24, Satish K.
Otherwise, tomorrow, my lords, it should not be a situation where, my lords, it is said that no interim order was granted.
ಮಧ್ಯಾಹ್ನ ತೋರ್ಸು. ಸ್ವಲ್ಪ papers arrange ಮಾಡಿಲ್ಲ. I'll take it up in the afternoon.
Very well.
ಮಧ್ಯಾಹ್ನ. Right, ಮಧ್ಯಾಹ್ನ.
For final hearing matters, serial number 25, Prakash Salmani.
Responding to this matter. In the last state, my lord, your lordships have directed us to consider their proposal, my lord, and file a report. Lord, I may have permitted, my lord. On the last day, a proposal was given by them. Lord, that was placed before the committee, and I was directed to furnish a report in that regard.
ಏನಾಯ್ತು?
Report is filed.
Yes, are you willing to accept this? ಮುಂಚೆನೆ ಕೊಡೋದಲ್ವಾ? You should have given circulated in advance.
My lord,
ಈಗ ನನಗೆ
prior to that, my lord, petition number 2 has given representation for that. Prior to that, petition number 2 in this case, my lord, has given the representation. For that, they have not given any report, my lord.
Petition number 2 ಗೆ ಏನ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಇಬ್ರದ್ದು ಕೊಟ್ಟಿದ್ದೀನಿ.
ಚಂದ್ರಶೇಖರ್ and ಉಮೇಶ ಇಬ್ಬರಿದ್ದಾರೆ.
Umesh is also there. Both of them, my lord, are entitled to this
ಇಬ್ಬರದ್ದು
amount.
ಇದೆಯಲ್ಲ, ಚಂದ್ರಶೇಖರ್ and ಉಮೇಶ.
ಇಬ್ರದ್ದು ಹೇಳಿದ್ದೀನಿ ನಾನು.
ಒಂದೇ ಇರೋದು.
ಚಂದ್ರಶೇಖರ್ಗೆ 39.5 ಲಕ್ಷ. ಉಮೇಶ್ಗೆ 33 ಲಕ್ಷ.
We will discuss with the client and
We'll go through it and.
ಮುಂಚೆನೆ ಕೊಟ್ಟಿರೋ
ಈಗ
ಮುಗಿಸ್ಬಿಡಿ.
ಬಂತು ನನಗೆ, ಅದಕ್ಕೋಸ್ಕರ I had to give it to
Because,
your
my
lordships now.
lord, there is a huge difference. We have given for 1 lakh.
Want to argue, you can argue, otherwise
One date may be given.
the learned
That may
counsel
be
for the respondent has.
Taken as part of.
No parted. The learned
Well,
counsel for the
otherwise-
respondent has today filed a memo along with a copy of the minutes of the
My lord, respondent committee.
respondent committee. The same is taken on record. The learned counsel for the petitioner seeks time to secure instruction.
I'll have it on Monday, my lord, Monday.
Interest ಎಲ್ಲ says factor ಮಾಡಿ could have closed it at 50 lakhs ಇಬ್ರಿಗೂನು.
I'll take instructions, my lord. I can't commit myself. ಈಗ ಅವ್ರ
ಅದೇ,
committee ಮುಂದೆ ಇಟ್ಟು.
All these petitions pending since the last 11 years. Suppose even if we say reinstatement with back wages, then the amount will be much more. So round it off at 50 lakhs each to both of them.
I'll communicate this to
Monday, my lord, Monday.
Iಷ್ಟ on ಯಾವತ್ ಬೇಕೋ ತಗೊಳ್ಳಿ.
after,
Monday.
immediately after vacation, if your lordships can have it.
You
Vacation.
decide and take whichever date
Yes,
you
yes, yes.
want.
Immediately after, because I'll have to communicate to your lordships.
Immediately after vacation.
Monday ಆದ್ರೆ ತಮ್ಮ ಮುಂದೆ ನಾವು.
Sir, Samunda, it's before the High Court. I don't have any personal interest in this
It is
matter.
heard, my lord.
It's all right. Now they have made an offer. If you're interested, accept it. Not
May I-
interested,
May I
argue the
make a
matter.
submission, my lord? without prejudice to my rights, my lord, this offer is made. Let that be recorded at least. Like, and without prejudice, and tomorrow
the
they should
matter
not
is-
come up and say,
The matter is seized before the court.
yes, my lord.
And you
but
made the
nonetheless, my lord,
proposal pursuant to an order passed by this court.
Definitely.
Where's the question of prejudicing your
No,
rights?
my rights should not, whatever canvas, my lord, before your lordship should not get prejudiced.
Will
on
it be
Kelkar.
prejudiced?
Like, they should not
Satyanand, you-
raise this as a defense before your lordship at the time of
Satyanand.
arguing the matter.
You are a lawyer with rich experience. How can you make such a statement? When the
I'm not
matter is
saying,
seized before the court.
I'm only saying this, my lord, they should
Shouldn't
not make this as a
unnecessary-
defense, my lord, ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ.
ನೋಡಿ, ಮಳೆ ಬರುತ್ತೆ ಅಂತ 3 ಸತಿ 3 ಪ್ಯಾಂಟ್ 3 ಶರ್ಟ್ ನೀವು ಹಾಕೋತೀವಿ ಅಂದ್ರೆ ನಾವೇನ್ ಮಾಡಕ್? ಮಳೆ ಬಂದಾಗ ನೋಡ್ಬೇಕು.
I will not say
ಮಳೆ
anything.
ಬರುತ್ತೆ ಅಂತ ನೀವು ಹಾಕೊಂಡ್ರೆ ನಾವೇನ್?
ಯಾಕಂದ್ರೆ ನನಗೆ ಇದೊಂದು ಅಪ್ರಿಹೆನ್ಷನ್ ಇದೆ ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ.
The matter is being examined by the court. Where's the question of prejudice? It is being examined by the court.
I definitely understand. My
Don't
only
make-
apprehension
no.
is, my lord, this.
Don't make unwanted
Very well.
statements.
Please, please.
ಯಾರು ಯಂಗ್ಸ್ಟರ್ ಮಾಡಿದ್ರೆ okay, you're a responsible advocate, so many years
Definitely,
of
my lord, but
practice.
nonetheless,
Don't make irresponsible statements.
please,
Yes.
any day.
26 AJ Srinivasan.
ಯಾವ date?
Mr. Ajesh, ಯಾವತ್ ಬೇಕೋ ತಗೊಳ್ಳಿ. Any date.
Any date after vacation. I'll
ತಗೊಳ್ಳಿ.
communicate your lordships this one.
Date maybe. ತಗೊಳ್ಳಿ. ಯಾವತ್ ತಗೊಳ್ರಿ ಯಾವ್ದಾದ್ರು ಡೇಟು.
14th.
14th.
Please.
This is the matter, my lord. This is the matter wherein you lordship.
Yeah, your lordship directed me to produce those records.
You know, what is this? The dates when they submitted the request for voluntary retirement,
Yes.
when it was accepted, when they were relieved,
Yes,
when the request for voluntary retirement was allowed to be withdrawn,
Yes.
and also whether they were granted.
they were, yes, my lord, these are all very old records. We've been trying to get about 6 we have got, the other we are getting, we require another 10 days time.
My lord,
The learned counsel
We'll
for the
produce all the
respondent
records.
my lord, one submission.
seeks time to comply the order dated 18/9/24. Now, without this information, can we decide your case?
Yes, my lord, that annexure itself is given under the Right to Information Act, my lord. Those are, that material itself, if the court considers, my lord,
No,
your
that on the
lordship.
last date, you are not able to furnish some information.
No, my lord, whether
We
it
looked
is an
into that.
authentic,
Lord,
whether
we have the information,
court
we will
had a
provide it,
doubt.
my lord, we'll produce the records also.
only thing is.
ಅವ್ನು ಯಾವತ್ ಬೇಕು?
Any date, my lord. After 10 days, my lord, any date your lordship can kindly fix.
15, 16.
Calendar is there.
Yes,
If you can't see it, we'll
21st.
put it
Lord,
close ಯಾವ್ದಾದ್ರು.
23rd, my lord, your lordship.
23rd.
23rd.
It may be taken as parted, my lord,
No,
that
no parted.
kindly decided.
No parted.
27 Nishant Devi.
Yogesh.
Appear for the petitioner. 27, that is writ petition 42494 of 20.
Hmm? 42494.
Please, minutes. There are
Maybe
two matters.
Narayan Swami.
Prepared a short list of.
Good, good. Yes, good.
Minutes. Petitioner minutes. Joint services of KUWS DB minutes. Then he was promoted as superintendent. Then minutes he was subsequently promoted as registrar. In 2007 minutes, when petitioner was continuing as registrar, a show cause notice cum charge sheet was issued upon him, stating that he is charged for shortage of store materials, which is an offence under Karnataka Civil Service Conduct Rules 1966. To which petitioner submitted a detailed reply to the charge sheet served upon him. Second show cause notice was issued on the petitioner pursuant to the report of the inquiry officer on 21/3/2011. Petitioner replied to the second show cause notice, which enumerates the bias that the inquiry officer has made of. Then, my lords, petitioner was relieved from the duty on attaining the age of superannuation. This is in 2014. Then petitioner on superannuation was denied terminal benefits by the respondent. Thereafter, petitioner made a representation. On receipt of the representation of the petitioner, the respondent, my lords, sanctioned provisional pension and ordered withholding of DCRG and communication of pension, invoking Rule 214A, and 376(7), the Karnataka Civil Service Rules. Then petitioner files an application under Article 226 of the Constitution in WP number 10558 of 2015, seeking a direction to the respondents to pay the balance terminal benefits excluding 1.35 lakhs. Then, my lord, subsequently legal opinion on submitting the report of the inquiry officer. Disciplinary, this, my lords, 35/2015, Annexure J, page 96. Disciplinary authority issued a fresh charge sheet on the petitioner for shortage of materials which had occurred in 1993 to 1998. Then disciplinary authority, after perusing the legal opinion, opted to re-enquire the matter, pursuant to which a new show cause notice cum charge sheet was issued on petitioner seeking a reply. Then a fresh presiding officer, new presiding officer was appointed. My lords, the specific case is this. The allegation is, my lords, pertaining to the year 1993, 1998.
The earlier allegation was in respect of what period?
The very same thing.
Same.
The very same thing.
Yaar pe aakar? Who appears for the respondent?
Mr. Yogesh Nayak.
Yogesh Naik.
Yogesh D. Nayak.
This could not have been done because it's more than 4 years.
Case alone. What is your case?
I filed this.
Huh?
Stage of charge sheet level, I filed this.
Charge sheet?
Stage earlier,
Mike,
2015 ಅಲ್ಲಿ, at the stage of charge sheet, I have filed this.
Anyway, that has become infectious. Alva?
House.
Yogesh Naik. ಕರ್ಕೊಂಡ್ಬರ್ತೀರಾ?
My lord, he is a government advocate.
Yogesh Naik, government advocate.
ಇಲ್ಲ, he is not a government. My lord, may kindly have to Monday.
But he can appear for the board, isn't it?
He can
appear.
In fact, last 2 occasions also.
ಅಲ್ಲಿ ಯೋಗೇಶ್ ನಾಯಕ್ ಕಲಿಗೆ ಯಾರು ಇಲ್ವಾ?
I'll inform him.
ಬರ್ತಾರಾ? ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ? ಪಾಸ್ ಓವರ್.
Serial number 28 urgent, serial number 29 disposed of, serial number 30 Ashok GV.
Please, my lord, here in this case, my lord, statement of objection, some rectifications there. State filed objection. I'll rectify it. To this time, I'll rectify it.
Copies ಹೊರತು ಅದು ಅಶೋಕ್ ಜಿವಿ.
Ashok GV, serial number 30.
ನೀವಾ? ಅಶೋಕ್ ಜಿವಿ. There is no representation for the petitioner. The learned AG undertakes to comply the office objections regarding
Statement of
office objections raised on the statement of objections. List on
after occasions.
23rd October.
In fact, please, oblige me.
Yeah.
Number 2 for final hearing matter, serial number 4.
SH Prashant. Password ready na?
Certain documents they had sought, my lords, we have given all the documents.
You ready? Both of you ready? Ready na? Ready? Password.
Serial number 5, MP Srikanth.
Serial number 5. Madhukar Deshpande, MP Srikanth. There is no representation for the petitioner and respondent. Serial number 5. Yes, ready idre kodi. Madam ಎಲ್ಲ ಹೋದ್ರಲ್ಲ.
To me.
No, Madam, no, Madam Vidyulata, I think she left the court. ಈಗಿದ್ರು can come by 3 o'clock. ಬಂದ್ರು ನೋಡಿ.
ಹುಡುಕ್ತಾ ಇದೆ.
They have made available the resolutions.
All lawyers can leave. Can I tell all lawyers to leave?
I'll take.
Allah.
Yes.
If it is good till 1:30, I can ask the lawyers to leave. They need not wait.
With your lordship's kind permission. Serial number.
Allah, this
No, no,
matter will take only up to 2:30, 1:30.
no, true, my lord, no. Just wanted to withdraw my petition.
Yavadu?
Serial number 33 in the first list,
Number 33.
please.
The learned counsel for the petitioner has filed a memo to withdraw the writ petition. The memo is taken on record and the petition is dismissed as.
In terms of the operative, the portion of the memo, my lord, because
Huh?
reserving liberty in case it is to be,
You have sought for liberty.
yes, because
Yes, good.
want of instructions, I am withdrawing it. Keeping all other questions open.
No, but then how can you seek for such a liberty? You argue the matter on merits then.
Then, I mean, what has happened is, 10 years have passed and that order which, I mean, the selection process which was now, after that, the 3 selection processes have taken place.
So
So
then this writ petition has
doesn't-
become infructuous virtually.
virtually it has become infructuous, therefore I'm withdrawing it.
So then don't you ask for liberty to you. You
No, very
also,
well.
you already retired from surveys.
No, not written.
Ilwa.
ಇಲ್ಲ.
Then,
No, it is for the first fresh applications which were filed.
then you, these questions will be kept open.
Yeah,
for
questions
court.
will be kept open, yes.
Yes, to withdraw the, however, the questions raised in this writ petition is kept open to be considered in an appropriate petition that
please.
may be filed by the petitioner.
Please, much obliged.
That's serial number 40, my lord. I'm suffering from eye fever, my lord. Afternoon, my lord.
You
Kindly
are
have the
suf-
matter Monday, my lord. Serial number
40.
40, my lord. I'm for the petition.
40 high fever.
Kindly have the matter
Done.
Monday, my lord.
Serial number 62, my lord. Day before yesterday. Each preliminary hearing al barbekaitu. One matter.
ಆಯ್ತು ಬರುತ್ತೆ ತಾಳ್ರಿ ಒಂದ್ 5 ನಿಮಿಷ ಕೂತ್ಕೊಳ್ರಿ.
Serial number 7, my lord. It was informed that acknowledgement was not been received. So I may be permitted to take I may be permitted to take notice on Central Government of India Panel Council.
ಯಾವ್ದು?
Serial number 7, my lord. CO was already been paid.
ಚೇತನ್
Please, ma'am.
Central Bank.
Central Bank of India Panel Council.
EF ಕೊಟ್ಟಿಲ್ಲ.
Put this, but it was await notice for on behalf.
Second time ಕೇಳಿರೋದು. Take out fresh process.
Lord, I may be permitted to take notice on standing council.
1 week time is granted to do the needful. In addition, the petitioner is permitted to serve and summons to the
Central-
respondent number 2 and 3 and also serve the standing counsel for the respondents 2 and 3.
Great.
List after the same is done and reported to the court.
Great.
My lord, my lord, serial number
ಆಯ್ತಮ್ಮ,
5.
ಇರಮ್ಮ, ಇನ್ನ ಕೋರ್ಟಿನ ಮುಗ್ದಿಲ್ಲ.
List
Okay.
number 2, serial number 4.
Sir, I have filed a synopsis on 30th August. A short synopsis. Lord, should kindly take.
Yes.
Anything from my side, madam? Melos at page 106. Annexure K. Is the first charge sheet issued to the petitioner. That is DI 1 of 2005. That is dated 10th March 2005. Then, my lord, the next charge sheet is at page 155. This is DI 8 of 2005, dated 18th August 2005. Then my third charge sheet is at page 192. That is DI 12 of 2005. In this, my lords,
The third charge sheet is 13th February 2006.
13th February
2000.
2006, yes, my lord, 12/2005, correct. Number third charge sheet is very significant, my lord. By reply given to the first two charges, it is made a charge memo here saying that I have not used very pious language in my reply. Law is settled, my lords. When you charge me, obviously, charger cannot expect me to be smiling and giving a, no, my lords, no. He'll write no. Does it become a misconduct?
Yes.
Then, my lords, in all the three inquiries, Lordship Justice H.L. Dattu is appointed as inquiry officer. Thereafter, my lords, on transfer of Justice Dattu, Justice S.R. Bannur Mutt is appointed as the inquiry officer. That order, my lords, would get at page 283. And he continues with the inquiry and he submits a report, annexure AC at page 285.
Page 285.
Page 285. That is the report of the inquiry officer, where, my lords, he holds.
This is in respect of all the three charges.
All the three charges in single penalty.
Yes.
What he is finding is, my lords, at page 330. Charge made against DJO in 1 of 2005 is proved. Charges made against DJO in 8 of 2005 proved. The first charge in the 12 of 2005 is proved and the second charge is not proved. On this, my lords, a second show cause notice is issued to me, which is at page 331. It is dated 11/3/2009. This is one of the contentions I have raised is, I was entitled for a notice before accepting the inquiry report. But the High Court accepted the inquiry report and thereafter issued me a notice, which amounts to post-decisional hearing, which cannot cure the defect of absence of pre-decisional hearing.
So the report of the inquiry was not furnished to you.
Report of the inquiry was furnished
When?
after accepting it. This, along with the second show cause notice, 11/3/2009, report of inquiry was furnished to me. This is how it reads, my lords. The High Court and the disciplinary authority has accepted the report submitted by the inquiring authority. The Honorable High Court has proposed to impose the penalty of dismissal from service against you and directed to issue second show cause notice.
Yes.
Then, my lords, I file a detailed reply, which is at page 332. In this reply, my lords, I raise several contentions, which are all reiteration of what I had raised in the inquiry. It is not that I became wiser after the event. I have raised all these grounds from time to time. First contention was that the two registrars' vigilance Of course, they did violence to vigilance. Two registrar vigilance who investigated into the matter, they were my juniors, and their career advancement very much depended upon removing me from the field of competition to be for elevation to the High Court.
Yes.
Second contention that I have raised is that the first inquiry officer, when the commencement of evidence, he sought to administer oath to the witness. Then I objected that, irrespective of the rank, he is not sitting in session in a court. Therefore, he has no jurisdiction to administer oath to the witness. Then inquiry was adjourned. Again, the matter came up. By then, what the High Court does is, it brings the inquiry under Public Servants Inquiry Act, where the inquiry officer is permitted to administer oath. Kindly, my lords, a charge sheet is issued under the CCA rules. At that point of time, Inquiry Act is not invoked. Here the damage done is, investigating officers who are the registrar's vigilance, they collect evidence administering oath to the persons they are examining.
Yes.
It is not a court. Then second oath administering ceremony, the inquiry officers opens. I say, stop. You have no business to do it. You have no power to do it. Matter is adjourned. Next, they come up with an order of the High Court that the inquiry has been brought now under Inquiry Act, and Lordship Justice Dattu, as inquiry officer, is empowered to administer oath.
Yes.
This is nothing but, a sort of predetermination. Whatever be the law, we will see that witnesses are examined on oath. Then, my lord, the prior statement of the witness with the registrar vigilance has administered oath and taken. They are taken as evidence. Of course, I am permitted to cross-examine. Then, my lords, another contention I raised is that Lordship Justice Dattu was the first inquiry officer. Lordship Justice S.R. Bandurmat is the inquiry officer who continued the inquiry from where Justice Dattu left and submitted the report. Inquiry is vitiated by bias because both of them were part of the Administrative Committee number 1, which rejected my defenses and ordered framing of charges, which rejected my representation for shifting of headquarters from Bidar to Bangalore during suspension, and their appointment as inquiry officer itself has vitiated the inquiry, because there is a judgment rendered by Lordship Justice Dattu himself on judicial side in a case where I appeared. I'll point out that judgment to my lords. Then, my lords, there was some delay in making available the proceedings of the first committee. After my lord's order, now they have made available to me the proceedings of the Administrative Committee, where decisions regarding disciplinary proceedings against me were taken. If my lords have that document, my lords.
When was that fight?
We filed it.
Today? This was filed on 25th.
Yes, ma'am.
Yes.
My lords, the first page 3 is The proceedings of the meeting of the Administrative Committee number 1 held on 2nd February 2006. This is in the matter of consideration of draft articles of charges and statement of imputations in respect of G. Narahari, Principal District Judge. Kindly see, my lords, who are the persons participating. 4 is the first inquiry officer, 5 is the second inquiry officer. In respect of 4, there is a notation made at the end of the proceedings that he did not participate in the proceedings.
No, but this meeting is in February 2006.
Yes, my lords.
And the articles of charge was issued.
That is, my lords, this, in fact, 12 of 2005 is actually issued on, though it is numbered as 12 of 2005. It is, my lords pointed out to me, it is issued.
13-2.
Yeah, 13-2.
2006.
Now, my lords, serial number 5, he participates.
Yes.
Then, my lords, next meeting is
Either item number 3 one. Mr. Justice H.L. Dattu did not participate in the
at the
deliberation.
last bariತಾರೆ note ಅಂತ ಹೇಳಿದ್ದೆ.
He did not participate.
He did not participate in the deliberations on this item. Stricto sensu meaning of it is he was sitting, but he did not open his mouth.
They do not sit, my lords. When these matters, my lords, on each day, 8 to 10 matters will be taken up, my lords. They do not sit, they go out.
I do not know, I am only,
Participate in
They
the
don't
process.
express, they don't participate.
They don't
they
participate.
don't participate in the deliberations,
They do not.
They don't express any of their opinion.
any of the views. Maybe looking to other side, just. Next meeting is that of, at page 7, 14 November 2015.
2005 ಅಂತಿದೆ.
2005, sorry, sir. To consider the reply submitted by so-and-so to the show cause notice in DI 8 of 2005. Here also, Lordship Justice S.R. Bandurmat very much participates. At page 8, they say, at page 7, they say, Justice Dattu did not participate. Next is 9th August 2005. That is at page 9, at which time both these inquiry officers were not members of the first committee. Then comes, my lords, page 12. Meeting of 27th September 2005. There also, at page 14, there is a note. Sri Justice H.L. Dattu did not participate in this item. Page 16 is another meeting of 7th June. There also, there is a statement made at para 17, page 17. The Honorable Justice Dattu did not participate. Then, my lords,
There's some in page number 17, there's some dropping of further proceedings. What is this? Page 17, item number 3, resolution. To consider the written statement.
that is, they wanted to issue another charge sheet, DI 13, that they say that we will not proceed. Because by then they had issued enough charges. Page 20 is crowning glory, 1st March 2007.
Yes.
This is the resolution appointing Justice S.R. Bandurmat as the inquiry officer. Kindly see the signatories at page 22.
Yes.
He himself is a party. Next page is 2nd March 2009 at page 23. Serial number 3 is S.R. Bannurmat. And the decision is accepting the adverse report of the inquiry officer. Let me read this page. Madam, is it 24, 25?
It is 24,
24 and
25.
25. Because the 3 ತರ ಕಾಣಿಸ್ತದೆ. ತೊಂದರೆ ಇಲ್ಲ. I will read it as I don't. The inquiry report dated 16/10/2008 submitted by Honorable Sri Justice S.R. Bannurmat in disciplinary inquiry so and so against G. Narahari is placed for consideration. The inquiry was conducted by one of the members of the committee, Honorable Sri Justice S.R. Bannurmat, and hence Honorable Justice but did not participate in the deliberations. The inquiry report dated so and so is against Sri under suspension is accepted. The committee accept Bannurmat deliberated into the report. Now, my lords, but kindly see, since the charges are proved and grave in nature, impose the penalty of dismissal. Now, my lords, participation in 4 meetings to issue the charge sheet. And then in the resolution, which appointed himself as the inquiry officer. That is good enough ground to set aside the whole inquiry.
Yes.
And the consequent penalty. For this, my lords, I rely on the judgment. I have filed the index of authorities. Good bit. There, my lords, item number 7 of those index of authorities at page 75. M. Sachidanandan versus Assistant General Manager. Para 2 gives the facts which I need not read to my lords. Para 4. Though numerous grounds have been raised in support of the prayer for quashing the orders imposed by the disciplinary authority and confirmed by the appellate authority in the petition, what has been really precedent to service by the counsel for the petitioner is the contention that the orders passed by the appellate authority is opposed to rules of natural justice. The reason being, the appellate authority must be deemed to have been biased, since the adjudicator of the appeal had personal knowledge of the material facts of the case and had rejected the explanation offered by the petitioner to the show cause notice issued by him, and had further referred the matter to the disciplinary authority of the bank to initiate domestic inquiry proceedings against the petitioner for the alleged irregularities said to have been committed by the petitioner. Per contra, so and so learned counsel for the respondent contends that the petitioner was aware that the appeal filed by him would be decided by the same officer who had issued the show cause notice in the capacity of AGM of the respondent bank. Having not objected at that stage, petitioner should not be permitted to raise the question of bias for the first time in the writ petition, and secondly submits that on the mere suspicion that the appellate authority hearing the proceedings is biased, the inquiry proceedings cannot be held to be vitiated. By saying so, the learned counsel justifies the orders framed. Para 8. Para 7 onwards. It is an elementary rule of natural justice. The person who tries a case should be able to deal with the matter before him objectively, fairly, and impartially. The word impartiality is the antonym of the word partiality or bias. Bias is a condition of mind which sways the judgment and renders judge unable to exercise his functions impartially in a particular case. Bias on the part of the person acting in a judicial capacity is called judicial bias. The broad principle evolved by the courts is that a person trying a cause, even in quasi-judicial proceedings, must not only act fairly, but must be able to act above suspicion of unfairness. This is based on the maxim, which is often repeated, that justice should not only be done, but should be seen to be done. The onus of proving bias is on the person who alleges it. The allegation must be clearly proved if the proceedings are sought to be set aside. Supreme Court in International Airport Authority versus KD Bali observed that it is not every suspicion held by a party must lead to the conclusion that the authority hearing the proceedings is biased. The apprehension must be judged from healthy, reasonable, and average point of view, and not on mere apprehension of any whimsical person. The reasonable apprehension, it may be noted, must be based on cogent materials. Keeping in view these well-settled principles, let me now advert to the facts of the present case. In the Sri S.C. Paul, an Assistant General Manager, International Banking Department of the respondent bank, had signed the show cause notice dated 29/1/87. In the said notice, several acts of omissions and commissions said to have been committed by the petitioner had been alleged. Petitioner had filed his reply denying these allegations. The Assistant General Manager of the bank, not being satisfied with the explanation offered by the petitioner, had requested the discipline authority of the bank to initiate disciplinary inquiry
Continue
proceeding.
in the afternoon session.
Then, my lords,
Afternoon.
well,
Dictation for- dictation for-
ಯಾಕ್ರಿ? ಏನ್ ಇನ್ನೇರಿ? ಆಯ್ತಾ ಮೇಡಮ್? ಮಧ್ಯಾಹ್ನಕ್ಕೆ ನೆನ್ಪು ಮಾಡೋದು. ಏನೇನು ಯಾವ ಕೇಸ್ ಏನಿಲ್ಲ ಪ್ರೊಸೀಜರ್ ಇದೇನು ಹೇಳಿದ್ರೆ ಆಗಿಲ್ಲ. Because of the procedure lapse. ಓದ್ ಹಾಕಿದ್ರು ಓದ್ ಹಾಕಿಲ್ಲ. Make difference to his case.
Document, whatever is in the
ಹೇಳಿ ಸರ್. ಯಾವ್ದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ರಾಜಗೋಪಾಲ್ ಯಾವ್ದೋ ಒಂದು ಈ ಮ್ಯಾಟರ್ ಮಾಡಿದ್ರು ಒಂದು ಫೋಟೋ ತಕೊಂಡೆ ಇದು ಮೇಡಮ್.
ಫಸ್ಟ್ ಅದೇ ಕರೀತಾರ ಅಥವಾ ಇದು ಕರೀತಾರ?
ಎಲ್ಲೂ ರೀಚ್ ಆಗಿಲ್ಲ.
First ಯಾವ್ದು ಸರಿ?
The question.
Lordship's kind leave.
Ah,
List number 3, item 5,
ah.
I had mentioned yesterday. Looks like it may not reach today. Monday would your lordship have it.
Whatever
Monday,
date
2:30. It's a short point, my lord, on the POSH Act. Alternative remedies available. Monday, 2:30, my lord.
Whichever date.
Monday, 2:30.
This lady was there on, I think, online.
We will communicate, my lord. It may not reach today, my lord. Third list.
We'll take it up after we finish this matter, 1 or 2 matters.
Oh, 4:30, my lord, can I?
Come at 4:30.
I'll come.
I make a submission, my lord. In the fresh matter, it's a matter of suspension for Monday.
Lord, list number 1, serial number 31. Lord, your lordship may kindly have it on 21st of October. But an amendment is required. I have filed an amendment application also, that is
Serial number 31.
31 in list number 1.
Serial 31. I think it's already adjourned. No?
No, not the Lord. This WP 20487 of 2014.
Not it.
Where there is an EA number 1 of 2024, application for amendment.
But you came from, I think, Kerala on the last date, you
Yes.
said. I told you that we'll take it up now.
But Lord, after going through the matter, Lord, I thought an amendment is highly required.
Oh, after
For
10 years.
incorporating.
When did you wake up?
Lord, there is a change of council, Lord. Earlier another council was appearing.
Right, after 10 years, you need an amendment.
But it's only a necessary corollary of relief number 1.
Learned counsel for the petitioner seeks time.
In fact, it is filed here, your lordship.
List on, when do you want it? 21st?
21st of October.
21st. Correct. ಯಾವತ್ ಬೇಕೋ ತಗೊಳ್ಳಿ, whichever date you want. 21st. List number 36 ನಾವು ಕೋರ್ಟಲ್ಲಿ ಇಲ್ಲ. Learned counsel for the petitioner seeks time. Serial number 36 ಅಲ್ಲಿ. Learned counsel for the petitioner seeks time. List on.
Number 63, Monday, my lord, 2 matters are there. One, there is already a stay order. 2 assistant professors transferred out of the faculty from engineering to architecture. ಒಬ್ರು ಅವ್ರಿಗೆ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರಾ. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಫಿಸಿಕ್ಸ್ ಹಾಕಿದ್ದಾರೆ. ಸೇಮ್ ಸ್ಟೇ ಮಾಡಿ ರಿಓಪನಿಂಗ್ ಡೇಸ್ ಆಫ್ಟರ್ ಹಿಯರಿಂಗ್ ಅದು ಕೊಟ್ಟಿರೋದು ಸ್ಟೇ ಆದ್ರಿಂದ. WP number 25511.
No, if it's already stayed, then what is to be?
Connected matter. Both are posted today. 24786 ಅಲ್ಲಿ individual order. ಅದು stay ಆಗಿದೆ. Similar order has been passed in respect of this petitioner also. He is PhD subjects. 3 ಜನ PhD students are engineering. He is undergoing undertaking guidance to 3 PhD students. Now he is transferred to physics. Impugned order is annexure. F, my lord, page 24. Same annexure F.
ಯಾವ್ದ್ರಲ್ಲಿ ಸ್ಟೇ ಕೊಡ್ಬೇಕು ನಿಮ್ಗೆ?
Annexure F has to be stayed. In WP number 25511, annexure F requires to be stayed. Annexure F. Transferred from civil engineering to the Department of Physics. In the other case, from engineering to architecture. Same college, same institution, same order.
Yeah, who appears for the other side?
They have been heard.
GV. GV.
The lordship may remember after
Let him
hearing
come.
them only. After hearing them only, stay was granted.
ಅವ್ರು ಇಲ್ಲ ಅಂದ್ರೆ ತಪ್ಪಾಗುತ್ತಲ್ವಾ? Let him come.
Yes.
Please wait.
Achint, you are not.
Kalburgi bench matter.
Yes, Mr. Kayyum.
Serial number 1. Second case.
Well, Lordships, yesterday I filed a memo admitting that the Joint Commissioner is not able to confirm why there is a difference between extract issued under Annexure A and latest
Mr.
extracts.
Kayyum, you're you're not audible. Please increase the volume.
It is 91%, 100% I have done, Your Lordship. There are several review petitions are filed. Four
Can you
more
increase
review
more?
petitions are filed.
Increase the volume. Yes, sir. Please wait. Yes.
Four more review petitions are filed by the claimant, by the petitioner herein. All those have to be clubbed, and one more case is pending before division bench on the same issue and arising out of the same accident. One more award is passed for 53 lakhs. That we have filed an appeal in the division bench here, it is pending. I'll try to get it posted immediately after vacation, and we will hear that matter. We will finish up that matter.
No, but then if the claimants are proceeding against the owner,
That we will not do it. And lastly, there are four more RPs are pending, review petitions. All may be together posted. In the meantime, there may be stay against him.
please give the review petition numbers.
Review petition numbers are 20037.
4845 4337.
Kayyum or LD? 200
37.
Sir, 200
37.
37 of what year? Which year?
2024.
2024 MLA.
And 43 also 24. 45 and
45 of 24, 43 of 24,
48 of 24.
48 of 24. Is that all?
Yeah, four more. Total 5, no? Mr. Other side advocate, Mr. Siri will be knowing. 4 he has filed. In fact, I am not served with the notice in that. One more, Your Lordship, appeal number 200848 of 2024 before division bench is pending on this. MFA number 200848 of 2024. Yesterday I filed a memo, Your Lordship, with all these details.
Barcode. Barcode number so 20037 200 sorry 20037 00043 45 48 of 2024. List this petition along with so and so numbers.
Permission of your lordship.
It is ಅದೇನು MFA pending ಇದೆ division bench ಅಲ್ಲಿ move ಮಾಡ್ಕೊಳ್ಳೋದಲ್ವಾ?
Arising out of same accident, 2 cases are pending before lordship.
So why don't you get this division bench matter decided?
It is for confirmation of DL, my lord. It is a digital copy. Everybody can verify the website also.
That is right, but if this issue is pending before the division bench, why don't you get it disposed of? So that
Please.
we can pass appropriate orders reviewing the orders passed in these appeals.
And my concern would be before your lordship is that they are filed a execution petition against me, my lord. Let him undertake before your lordship.
Yes, what is Mr. Kayyum, what is your observation about the driving licenses?
Driving license, Your Lordship, that handwritten, first of all, the Joint Commissioner himself said when computation is done, handwritten formats are not given. Annexure B is handwritten. Annexure A does not reflect this handwritten one.
Correct, but are these driving license available in the regional transport office?
They don't have, they have only these, they are not showing that, Your Lordship.
Not showing on the ring, sir. How can you?
They are only issuing these extracts. Your Lordship, my prayer is also given yesterday in the memo to issue suitable direction to the state commissioner.
ಎಲ್ಲಿ ಯಾವ RTO ನಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್?
Kalburgi.
Gulbarga. Yes, ma'am.
Then we'll direct the notice to the RTO Gulbarga.
Evidence also led before the tribunal, my lord. He is also confronted the document.
This should be clarified by
RTO itself is went in the witness box and confronted the document. Yes, it is issued by our authority. It is on one handwriting, it is issued one handwriting DL. That is they are making confused before your lordship.
But then why
it
was
is
it that
digital copy? Everybody can verify in a website, my lord.
please move the division bench matter. ಏನಾಯ್ತು?
My submission, my lord.
List these petitions after disposal of MFA 200,848 of 2024, which is pending consideration before the division bench.
My lord, execution petition and they are filed. This
No. The execution petition stay ಮಾಡ್ಕೊಳ್ಳೋದು ಹೆಂಗೆ ಅಂತ ಗೊತ್ತಿಲ್ವಾ ನಿಮಗೆ?
oversight have not filed a petition.
Serial number 2, Deepak Bharat.
My lords, the writ petitioners are challenging the Annex K. My lord, appointment of Qazi of the respondents, my lord, herein. My lords, earlier, my lord, the respondents had challenged the Qaziship of the petitioner as at page 23, my lord. My lord, A2. My lords, A2, my lord, wherein the respondent had called in question our appointment in writ petition number 84085, page 31, my lord. Page 31. Yes, Lord. And the order was passed by this honorable court in page 36, operative portion, para 5, my lord. The matter in view of these petition are allowed, directing the respondent 1 to 5 to consider the request of the petitioner as well as the respondent number 2 to 4 to appoint as a Qazi of the Afzalpur Taluka consisting of 3 circles, 90 villages coming on their under, my lord. My lord, here the direction was, my Qaziship was not, our Qaziship were not cancelled, my lord. But the writ petition was allowed, and the petitioner therein, who are the respondents herein, along with the respondents, our Qaziship also to be considered, my lord. That was questioned in writ appeal, my lord, in page 37.
2 to 4 ಯಾರು? Syed Gausuddin,
Yes, madam.
Muhammad and Liaquat.
Yes, madam.
Petitioners ಯಾರು? Riazuddin, Salahuddin, Alimuddin, Minhajuddin, Najmuddin.
Yes. Now, my lord, in this petition, they are the respondents, and as per impugned order, my lord, they have been appointed, leaving the petitioners, my lord. Whereas the direction was in page 36 clear that, my lord, along with the respondent 1 to 5, the petitioners, along with the petitioners, the respondent 2 to 4 has to be considered as a Qaziship, my lord.
Yes.
Now, as per Annex K, my lord, that has not been considered. We have left out, my lord.
So what is the order passed by this court?
My lord, this court, my lord, first, my lord, the Annex A2, page 23, the petitioner, second petitioner and father of the first petitioner was appointed as a Qazi of a particular Afzalpur, my lord, circle. And may I take to page 30, my lord, page 30. It will be relevant.
Why is this matter listed before me? I don't understand.
Lords, one of the matter was disposed by my lords, and that's why Justice Devdas. One of the connected matter was disposed of by my lordship.
In the petition 201307, 2018. Well, now the split petition does not serve a view of the order already passed by the honorable court. If there are any grievance, they have to make a separate representation.
Yeah, my grievance is that, my
Can't
lord.
hear you, Krupa Sagar Patil, ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Please, my lord.
Well, now I am audible.
ಇದ್ಯಾವ್ದು WP ಯಾವ್ದಿದು? 201294 of 2018 is filed by whom?
By the
earlier Qazis, my lord.
One of the Qazi,
Both are the Qazis. One is dead now, my lord.
Syed Gausuddin.
Gausuddin is the, my lord,
So the respondents 2 and 3 in the earlier petition.
Yes, ma'am.
The respondents 2 and 3 in the earlier petition who failed in writ appeal 50307 of 2012.
No, they have not failed, my lord. The direction was given, page 44, may kindly.
No. Writ appeal was filed by you.
Yes, lord, I have filed, challenging the learner single judge order in page 31, my lord. Whereas in page 36, learner single judge had passed the order to consider our application, our guardianship along with the petitioner in that
So
writ
please
petition.
read
below.
the findings in the writ appeal.
Yes, sir. May I take to page 40, my lord. The
No,
government of
read the last paragraph.
yes, sir.
Or
In view of
paragraph
the
number
matter.
9. Para 9.
Yes, yes. Since the learned single judge has not found fault with the appointment of appellants as Qazi, the order direction issued has to be construed as one directing consider of request of the writ petitioners for appointing them as a Qazis. Since the appointment of as a Qazis has not been quashed, appellants cannot have any grievance against the order passed by the learned single judge to consider the case of writ petitioner for the appointment of Qazis. In view of the matter, the writ appeals are disposed of. The government is directed to consider the request of the petitioner for the appointment of Qazis based on the recommendation of the principal Mohammedan residents of the area and select one or the more fit persons and appoint them as a Qazis of area. It is open for the appellant to put forth their objection, if any, before the government. It is for the government to consider the matter in the light of provisions of Section 2 of the Act. My lord, now the present petitioners have filed objections, my lord. Annexure D and D1 and D3, D4, my lord, before the appropriate authorities. My lords may kindly peruse the Annexure K, my lord, with the impugned order passed by the government of Karnataka.
Please wait. Annexure D elide.
Yes, sir. Annexure D. My lords, 66. My lord, we have filed objections, my lord, objecting the appointing respondent, my lord. May I read, my lord?
Yes. You see that after
this after this objections, my lord, the Annexure K impugned has been passed, my lord. My lord, Annexure K, page 101. My lord, in this impugned order, yes.
101.
Yes, sir.
My
my lord, the directions was given by the division bench to consider our objection as well. My lord, the government has not at all considered our objections. May I read, my lord? The order starts from 102, my lord. It will be relevant. The above petitions filed writ petitions so and so, challenging the order of Sri Syed Gausuddin Qazi of Afzalpur. The Honorable High Court of Karnataka Circuit Bench Kalburgi allowed the writ petition pass order directing the Respondent Secretary to the Government Minority Department to appoint the petitioners as Qazi of Afzalpur, consisting of 3 circles and 90 villages coming thereunder. In pursuant of the WP number and so and so, the respondent Gausuddin Qazi and another filed an appeal before the High Court of Karnataka Circuit Bench. The said appeals were disposed of by the Honorable Court with reads as under. In view of the matter, the writ appeals are disposed of the government directing to consider the so and so. No, as per the direction. As per the direction of the Honorable Court of the Karnataka Circuit Bench, then Secretary MWD requested the Deputy Commissioner Kalburgi to ascertain and communicate the recommendation of principal Mohammedan resident of area for selection of 1 or more persons as Qazis for appointment as Qazi of Afzalpur, White so and so. The respondent Syed Qazi another petition issued against the DO letter so and so issued by the Secretary of the Government Deputy Department to the Deputy Commissioner Kalburgi. The said writ petition question is rejected in Honorable Court on 10/2/26. In pursuant to the judgment of so and so, the respondent said Gausuddin and another person preferred appeal before the Honorable High Court in WA number so and so. The said appeal was disposed of as a premature. After pursuing the matter, the Deputy Commissioner by repeated reminder recently has submitted a report on 19/2/2009 stating that the jurisdictional assistant commissioner and Tahsildar of the Afzalpur Taluka, after holding a meeting with the principal Mohammedan of a area, has recommended to appoint the petitioners appear in so and so writ petitions. Riazuddin Qazi and 5 others at the rate of 2 causes in 3 circles with 90 surrounding villages. While disposing of the WP on 6/6/21, the Liaquat was earlier appointed as Qazi, or also the petitioner in the writ petition was alive. Subsequently, he expired on so and so. In absence of any provisions under law, there is no scope to consider the request of the Sri Moinuddin Qazi, brother of the deceased Sri Liaquat, to appoint Qazi in place of Sri so and so. The petitioner in the above petition submits the application dated 22/8, consider the request and appoint the Qazis of the Afzalpur as per direction of so and so. Though the Qazis Act repeal on 19/3/2003 by the Law and Parliamentary Affairs and Legislation Department so and so. After saving clause for Qazi who have been performing duties of Qazis prior to repealing Act are ever continue functioning. Thereafter, the order has been passed. But the petitioners had made an objections that has not at all been considered.
But if all the residents of the village say the petitioners could be appointed as Qazis, is it not sufficient consideration of your objection?
No, my lord. My specific, there was a direction by this honorable court that my objection has to be considered. There is not at all a reference to my objection as well in this order, impugned order, my lord. Because there, my lord, in 2 causes are enough as per the petitioner, my lord. They had filed, though there are villages are there, my lord. These number of causes are not required, and the villages have also signed its. Along with the objection filed by the petitioners here in my lord. That at least, my lord, they have to consider our objections as per the direction of this honorable court. That is nowhere the reference of the objection has been stated, and nothing has been done by the government, my lord. There was a specific direction of this honorable court, my lord.
Your brother had filed one writ petition. This is somebody by name Moinuddin.
Yes, sir, that order has been
So
confirmed.
he had filed some writ petition challenging the very same order.
Yes, my lord.
I have upheld this order dated 23/2018.
But we were not a party to that petition, my lord.
But sir, Moinuddin was your brother, sir.
No, my lord.
He was your brother.
No, he is not my brother, my lord. He is some other Qazi who has been. My lords may kindly see the cause title, my lord. And Moinuddin is late Afzal Pasha Qazi, my lord. And another second petitioner is Sayyid Gauzuddin, my lord. He is nowhere concerned to the. And we were not party made to.
Lord, this honorable court has already held, my lord, that any number of causes can be appointed. There is no any bar in that, my lord.
My only may I complete? My only request is that, my lord, as per the directions of this honorable court, at least my objection has to be considered, my lord. That has not been considered by the government. That's the main grievance, my lord.
Why should I consider this? Let the matter.
Let the government may consider our objections, my lord.
Let the
That has
matter
not.
be listed before the same court.
Yes, my lord. I will leave to the court, my lord, because
why it is posted before me.
Lord, that was not submitted by either of them, my lord. The court hearing the matter, since the earlier order was passed by this honorable court, I directed this matter has to be posted before this court, my lord. There was no submission made as such, and my lord, the honorable court.
Madam, peruse the order dated 14/11/2022. Directing the registry to list this petition before me. The reason for listing this petition before me is that I had disposed of WP number 201307 of 2018, where the order dated order dated
23. 28/3/2018.
28/3/2018 was challenged. Full stop. It is relevant to note that WP number 20
1294.
1307 of 2018 was not filed by the petitioners herein, but by a third party named Moinuddin. Full stop. Therefore, the grounds of challenge in the present writ petition are different from the grounds urged in WP number so and so. Hence, the writ petition is ordered to be listed before the appropriate court having the roster. Yes. Sorry, dictation,
First door matter, serial number
no, dictation 4 time.
First door matter, serial number 27, list number 1. Nishant Evi,
Yaru? Nishant.
Yogesh D. Naik.
Elli Yogesh. You're donning too many caps.
Respect of my lord, petitioner challenging the inquiry, my lord.
No, but how can this happen?
Please, my lord.
Vansati, there's already a.
In respect of my lord, the petitioner itself given a reply to the regarding my lord. Not only I am involved that and do other officers also involved. There is a reason, my lord, continuation of the inquiry, my lord. I have joint inquiries in held. This continuation of the inquiry, my lord, is not a fresh.
Continuation of the inquiry, how can you appoint a new inquiry officer? Does the rule allow?
No, my lord, in respect of my kindly see, my lord, my statement objections, my lord. I've stated on that point only. Regarding that, my lord.
Correct, Mr. Now there's already a report.
Please, my lord.
There's
No,
already a report submitted.
Second show cause notice is given. We have considered second show cause notice. As per the second show cause notice, my lord, here shall say that, my lord, I am not only responsible, other two officers also sent. And as per the GM tank of my lord of the honorable.
Correct. Has the discipline authority passed any order on the reply submitted to the second show cause notice?
Please, my lord. Please, my lord. Lord, reply is given, my lord, annexure. 51, my lord, page 51, 3, my lord.
Page?
51, my lord.
Where is the consideration of this reply?
Lord, thereafter, my lord, impugned order passed.
Really there. Where is the impugned order?
Lord.
Where is the order of the discipline authority?
Annexure, my lord. 58, my lord, page. Report, my lord. Inquiry.
So where is the order passed by the discipline authority?
Please. Annexure, EM.
Annexure?
Annexure, E.
Ena.
A.
Karnataka notice.
Please, my lord, second show cause notice. After inquiry, my lord, after inquiry, my lord, the second show cause report submitted by the inquiry officer, my lord. Second show cause notice issued. Along with the charge memo. Thereafter, my lord, we issue the important notice, my lord, page number, my lord. Next year, G.
If you're not ready, we'll take it some other day.
Monday, man.
Waste now, time waste now. For the respondent seeks time, list on Monday.
Please.
Monday.
Please, ma'am.
List number 2, first door matter, serial number 1.
List number 2 now.
Yeah, Srinivas Gowda.
We
are Srinivas Gowda.
Mr. Srinivas Gowda.
List number 2.
He's on the way.
She's there. Shall I-
There is no representation for the petitioner, though it is called twice in the day. Means the petition is dismissed for non-prosecution. Yes, correct. Serial number 4. SH Prashant. List number 2, serial number 4. SH.
So I was on the question that the inquiry officer has participated in the meetings of the first committee, which rejected my defenses, appointed inquiry officers, and but then therefore it is vitiated. I was taking my lords to judgment number 7, which is at page 75.
Yes.
That was a case, my lords, where a person who had rejected the show cause notice functioned as appellate authority.
Humble submissions. Request. Humble submissions. But they challenged the annexure A, my lord. The government circular has been challenged.
Government circular, government order.
The government order, sorry. The government order has been challenged. So government should be the party, my lord.
What? It is not a government order. It is order passed by the governor as disciplinary authority.
Payment has to be done by the government only.
What payment?
ಅದು ಎಲ್ಲ ಕೊಡ್ಬೇಕು benefits ಎಲ್ಲ ನಾವೇ ಕೊಡ್ಬೇಕು.
ನೀವೇನ್ರಿ
They
ಕೊಡ್ತೀರಾ?
challenge the government order, so government should be the party. So file ಹೊತ್ಕೊಂಡು ಹೋಗಿ ತಗೊಂಡು.
But the disciplinary authority is the High Court.
Disciplinary authority is the High Court. Appointing authority is His Excellency the Governor. Governor is made a party. If you want to appear for governor, nobody prevents you. Don't say that I have not made somebody a party, as if I do not know who is necessary party. And Accountant General is implicated as third respondent. State of Karnataka is fourth respondent. Department of Law and Parliamentary Affairs. Is very unfairly disturbing the flow of the arguments. That is page 75, my lords. I read to my lords this one. In that, my lords, para 9 I was reading. Keeping in view these well-settled principles, let me now advert to the fact situation in the present case. Sri S.C. Paul, as an Assistant General Manager, International Banking Department of the respondent bank, had signed the show cause notice dated 29/1/87. In the said notice, several acts of omissions and commissions said to have been committed by the petitioner had been alleged. Petitioner filed his reply denying the allegations. Assistant General Manager, not being satisfied with the explanation offered by the petitioner, had requested the disciplinary authority of the bank to initiate disciplinary inquiry proceedings against the petitioner on the same allegations made in the show cause notice. After completion of departmental inquiry proceedings, on an appeal filed by the delinquent officer, the same authority who had issued the notice in the capacity of the appellate authority decides the appeal and rejects the same. It is the apprehension of the petitioner that justice is not being done to him by the appellate authority, who had personal knowledge of the material facts of the case and had rejected his explanation. In cases like this, official bias is likely to arise when an adjudicator has previous knowledge of the material facts of the case before him by virtue of his dealing with those facts in some other capacity. In such cases, the possibility of predispositions hovering over the mind of an adjudicator for or against a party in the case before him cannot be ruled out, and there is a very possibility and probability that the administration of justice was less than fair. Further, there is a very possibility that the adjudicator who has adjudicated between the parties has not adjudicated the matter before him with an independent mind and without leaning towards one party or other. In my view, nothing is to be done which creates a doubt or suspicion in the mind of the party that there has been an improper interference in the cause of justice. When the other officer who had issued the show cause notice and who had rejected the defense of the delinquent also hears the appeal and decides it, any reasonable person will definitely entertain a reasonable apprehension that his case has not been considered on its merits and justice has not been done to him. In the case of this nature, the test is not whether in fact the judicial bias and the official bias has affected the judgment. The test is whether a litigant could reasonably apprehend that bias attributable to the appellate authority might have operated against him in the final decision. It is in this sense that it is often said that injustice must not be, justice must not only be done, but also appears to be done. in my view, there is reasonable material to come to the conclusion that there was likelihood of bias on the part of the appellate authority while deciding the delinquent official appeal. Therefore, the order made by him, in my view, is contravention of the rules of natural justice. I hasten to add that this is not a case where doctrine of necessity makes it imperative for the authority to decide. Lastly, in view of the observations made by the Supreme Court in Ratanlal Sharma versus Managing Committee, this court can entertain the plea of bias if it is not raised before the appellate authority who decided the appeal. In my Lordship Justice Venkatacharya pending the judgment in Ratanlal Sharma has not, where the allegation of bias is based on undisputed facts.
Yes.
Then it can be raised at any stage. And here, one important aspect I would like to point out to my lords is the penalty that was imposed in this case, my lords, was a penalty of stoppage of increment.
Minor penalty.
Minor penalty. Here, my lords, it is a civil death, particularly to a judicial officer if dismissal is imposed.
Yes.
He would suffer not only financially, but morally, my lords. What will be his stature in the society?
Yes.
ಎಲ್ಲ ನಮ್ಮ ಕೆಲಸಗಳೆಲ್ಲ ಹೀಗೆ ತೀರ್ಮಾನ ಮಾಡಿರೋದು ಇವರು ಅಂತ ಹೇಳಿದ್ದೆ. Should a person suffer that ignominy? Then, my lords, another aspect of the matter, as I pointed out to my lords, is that kindly see the resolution which they gave, in which the decision was taken to accept the inquiry officer's report. I think that is, my lords, at page 23 of the this one. There, my lords, not only that Justice S.R. Bandurumat participated, of course, there is a footnote that he did not this one. Then, my lords,
Paragraph number 4, there is a reference
yes, my lords.
that he did not participate.
Yes, my lord. Kindly see, my lords, they are right. I have greatest respect for all the signatories. They are all learned judges of this court. They are aware that in a quasi-judicial proceedings, reason is the heartbeat of the decision. I file enormous substantive objections in answer to the second show cause notice, which is issued to me, of course, after accepting the report. Kindly see that particular resolution. That resolution is, my lords, dated
March 2009.
That is, my lords, at page 28. 28, that is proceedings of the meeting held on 30th August 2010. This is the meeting where my reply to the second show cause notice is considered and proposed penalty of dismissal is confirmed. Kindly see this one. The committee considered the office note, reply dated 28/3/2009, submitted by the officer to the second show cause notice and the material placed on record. The committee observed that in furtherance of the inquiry report dated 16/10/2008, all charges made against so and so in DI number so and so, DI number held to be proved. In DI, the first charge was held to be proved, but the second charge was held to be not proved. The second show cause notice proposing punishment of dismissal from service was issued on 11/3/2009. The delinquent judicial officer has submitted his reply on 28/3/2009. The committee, having considered the aforesaid reply, finds no justification therein and resolved to recommend the infliction of penalty of dismissal from service. No reason, and the no consideration of my representation, and this is another ground. which they cannot improve now by filing of an affidavit, because validity of order must be decided on the basis of what is stated in the order and not a subsequent affidavit filed having become wise after the event. Then another aspect of this, my lords, I have placed on record the half-yearly seniority list of judges, that is at page 41 of my writ petition. At page 50, my lords, is the seniority list of district judges in super time scale. Serial number 2 is the petitioner.
Page number?
Page number 50, my lords. Then, my lords, the first investigating officer is Mr. A.S. Pachapure, who is at serial number 7 at page 51. Subsequent investigating officer,
serial number 51.
Serial number 7, my lords, at page 51. A.S. Pachapure.
He was the investigating officer.
He was the first investigating officer. There have been 2 successive investigating officers. What happened was that, my lords, I think first Mr. Pachapure investigated. Then, my lords, he was elevated as judge of this honorable court. Then comes Veeranna Tigadi, who is at page number 22, page 52, serial number 22. He is the second investigating officer. And one aspect of this matter which my lords may notice is that, apart, they were not only juniors. Without a formal order of the Chief Justice, Mr. Pachapure commences the investigation. That also I have said in my synopsis. And 3 days after he commences collection of material, and thereafter he places the matter before the Chief Justice. Then Chief Justice orders Registrar Vigilance may investigate. Kindly see the hurry in which a junior wants to bury the senior. My lords, after all, one question may arise, my lords. After all, he only investigated. What is the harm? Supreme Court has said, even it may not weigh with the final authority, but we cannot say how much it is. For example, my lords, in a court martial, there is what is known as one advocate member or judge member or something like that. He is also from the army. He doesn't participate in the ultimate decision making. He is like an informant or like a relator or like a legal remembrancer. Question arose before the Supreme Court. After all, he is not participating in the decision making. He can be anybody. Then, my lords, the Supreme Court said, if the advocate member is junior to the charged army officer, it would vitiate the court-martial proceedings. I have placed that also on.
Advocate member ಎಲ್ಲಿರ್ತದೆ ಜಾಗ್ ಅಂತ ಇರ್ತದೆ.
Advocate member ಅವರಿಗೆ
judge adjutant something like that, jag ಅಲ್ಲ?
Yes, my lords. I don't know what they call, because my knowledge of army law is, my lord, very poor.
They call
I appeared only for one general in one of the
judge
cases.
adjutant.
General. There I have placed the judgment on record. That also I have placed, my lord. Second is, I raised this question in the inquiry that Look, I am placing on record a notice of the first committee meeting issued to you, where to consider the question regarding my misconduct by a notice dated 10th November 2015, you have been invited for the meeting held on 14th November 2005. Therefore, you are biased. Please do not proceed with the inquiry. The inquiry officer does not even pass an order on that objection. Now, my lords, I don't question the honesty of the recording of the proceedings. But whether honest doubt can arise in my mind about the genuineness of the proceedings, I am not questioning it. But can you say how suspiciously they do? Annexure R, page 179, is the notice issued to HLDJ in the matter of meeting to be held on 14/11. Yes. Then, my lords, in page 203 of the inquiry proceedings, the inquiry proceedings are at page 201. Yes, please. 203, my lords. This is the protest memo I filed. That by a notification dated 25/11/2005, so-and-so under Judge Honorable High Court of Karnataka and Inquiring Authority under Section 4.2 of the Karnataka Departmental Inquiries Enforcement of Attendance of Witnesses, Production, Documents and Miscellaneous Provision Act, in exercise of powers specified under Section 5 of this Act. In connection, the CJO respectfully submits that the said notification, in so far as it does not specify as to in respect of which department of inquiry the authorization is issued, is void and unenforceable, as being contrary to Section 4.1 of the Act, because there were 3 inquiries against me. The rules of the game ought not to have been changed during midstream. In respect of charge sheet DI 8 of 2005, CJO submitted defense statement on 16 September 2005. This defense statement was rejected by the first administrative committee, holding it to be unsatisfactory, and the FAC decided to hold an inquiry and to appoint inquiring authority. Either in the same meeting or in the subsequent meeting, the FAC also decided that the reply dated 16 September 2005 of the CJO should be made against some subject matter of another disciplinary inquiry, and accordingly, show cause notice dated 5th October 2005 was issued to the CJO. Pursuant to decision of the FAC, the CJO was kept under suspension by order dated 5th September 2005. Representation dated 9 September of CJO to change of headquarters during the suspension was rejected by the FAC, and decision was communicated to the CJO by a letter dated 30th September 2005. Lastly, when the CJO raised the objections regarding oath that was sought to be administered to the witnesses in the inquiry, notification date 25/11/2005 has been issued, empowering the Honorable Inquiring Authority to administer oath by issuing a notification under the Act. This in all probability would also have been pursuant to a decision of the FAC. CJO praised that copies of the proceedings of all the above mentioned meetings of the FAC be ordered to be kindly made available to the CJO in the interest of justice and equity. No order is passed on this. And I don't know whether those proceedings have even now been made available.
Yes.
Anyway, my lords, I have in 3 meetings, participation of SR BJ has annulled it, and in the question of bias, percentage would not arise. Either a person is honestly biased or honestly not biased. Percentage would not apply there. Is 10% bias level ಬರೋದೇ ಇಲ್ಲ ಅದು. Then, my lords, kindly see the order of penalty, because my learned friend had a serious objection. Their party not made a party. At page 33. Registrar General ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ನರಹರಿ ನ್ಯಾಯಾಧೀಶರು ನೀಡಿರುವ ನೋಟಿಸ್, ದಟ್ ಇಸ್ ಚಾರ್ಜ್ ಶೀಟ್ಸ್. ಜಿಲ್ಲಾ ನ್ಯಾಯಾಧೀಶರು ಉತ್ತರ. ವಿಚಾರಣಾ ವರದಿ 16/10/2008 ನ್ಯಾಯಮೂರ್ತಿ ಶ್ರೀ ಸೋನ್ಸೋ. ಎರಡನೇ ನೋಟಿಸು ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ. ಎರಡನೇ ನೋಟಿಸಿಗೆ ನರಹರಿ ಸೋನ್ಸೋ ದಿನಾಂಕ ಉತ್ತರ ದಿನಾಂಕ ಸೋನ್ಸೋ. ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಇವರು ಕರ್ನಾಟಕ ಸರ್ಕಾರಕ್ಕೆ ಬರೆದಿರುವ ಪತ್ರ. ಕಾನೂನು, ನ್ಯಾಯ ಮತ್ತು ಮಾನವ ಹಕ್ಕುಗಳ ಇಲಾಖೆಗಳ ಟಿಪ್ಪಣಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ. ಪ್ರಸ್ತಾವನೆ. ಜಿ ನರಹರಿ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಲಯದ ವಿರುದ್ಧ ದೋಷಾರೋಪಣೆ ಮಾಡುವ ಮೂಲಕ ಈ ಕೆಳಕಂಡ ಆರೋಪಗಳನ್ನು ಕುರಿತು ವಿಚಾರಣೆಯನ್ನು ನಡೆಸಿತು. Then, my lords, charges are extracted. Then, my lords, at page 39, till then it is only reproduction of the charges. Last paragraph at page 39. ವಿಚಾರಣಾ ವರದಿಯ ಪ್ರತಿಯನ್ನು ಲಗತ್ತಿಸಿ ಶ್ರೀ ಜಿ ನರಹರಿ ಇವರಿಗೆ ಮೇಲೆ 4ರಲ್ಲಿ ಓದಲಾದ ದಿನಾಂಕ 11/3/2009 ಎರಡನೇ ನೋಟಿಸ್ ನೀಡಿ ವಿಚಾರಣಾ ವರದಿಯ ಬಗ್ಗೆ ಏನಾದರೂ ಹೇಳುವುದಿದ್ದಲ್ಲಿ ಹೇಳಲು ಲಿಖಿತ ಉತ್ತರ ನೀಡಲು ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಯಿತು. ಶ್ರೀ ಜಿ ನರಹರಿ ಅವರು ಮೇಲೆ 5ರಲ್ಲಿ ಓದಲಾದ ದಿನಾಂಕ 28/3/2009 ಉತ್ತರ ಸಲ್ಲಿಸಿರ್ತಾರೆ. ಸದರಿಯವರ ಉತ್ತರಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಆರೋಪಿತರ ತಮ್ಮ ವಿರುದ್ಧ ಮಾಡಿದ ಆರೋಪಗಳಿಗೆ ಸಮರ್ಥನೀಯವಾದ ಉತ್ತರಗಳನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. This is something that is not there in the resolution of the first court itself.
Yes.
What is not written there, they cannot write here. Of course, it is another matter that even what is written here does not give any reasons, except pretending to give reasons. ಮುಂದುವರೆದು ಮೇಲೆ 7ರಲ್ಲಿ ಓದಲಾದ ದಿನಾಂಕ 27/10/2010 ಸ್ವೀಕೃತವಾದ ನಗರಾಭಿವೃದ್ಧಿ, ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ವ್ಯವಹಾರಗಳ ಸಚಿವರ ಆಪ್ತ ಕಾರ್ಯದರ್ಶಿಯ ಟಿಪ್ಪಣಿ ಹಾಗೂ ಅದರೊಂದಿಗೆ ಸ್ವೀಕರಿಸಲಾದ ನರಹರಿ ಅವರ 25/10/2010 ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಿದ ನಂತರ ವಿಚಾರಣೆ ಎಲ್ಲ ಆರೋಪಗಳು ಸಾಬೀತಾಗಿದ್ದು, ವಿಚಾರಣಾ ಸಂಖ್ಯೆ 12ರಲ್ಲಿ 1ನೇ ಆರೋಪ ಸಾಬೀತಾಗಿದ್ದು, 2ನೇ ಆರೋಪ ಸಾಬೀತಾಗದಿರುವುದಿಲ್ಲ ವಿಚಾರಣೆ ವರದಿಯನ್ನು ಒಪ್ಪಿಕೊಂಡು ಈ ಮುಂದಿನಂತೆ ಆದೇಶಿಸಿದೆ. ಗರ್ತವೆತ್ತ ಕರ್ನಾಟಕ ರಾಜ್ಯಪಾಲರು ಕರ್ನಾಟಕ ನ್ಯಾಯಾಧೀಶ 8/7 ಅನ್ವಯ ವಜಾಗೊಳಿಸಿದ್ದಾರೆ.
Yes.
Another thing that happened in the inquiry, my lords, apart from these reasonings and absence of reasons, the petitioner was kept under suspension on 5/9/2005. Actually, inquiry was commenced on 10th March by issue of the first articles of charge. Second articles of charge was issued on 18/8.
Yes.
Thereafter, my lords, midway in the inquiry, on 5/9/2005, I was placed under suspension.
Yes.
That order of suspension is at page 177.
Yes.
That on 30th August 2005, the High Court, after examining relevant materials relating to the nature of charges after being satisfied that there is prima facie evidence of gross dereliction of duty against so and so. Day 1 of 2005, passed an order to place Sri G. Narhari under suspension. This is the only reason. Are they telling me that while issuing the charge sheet, we did not apply the mind?
Yes.
Suddenly, midway, why this realization? It is a clear admission to say that we have examined the material now. Then how did you subject me to inquiry and all this ignominy long before that? Anyhow, they placed me under suspension. This is on 5th September 2005. From 1/1/2006, there was salary revision.
Salary?
Revision. Law is, I may not be entitled for annual increments during the suspension period. But if there is a salary revision, I am entitled for revised subsistence allowance based on the revised salary.
Yes.
They did not pay. Then, my lords, on my representation, no decision was taken. And this suspension continued from 5th September till this penalty order was served on me on 13th April 2011. Substantial part of the inquiry was held during that period.
Yes.
I was paid subsistence allowance, which is less than my entitlement. And kindly see, my lords, what happens even after dismissal. I filed IA number 2 for an interim direction. They cannot deny me the subsidy, enhanced subsistence allowance for the period of suspension.
Yes.
Kindly direct them to pay me the revised subsistence allowance. Because even if my dismissal order is upheld, subsistence allowance has to be.
Correct.
That IA is still pending.
Yes.
Because every time the matter comes, some objection or the other is raised. Finally, out of frustration, I have to tell, all right, ಅವರು ಕೊಡೋದಿಲ್ಲ, ಹಾಗೂ ನನ್ನ ಕ್ಲೈಂಟು ಸತ್ತೋಗಿದ್ದಾನೆ, ಒಟ್ಟಿಗೆ ತೀರ್ಮಾನ ಮಾಡಿ ಅಲ್ಲ. This is the treatment. Kindly see, 2 juniors of me are appointed as investigating officers, first of whom starts investigation without an order of the Chief Justice. Then they administer oath in the confidence of a chamber. Why oath is administered in an open court? Because it is open court. In a closed chamber, he administers oath, records the statement. That is thrown at me as evidence. Then inquiry officers are appointed. There were 30 judges. Why only a person from first committee who goes there and sometimes says that I did not talk, sometimes does not say even that? Why he ought to have been appointed as inquiry officer? I am pointing this out to say that it is not a case where doctrine of necessity can be invoked. Suppose there were only 5 judges in this court, and all the 5 of them are members of the first committee. ಏನು ಮಾಡೋಕ್ಕಾಗತ್ತೆ ರೀ, ಯಾರನ್ನಾದ್ರೂ ಒಬ್ಬರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಬೇಕು, ನಾವು ಮಾಡಿದ್ದೀವಿ. ಅದು ನಾವೇನಾದ್ರು ಪ್ರೈವೇಟ್ ಆಗಿ ಹೋಗಿ ಕೇಳಿದ್ರೆ ನಿಮಗೆ ಬೆಸ್ಟ್ ಫೇವರಬಲ್ ಜಡ್ಜ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದೀವಿ, ಅದು ಬೇರೆ. ನಮಗೆ 30 ಜಡ್ಜಸ್ ಇದ್ದಾರೆ.
Yes.
They could have appointed anybody who is not a member of the first committee. Why this drama? He sat, he did not speak. Where was the need? Then, my lords, in the inquiry, oath is sought to be administered. Inquiry is adjourned. A notification is issued enabling him to administer the vote. Thousands and thousands of inquiries my lords are seeing every day as judge of this honorable court. Are those inquiries not conducted without administering vote to the, what is the difference? What is the harm caused to me? Madras High Court has held, what is the harm caused to me? Nagpur High Court has held, what is the harm caused to me? It is apparent. Then inquiry report comes. In between, I seek, now I have been suspended. My family is at Bangalore. Inquiry is being held at Bangalore. Please permit me to shift my headquarters. No. Enhance my subsistence allowance. No answer. At least first there was an answer. Then there is unreasoned dismissal. Therefore, my lords, my respectful submission is, this is a case where the inquiry ought to go, penalty ought to go on more reasons than one.
Yes.
Of course, I don't want to argue on disproportionality and all that. When it is totally illegal, there is no question of proportionality in illegality.
What are the charges against you?
Charges, my lords, I'll take my lords to that. First charge, you my lords would see DE 1 of 205.
I think the order of penalty itself will contain that.
It contains.
Let us see what are those
The
charges.
charges are, my lords. What are the charges? That is page 33. ಆರೋಪ 1. ಇವರು ಬೆಳಗಾವಿನ ಪ್ರಧಾನ ಜಿಲ್ಲಾ ಮತ್ತು ಸೆಷನ್ಸ್ ನ್ಯಾಯಾಧೀಶರಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದಾಗ ಕೋಲಾರ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಲಯದ ಬೆರಳಚ್ಚುಗಾರ್ತಿಯಾದ ಶ್ರೀಮತಿ ಸೋನ್ಸೋ ಇವರೊಂದಿಗೆ ಯಾವುದೇ ನ್ಯಾಯಯುತ ಮತ್ತು ಅಧಿಕೃತ ಕಾರಣಗಳು ಹಾಗೂ ಉದ್ದೇಶವಿಲ್ಲದೆ ಅತಿ ಹೆಚ್ಚಿನ ಸಂಖ್ಯೆಯಲ್ಲಿ ದೂರವಾಣಿ ಮೂಲಕ ಸಂವಾದಿಸಿದ್ದಾರೆ. 2. ಶ್ರೀಮತಿ ಸೋನ್ಸೋ ಇವರು ಕೋಲಾರದ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಲಯದ ಕಚೇರಿ ದೂರವಾಣಿಗೆ, ಇವರ ಮನೆ ದೂರವಾಣಿಗೆ ಮತ್ತು ಮನೆ ದೂರವಾಣಿ ಮೂಲಕ ಯಾವುದೇ ನ್ಯಾಯಯುತ ಮತ್ತು ಅಧಿಕೃತ ಕಾರಣಗಳು ಹಾಗೂ ಉದ್ದೇಶವಿಲ್ಲದೆ ಸಂವಾದ ನಡೆಸಿ ದೂರವಾಣಿಗಳನ್ನು ದುರುಪಯೋಗಪಡಿಸುವುದರೊಂದಿಗೆ ಉಲ್ಲಂಘಿಸಿದ್ದಾರೆ. 27/5/2002 31/12/2002 ಅವಧಿಯಲ್ಲಿ ಬೆಳಗಾವಿ ಪ್ರಧಾನ ಜಿಲ್ಲಾ ಮತ್ತು ಸೆಷನ್ಸ್ ನ್ಯಾಯಾಲಯದ ಕಾರ್ಯನಿರ್ವಹಿಸಿದಾಗ ತಮ್ಮ ಕಚೇರಿಯ ದೂರವಾಣಿ ಮೂಲಕ ಶ್ರೀಮತಿ ಸೋನ್ಸೋ ಅವರಿಗೆ 727 ಬಾರಿ ಸಂವಾದ ನಡೆಸಿರುವುದು ಕರೆ ಮಾಡಿ ವೇಳೆ ಕರೆಗಳ ಅವಧಿ ಇತ್ಯಾದಿಗಳನ್ನು ಗಮನಿಸಿದಾಗ ಆರೋಪಿಗಳು ಕಚೇರಿ ದೂರವಾಣಿಯನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡಿರುವುದರೊಂದಿಗೆ ಆರೋಪಿಸಿ ನ್ಯಾಯಾಂಗಾಧಿಕಾರಿ ನ್ಯಾಯಾಲಯದ ಕರ್ತವ್ಯವನ್ನು ನಿರ್ಲಕ್ಷಿಸಿ ಕೆಲಸ ಸಮಯವಂತೆ ದುರುಪಯೋಗ ಮಾಡಿಸಿಕೊಂಡಿದ್ದಾರೆ. ಕಚೇರಿ ದೂರವಾಣಿಯನ್ನು ಅನಧಿಕೃತ ಉದ್ದೇಶಗಳು ಬಳಸಕೂಡದೆಂದು ಗೊತ್ತಿದ್ದಾಗ್ಯೂ ಶ್ರೀಮತಿ ಸೋನ್ಸೋ ಅವರಿಗೆ ದೂರವಾಣಿ ಸಂವಾದ ಮನಮಾಚಲು ಸಂವಾದದ ಕರೆಗಳನ್ನು ತಮ್ಮ ಖಾಸಗೀಕರಣಗಳೆಂದು ಪ್ರಮಾಣಿಸದೆ ಸೋನ್ಸೋ ಮೇಲೆ ಓದಲಾದ ದಿನಾಂಕ ನೀಡಿದ ಉತ್ತರಗಳು ವಿಚಾರಣಾಧಿಕಾರಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಅದು ಫಸ್ಟ್ದು. ಸೆಕೆಂಡ್ ಚಾರ್ಜ್ ಶೀಟ್ದು ಪೇಜ್ 35. ಶ್ರೀ ಇವರು ಬೆಳಗಾವಿನ ಪ್ರಧಾನ ಜಿಲ್ಲಾ ಮತ್ತು ಸೆಷನ್ಸ್ ನ್ಯಾಯಾಧೀಶರ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ್ದಾಗ ಕೋಲಾರ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಶ್ರೀಮತಿ ಸೋನ್ಸೋ ಇವರು ಬೆರಳಚ್ಚುಗಾರ್ತಿಯಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ್ದರು. ಅದೇ ನ್ಯಾಯಾಲಯದ ಸೆಷನ್ಸ್ ಪ್ರಕರಣ ಶ್ರೀಮತಿ ಇವರ ಪತಿ ಹಾಗೂ ಮಾವ ಅವರ ಭಾವ ಇವರೆಲ್ಲರೂ ಆರೋಪಿಗಳಾಗಿದ್ದು ಆರೋಪಿಗಳು ಹತ್ತಿರ ಸಂಬಂಧಗಳಿಂದ ಸದರಿ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಲಯ ಗೊತ್ತಿದ್ದರೂ ಸಹ ವಿಚಾರಣೆಯ ಸಂದರ್ಭದಲ್ಲಿ ಆರೋಪಿಗಳ ಹೇಳಿಕೆಗಳನ್ನು ಇವರ ಕೈಬರಹದಲ್ಲಿ ದಾಖಲಿಸಲು ಅವಕಾಶ ನೀಡಿರುತ್ತಾರೆ ಮತ್ತು ಪ್ರಕರಣದ ವಿಚಾರಣೆ ನಡೆಸಿ ಎಲ್ಲ ಆರೋಪಿಗಳನ್ನು ದೋಷಮುಕ್ತರೆಂದು ತೀರ್ಪು ನೀಡಿ. ದಟ್ ವಾಸ್ ಒನ್ ಆಫ್ ದಿ ಯಾವುದು ಚಾರ್ಜ್ ವಾಸ್ ಮಾಸ್ ಏನು ವೈಲೆನ್ಸ್ ಇಲ್ಲ.
It's a murder charge.
Huh?
It's a murder charge.
Not the murder.
Murder charge.
Mob riot. ಯಾರು ಮರ್ಡರ್ ಆಗಿಲ್ಲ. ಮರ್ಡರ್ ಆಗಿರೋದು ನನ್ನ ಕ್ಲೈಂಟ್ ಮಾತಾ ಇದರಲ್ಲಿ, ಬೇರೆ ಯಾರು ಆಗಿಲ್ಲ. ಅದ್ರ ಮೇಲೆ ನಾವು ಇನ್ನು ಚಾರ್ಜ್ ಮಾಡೋ ಮಟ್ಟಕ್ಕೆ ಹೋಗಿಲ್ಲ ನಾವು. ಆರೋಪ 2, ಇವರ ವಿರುದ್ಧ ವಿಚಾರಣೆ ಸಂಖ್ಯೆಯನ್ನು ಪ್ರಾರಂಭಿಸಿದ ನಂತರವೂ ಈ ವಿಚಾರಣೆ ಸಾಕ್ಷಿಯಾದವರೊಂದಿಗೆ ತಮ್ಮ ಕಚೇರಿ ದೂರವಾಣಿ ಮೂಲಕ ಅಥವಾ ಕಚೇರಿ ಮನೆಗೆ ಮಧ್ಯೆ 71 ಬಾರಿ ತಮ್ಮ ಮೊಬೈಲ್ ಸಂಖ್ಯೆ ಮೂಲಕ ವಿಚಾರಣೆ ವೇಳೆ ಪರವಾಗಿ ಹೇಳಿಕೆ ನೀಡುವಂಥ ಪುಸಲಾಯಿಸುವ ಉದ್ದೇಶ ದುರುದ್ದೇಶದಿಂದ. ದಟ್ ಇಸ್ ಆಫ್ಟರ್ ಎನ್ಕ್ವೈರಿ ಕಮಿಷನ್ ಐ ಹ್ಯಾವ್ ಟಾಕ್ ಟು ಹರ್ ಟು ಗಿವ್ ಎವಿಡೆನ್ಸ್ ಇನ್ ಮೈ ಫೇವರ್ ಅಂತ. ಶ್ರೀಮತಿಯವರ ಪತಿಯಾದ ಒಂದು ಆರೋಪದ ಗಮನ ಈ ಸೆಕ್ಷನ್ಸ್ ಪ್ರಕರಣದ ಆರೋಪಿಗಳನ್ನು ಮನೆಯ ಧಾರ್ಮಿಕ ಕಾರ್ಯಗಳಿಗೆ ಆಹ್ವಾನಿಸಿ ಒಬ್ಬ ನ್ಯಾಯಾಧೀಶರ ಸಲ್ಲದ ರೀತಿಯಲ್ಲಿ ಮೂಲಕ ಇನ್ವೈಟಿಂಗ್ for a religious function at home. Recently, we have all seen the photographs of who being invited by whom. For ಅದು ಗಣಪತಿ ಪೂಜೆ ಇದೇನೆ, ಇದು ಸತ್ಯನಾರಾಯಣ ಪೂಜೆ ಅಂತ ಕಾಣುತ್ತೆ. ಶ್ರೀಮತಿ ಸೋಣಸ ಕಾಲೇಜೊಂದರಲ್ಲಿ ವ್ಯಾಸಂಗ ಮಾಡಲು ಅನುಮತಿ ಕೋರಿ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಕಾಲೇಜಿನ ಹೆಸರು ಮತ್ತು ಸ್ಥಳವನ್ನು ಖಚಿತಪಡಿಸಿಕೊಳ್ಳದೆ ಅನುಮತಿ ನೀಡುವುದರ ಮೂಲಕ ಹಾಗೂ ನ್ಯಾಯಾಲಯದ ಕಚೇರಿ ಸಮಯದಲ್ಲೇ ತರಗತಿ ನಡೆಯುವ ಕೋಲಾರದಿಂದ ಕರ್ತವ್ಯ ನಿಷ್ಠಕ್ಕೆ ಉತ್ತರಗಳನ್ನು ವಿಚಾರಿಸಬೇಕು. ಆಮೇಲೆ 3ನೇ ಚಾರ್ಜ್ ಶೀಟ್ದು ದೆನ್ ದಟ್ ಈಸ್ ಅಟ್ ಪೇಜ್ 38. ಇಲಾಖಾ ವಿಚಾರಣೆ ಜಾರಿಗೊಳಿಸಿದ ಆರೋಪಿಗಳಿಗೆ ನೀಡಿದ ಉತ್ತರದಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ವಿರುದ್ಧ ಅವಹೇಳನಕಾರಿ ಹಾಗೂ ಬೇಜವಾಬ್ದಾರಿತ ಆರೋಪಗಳನ್ನು ಮಾಡುತ್ತಾರೆ. ಇನ್ ಮೈ ರಿಪ್ಲೈ ಟು ದಿ ಚಾರ್ಜ್ ಶೀಟ್, I'll read that charge sheet. What is defamatory in that? Let me find out.
What is the, whether this lady was examined?
She was examined.
What does she say?
She says, that is, my lord, her examination is at page 205. 206. I was appointed as a typist on so and so. I was transferred as typist to principal scholar. I was basically working in the office as typist. I worked as typist in principal division Kolar for a period of -years, and thereafter I was transferred to Chintamani as a typist. I do not remember the actual date of my transfer. After I was transferred, I went and joined service in Chintamani. After reporting for duties, I might have worked in that place for about 15 days. Since I was not keeping well, I made a request to the then principal and district judge to post me to Kolar on deputation. In the same year, I was deputed to work in Kolar as a typist. The order was passed in that regard by so and so. I reported for duty at Kolar as the typist. I was working as a typist in the office as well as in the court hall. When I was called for. I do not know from what date to what date so and so worked as principal district judge. In computer section of the court, there is a telephonic connection. I do not remember the number of the telephone which is in the computer section. In my elder brother's house, there is a telephone bearing number so and so. My elder brother's name is one so and so. I have a telephone in my residence bearing number so and so. My residence is at Sugutur, Kolar Taluk. The distance between Kolar and Sugutur is about 10 kilometers. My elder brother's house is near my residence at Tugutur. I have applied for maternity from 21st for a period of 4.5 months. I had sought permission of my district judge to prosecute LLB studies. I had requested permission to prosecute my studies either at KGF or at Bangalore. In KGF, LLB course is conducted only in the day. Letter of permission signed by so and so is shown to the witness for the purpose of marking. So delinquent objects, marking is said letter on the ground that what is listed as documents in support of the charges is copy of the letter number 618 of 2005, dated 16/7/2005 of Sri Mahipal Desai, Principal District Judge. The objection of the non-consular is overruled. Along with the copy of the letter dated so and so, was issued to the witness by permitting the presenting officer to mark the said letter. In my opinion, it would not cause any prejudice to the delinquent officer. It is not a listed document and ignore ಮಾಡ್ತಾರೆ.
Yes.
He could have ordered. I permit him to, because in the CCA rules there is a provision. At the request of the disciplinary authority, inquiry officer can permit marking of additional.
Yes.
The letter of permission granted is marked as P1. Witness says she gave a representation requesting so and so to permit her to prosecute her studies. The witness states that on the same date her representation was considered by delinquent officer and letter of permission is granted to her to prosecute her education. The said letter was received by her. My husband's name is so and so, father-in-law is so and so. My brother-in-law is so and so. There was a criminal case, Dombi case. Madam, note ಮಾಡ್ಕೊಳ್ಳಿ. Dombi case against my husband, my brother-in-law, my father-in-law. I do not remember case number. I do not remember for how many years the case was going on. when so-and-so, the aforesaid criminal case was still pending. I do not remember whether such criminal case was disposed of when so-and-so was the principal and district judge. I was one of the open court typists when so-and-so was the principal. I have typed the evidence of one or two witnesses in the aforesaid criminal case recorded by the PDJ. It is true that my husband was one of the accused in the above criminal case. I do not remember whether he was arraigned as accused number 5 in this case. My father-in-law was also one of the accused. I do not remember whether he was in the said case. My brother-in-law in one Narayan Murthy, the presenting officer now requests the witness to see the original records pertaining to session case so and so. Objects for either production of those records or for marking inquiry on the ground the same is not listed along with the list of documents furnished along with the articles of charges. The objection of so and so is overruled. Now I see the original records. Accused number 5 is one Shankar so and so so and so. I do not know whether there is any against my husband or against my father-in-law. In statement of accused number 5, 313, the answers of the accused are written in my handwriting. 313 statement. The same is marked so and so. Accused 6 is my father-in-law. His also is in my handwriting. Accused so and so is my brother-in-law. Is also in this one. At the dictation of the principal type judge, I have typed the evidence of one or two witnesses. Presenting officer is following questions to witness. Have you typed the evidence on the dictation of so and so? I have typed the evidence of some of the witnesses in this case. She says that she cannot remember whether she had typed evidence of PW volume 2, PW 16. Have you typed in so and so on the dictation of the? I do not remember. In Arahalli village, there is a power grid corporation limited. The distance between Arahalli village and Suktur is about 4 to 5 kilometers. Then, my lords, they might have worked as principal there between so and so dates. I was transferred there and then, my lords. In there, sometimes I have received these calls and I have spoken to him also. May I so call up my brother who is residing at the telephone number of my brother is. I figured the telephone comes from. I do not remember how long we made to the computer section when I was working. It is true that I did take maternity leave from. It is not true to suggest that when I took maternity leave, I was in my mother's place. Witness adds that she was staying in her husband's house. It is not true to suggest that whenever Narahari used to make phone calls from Belgaum, it was to speak to me alone during that period. It is true that so and so. I do not remember when actually the said telephone was installed in my house. It may be at the end of year 2002. I do not know whether any inquiry proceedings are initiated against so and so. I do not know whether any inquiry has been held against them about the telephonic conversation. It is true that so and so the then registrar of vigilance had recorded my statement, but I do not remember the exact date of recording my statement. Now I see my statement was recorded and it is marked as Exhibit P3. After I gave statement as per Exhibit P3, I have also made an affidavit dated so and so. The said affidavit was given to so and so. After swearing to the affidavit, I have written the same to so and so. I do not know whether inquiry proceedings were initiated after my statement was recorded by so and so, the then registrar of vigilance, and I handed over the affidavit to so and so. After disciplinary proceedings initiated, he was speaking to me on the phone. I was speaking over my residential phone. I have not kept account of number of calls. It is true that he has spoken to me on telephone during so and so period. I do not remember how many calls he made during that time. She so and so did inquire about the number of calls and other matters relating to conversation. He also inquired with me about the recording of evidence at the dictation of so and so delinquent officer when he was, and also the recording of accused 5, 6, and 13. I have given my statement to so and so registrar of vigilance. The statement that was made is made on oath. I have signed this foreign statement. Though the statement was read over to me, I did not understand the same since I was upset. So and so delinquent process using and marking a foreign statement of witnesses on the ground that registrar of vigilance is not empowered to administer both. The protest of learned counsel may be considered at a later stage. It was never considered. The protest of learned counsel may be considered at a later stage. For the present foreign statement made before so and so is marked Exhibit 5. Before taking it on record, he has to decide. Yes. The entire sworn statement made before is signed by me. The signatures are marked. I gave one more sworn statement to register on the date of statement is so and so. I have signed this sworn statement at the request of President. further chief examination is postponed. Then, my lords, further again both administered in computer section of the district judge so and so, who were working at the relevant point of time. Srimati so and so, Srimati are also working as typist. I was transferred to computer section in the place of Srimati so and so. I know one Giridhar, who is brother, son of delinquent officer. The delinquent officer and his wife introduced so and so to me in their residence. He has visited my residence several times, but I cannot say how many times he actually visited me in my residence. She so and so also used to visit my brother in his residence. I am not in a position to tell the exact time when Giridhar used to come to my residence. Question: if you cannot tell me the timings when so and so used to come to, at least tell me whether he used to come in the morning, afternoon. He used to come at different times. See, so and so used to come to my brother's place at different witnesses. I had given birth to child. I used to be at home when so used to come to my residence. Before I applied for maternity, Sri so and so never came to my residence. He used to come to me to receive phone calls of Sri so and so, the delinquent officer. I do not know whether any STD booths are there in any shops in Sugutu. Sri Narendra used to ask me whether Giridhar had come to my residence. Whenever Sri so and so used to call me residence, they was not available. Myself and husband were used to attend the functions organized by Sri. I introduced my husband after he was transferred from Kolar to Belgaum. Just 2 months before Sri was transferred to Kolar to Belgaum, he had organized a function. To that function, myself and my husband were invited, and my husband had attended the function. I completed my 5 years LLB course in the month of May 2005. The witness adds that she has to complete one more paper in the first semester. I have read the decisions of the High Court and Supreme Court when I was doing 5 years LLB course. I do not remember the citations of those case laws with regard to these subjects. I have received telephone calls from so and so. I am not in a position to say how many calls. It is true that I have stated before this inquiry that so and so has recorded my statement on 2/7. I have stated he also made a statement before, but who was then registered. When did you hand over affidavit of a? I handed it over on the dated so and so, but not as per his dictation. Since the witness started crying when certain questions were posed to her, to make her control her, the recording of the evidence is deferred 5 minutes. Witness is recalled. Since the witness stated that certain answers elicited by the presiding in force, coercion, pressure, etc., Vishwanath, presenting officer, requests me to treat the witness for prosecution as a hostile witness and permit him to cross-examine her. The presenting officer is permitted to treat the witness as a hostile and is permitted to cross-examine her. The request of the president is opposed by sound. 5 is a statement. The presenting officer reads and then he goes on reading what are there in the affidavit and marks each of them. And all the suggestions
What
in
was
the
the
cross.
statement?
Yes, my lords.
What was the statement recorded by this Registrar Vigilance?
Registrar Vigilance.
The page 218, bottom paragraph.
Yes, my lords. That statements recorded. I don't think they are part of the record here.
No, but this evidence is the contents of the statements are recorded.
Are recorded. They have extracted whatever is required. That is, my lords, I was the one from September. I am working in the open. I was typing the oral evidence. Yeah, here there is nothing actually incriminating or contrary to what is stated by her in the evidence. Page 220 is one extract. Regarding this, a trial was conducted and respectively. Then, my lords, another extract. These are all about 313 statements. Page 85, my lords, is the annexure G is the statement.
No, but when were this lady and her husband invited to the house?
That was, my lords, for it is there.
Because there are two
Page
instances.
85 ಅಲ್ಲಿ,
Page?
85 ಅಲ್ಲಿ our statement ಇದೆ, sworn statement. ಅದರ ಟೈಪ್ಡ್ ಕಾಪಿ 89. Occasion. ಅಲ್ಲ ರೀ, what was the occasion? ಹೀಗೆ ಕರೆಯೋದಿಲ್ಲಲ್ಲ ಯಾರು. That was my lord's
216, there is a reference. Myself and my husband used to attend the functions organized.
their attending is not.
It was the first time that she attended.
There is no question to that regard. She was.
No, to say that the officer knew about her husband.
That is not, that function is suffering is after the acquittal.
After the acquittal.
Yes.
After the acquittal.
Yes, not during the trial.
Referred in 216 minutes. It's referred to in 216 as after acquittal, when he is transferred.
During the period of murder.
Murder case also, there is a inquiry.
Murder case ಎಲ್ಲಿದೆ?
Did he have any information?
That was ನರಹರಿ ಅವರ ಅಣ್ಣನ ಮಗಳ ಸೀಮಂತಕ್ಕೆ.
That the accused in this particular case is the husband, father-in-law, brother-in-law
Yes,
of
yes,
this
there,
lady.
there is a report, my lords. I'll read to it.
Yeah.
ಅದಿದೆ. But function ಗೆ ಹೋಗಿರೋ reference ಇರೋದು after.
Inshallah, I just wanted to see whether that could be correlated.
Yes, yes. That
Whether
is,
he knew.
he knew.
He knew that.
He knew they
accused were the.
accused in a sessions court, my lords. It's a murder case.
Murder, please, if it is a murder case, place the charge.
Yes, please, sir.
Yeah.
Yes, please. Sessions court.
Page number 2.
Sessions court is different. The moment it is sessions,
Report, sir.
don't murder because it is a
Please,
sessions
sir.
case. Please tell me where is the charge? 2?
280.
No. All I wanted to know was,
My lords, ask,
no, did the official knew that the accused in that case, whichever case,
my lords, the
Husband and-
invitation to the house is
That.
after the trial had been over and after the acquittal. And that acquittal has not been appealed.
not on that. Acquittal could be acquittal.
Acquittal
not-
is acquittal.
We are not going into that
The
question.
question is not, they could have simply charged. If they wanted to, this one. You have written this judgment dishonestly.
That is not at all the charge.
That is not the charge. And my lords, what is that evidence? 313 statement. In fact, inquiry ಆಗೋದು, because I defended, I know what has happened. ಎಲ್ಲಾರು ಕೆಲವು 313 statements are not recorded in the handwriting of ನರಹರಿ. ಯಾವ district judge ತನ್ನ ಕೈಯಲ್ಲಿ ಬರೀತಾರೆ 313? 313 has been reduced to a formality.
61/91.
Yes.
It is not substantive evidence. Only thing is, if a question has not been put to the accused on the evidence that has come on record in 313, and that circumstance is taken by the court to convict him, and if that has caused prejudice to the accused, then only 313.
We're not at all on that.
Yes.
Question is,
Yes.
if he knew,
Yes, ma'am.
if he knew
Yes.
that the accused in this particular criminal case
There is no
the
evidence
husband,
there.
father-in-law, brother-in-law of the stenographer
That
who
there
was
is no.
involved in taking dictation of the evidence.
ಅದು ಆ ಥರದ್ದು ಯಾವುದು ಎವಿಡೆನ್ಸ್?
ಅದನ್ನ ಕೇಳಿದ್ ನಾನು.
ಅದೇ ಯಾವುದು? No, my lords. When the enquiry is fully vitiated by recording sworn statements at the time of investigation, then the question of looking into all that would not arise. But my lords want to be, my lords, whether there is anything immoral done by the judicial officer, my lords would, I am bound to answer it. I am answering it. No, my lords, I will straight away take my lords to what I have stated in my synopsis. Now, my lords, page 1, I read out what are the charges. That is not clear. Seniority is the second issue that I have mentioned at page 2.
Yes.
Third is, my lords, charge memo is issued on the basis of investigation form submitted by statements obtained on oath by CASP, who is listed as witness number 1 in support of the charges. DI 8 of 2005 dated is issued on the basis of investigation reports submitted by ASP and VGT, whose names are shown as witnesses so and so. In support of the charges at page 160 and the statements obtained by them on oath, and the third set of disciplinary proceedings was initiated solely on the basis of say of VGT, who is listed as sole witness for charge at so and so. It is specific case of the petitioner that ASP and VGT were junior to him. Then I refer to the paragraph and page number in the writ petition. Para 2, page 7. That ASP started investigation on 23/1/2003, even without order of Chief Justice, which came only on 29/1/2003. That the investigating officers recorded sworn statements, which in law could not have been done, and that no proceedings could have been initiated on the basis of such investigation reports submitted by 2 juniors, as their investigations would be perverse, partisan, and biased, since their career interests were in conflict with the career interest of the petitioner. High Court in its reply statement at page 16, para 16, page 25, admits the position of seniority of the petitioner over investigating officer. This without anything more vitiates. There is more than 3 judgments of the Supreme Court with para number, have derived certain dates and events. An anonymous complaint, C/65, is received by the Registrar of Vigilance on 23/1. The Registrar of Vigilance commences the investigation. He admits having commenced the investigation, which he says has inquiry either on 23rd or 24th January, and at page 258 having commenced the inquiry on 23rd June itself in his cross-examination at PW4. 29/1/2003, F-bar 77 at page 80, on the basis of the report submitted by the Registrar of Vigilance and the investigation already done by him, the Chief Justice orders that Registrar of Vigilance to inquire and discreetly report. This by a person who was junior to the petitioner without order of the competent authority is without jurisdiction. Show cause notice issued to the petitioner 14/1/2003. All matters pertaining to disciplinary proceedings against district judges super time scale from the stage of decision to initiate disciplinary proceedings till the stage of imposition of penalty are decided by the ACN, consisting of Honorable the Chief Justice and 4 judges of the High Court. It is admitted by the High Court at para 16, page 25 of the statement of objections that High Court is the disciplinary authority for the petitioner, and only ACN 1 as well as the Chief Justice will exercise their power. 9/2004, petitioner replied pointing out that he has never abandoned work and that he was making phone calls in connection with certain problems being faced by his nephew P. Giridhar. He also sent and enclosed 2 affidavits of one Srimati Padmamma and another so-and-so. ACN rejects explanation dated 9/2004 submitted with the petitioner and orders initiation of disciplinary proceedings. The 10.3, charge memo is issued pursuant to the decision of ACN 1. Petitioner replies. If the ACN rejects the defense statement and appoints HLDJ as inquiry officer. 5/5/2005, HLDJ takes up the inquiry. 8/7, pre-recorded and summons issued. 16/8, on superannuation of AMFJ, Honorable HLDJ become member of ACN 1. AC1 decides to initiate disciplinary against the petitioner in DI 8. Charge memo issued to the petitioner referring to direction of ACN 1 without disclosing the date. Petitioner submits defense statement. Then, my lords, the petitioner is placed under suspension that I have taken, my lords, through that order. 14/11/2005, AC1 meets and rejects the defense statement dated submitted by the petitioner and decides to appoint HLDJ as inquiry officer. At page 24 of the statement of objections, the High Court has not denied participation of HLDJ in ACN 1 meeting held on 14/11/2005, and even while denying his participation in the meetings on 27/9/76 and 23. Then, my lords, inquiry officer had sought to administer oath, that is on 11/1/2005. Inquiry adjourned to 24.
We'll have it on Monday.
Monday I will be
Jana
out.
ಕಾಯ್ತಿದ್ದಾರೆ.
Monday I will be out of station, Monday, Tuesday, because there is some death of a close relation with the
Tuesday?
family. This one.
Tuesday.
2 ದಿನ ನಾನು ಅಲ್ಲಿ ಹೊರಗಡೆ ಇರ್ಬೇಕಾಗುತ್ತೆ.
ಆಯ್ತು, ಮುಗಿಸಿ.
That is why another for 10 minutes I will complete, because I will not read the judgments and because judgments are there, paragraphs are there, I will conclude. Then on 24/11, after hearing the counsels on both sides, inquiry adjourned to 25th to enable the presenting officer to produce clarifications. 25/11, High Court authorized HLDJ under section 4(2) of the departmental inquiries to exercise the powers specified under section 5. Here, this I think, my lords, is not backed by decision of ACM. That is for my lords to check. 5:10, show cause notice issued with taking objection to the contents of the statement of defense. 29:10, petitioner replies denying allegations and inviting the attention of disseminate two decisions on one of which is held that no disciplinary proceedings can be initiated on the basis of the inquiry furnished to the charge sheet. Others setting down high standards to be observed by the Chief Justice or administrative judge in discharging administrative functions. That is a case which went from our High Court minutes regarding the appointments made. That is H.C. Putswamy. ACN rejects the reply submitted by the petitioner and resolves to initiate disciplinary procedure. The date of the decision is not forthcoming. Then, my lords, 5:12, protesting against notification by which HLDJ was authorized. Then, my lords, I rate what are there. No order was passed by the learned IO on copies being sought from the ACN 1. The inquiry has rejected proceeded with the inquiry. Charge memo 12 is issued. Submit the decision statement. Then, my lords, Y is another charge sheet appointing inquiry officer. H is another notice. Then show cause establishes the fact that decision as to why action should not be initiated against him with regard to aforesaid matters resides the decision of ACN 1. Then, my lords, the inquiry is concluded. My lords may straight away come to page 13. Inquiry is concluded on 2/6/2007. Report is submitted 1 year, 4.5 months thereafter on 16/10/2008. Then, my lords, the ACN 1 takes 5 months to accept the report and issue me the second notice. These, my lords, I have raised 2 grounds. Here, apart from Sachidananda that I have raised about the bias, I have placed on record Ranjit Thakur judgment. Then, my lords, Justice P.D. Dirkar. Yes. Where, my lords, the judgments. Inquiry and post-decisional hearing is no substitute for pre-decisional hearing. This is again 2 judgments rendered by our High Court. In that, relevant Supreme Court judgments have been referred. In the instant case, prejudice specifically pleaded at 334, 335, paras 4 to 7, which has not even been adverted to by the ACN 1 and the full court in R2/35 and R3/36. Second show cause notice categorically stating that the High Court has accepted the report, issued notice of petitioner replied, without assigning any reason, rejects the cause shown by the petitioner. Full court resolves to confirm the proposed event. Here, my lords, it was a proposal. There was no need to change the proposal. We confirm earlier it was decided. A proposal is a proposal. Then, what is impugned penalty? The Swarnamba BR is the last judgment I have cited, where our High Court judgment is under Rule 98 and 118 of the KCSR. The subsistence allowance is payable on revised pay if the pay revision is given from a date anterior to date of suspension. Yes, that is it. I conclude, my lords, if there is anything I would.
Yes, for Monday.
Yes, please.
Monday.
Because this, I did not expect, my lords, Monday and Tuesday I have to be out of.
ಆಯ್ತು. So primarily it is about bias.
Primarily bias, my lords, because that is on documentary basis, I will say. No further examination of the disputed facts would have. In fact, my lords, in one judgment which Supreme Court rendered, they set aside the judgment of the High Court only on the ground that for this reason, this particular judge should not have sat in judgment in this case. Even if the most unbiased judge, even if he would have rendered the same judgment, that is no justification to sustain this judgment. A totally unbiased man might have come to the same conclusions, but that is no reason for me to uphold this judgment, and that is what the Supreme Court is.
Covers together is talking to typist.
There could be a bias in the procedure adopted.
Bias is in procedure, bias in, because
In the decision making, whether there was bias is the question.
in the decision making, whether there is a bias or not, findings are, in findings there is a bias. Once there is a finding in the bias, when there is a bias in findings, because inquiry officer who is a party to ACN 1, who is a party to rejecting my replies to this one, who is a party to say issue charge memo, if he writes the judgment, judgment is inquiry officer's report.
That is right.
Thereafter it is only accepting. That accepting is also without assigning any reason. It should fail on two reasons: absence of reasons and presence of bias.
Yes.
Test for bias is clear agide. What is not what the judge thinks. Judge may think
Correct,
that
correct.
what I would think as an uninformed man. None as a bitbidi, because I am advocate. What anybody in this hall would think. They are not concerned in the case.
Yes, Monday.
Yes, please.
Thank you.
ಯಾರ್ದು ಇವ್ರದ್ದು ಯಾರ್ದು ಇತ್ತಲ್ಲ, ಅರವಿಂದ್ ಕಾಮತ್ ಅವ್ರು ಏನು ಹೇಳಿದ್ರು, ಯಾವ್ದು ಕೊಡಿ.
Food matter for price serial number 1, Vijay Kumar.
The petitioner is working as assistant engineer in BBMP Malad. While he was working at Chamarajanagar subdivision, they have executed certain development works in the Rajashankar playground. But as per the estimate, Malad, the works were executed. Quality control department has also certified the works.
What does the inspectorate say?
You may kindly see the page 45, Malad.
Page 45.
Yes, ma'am. This is the quality control department has certified.
What does the electrical inspectorate say?
Regarding
some electrocution, tane idu.
No. This is regarding fall of the gate, MS gate in the playground. The maintenance department, the work on completion has been entrusted to the maintenance department. But the petitioner had completed the work in 2023, and he has been transferred. The maintenance department having failed to maintain it properly, the gate has collapsed due to lack of lubrication and rusting. Now, the assistant engineer is being placed under suspension, whereas the executive engineer and assistant executive engineer are the one who have executed the work. I am only a supervisory officer. Your may kindly see page 47. ಆಟದ ಮೈದಾನದ ಗೇಟ್ ಅನ್ನು ಅಳವಡಿಸಿ ಸುಮಾರು 2 ವರ್ಷಗಳು ಕಳೆದಿದ್ದು, ಸದರಿ ಆಟದ ಮೈದಾನದ ಗೇಟ್ ಜಾಗವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು, ಗೇಟ್ ಸಾಮರ್ಥ್ಯಕ್ಕೆ ತಕ್ಕಂತೆ ಕೀಲು ಅಳವಡಿಸಿಲ್ಲದೆ ಇರುವುದು, ನಿರ್ವಹಣೆ ಕೊರತೆಯಿಂದ ಅದಕ್ಕೆ ಕೀಲು ಲೂಬ್ರಿಕೇಶನ್ ಮಾಡಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಕೀಲು ತುಕ್ಕು ಹಿಡಿದು ದಿನಾಂಕ 29.
What are you?
I am assistant engineer.
You are the one who is supposed to.
No, after execution of the work, I have been transferred, and it is the work has been entrusted to maintenance department.
Correct.
Maintenance department has to look into it. For about 2 years back only, I had executed the work. Now I am the only one who has been placed under suspension.
They also take.
My only submission is I was never there. The maintenance department has to take care of it. It is not me. I am not working there at all. In 2000. In fact, I made I was working in Chamarajpet division. I was given additional work. And the person who was on regular basis, who has executed the work, that is at page 20,
Yes, Barcode. The petitioner has challenged an order of suspension.
Let the notice go, my lord. I will.
ಇಲ್ಲ. ಇಂಥ ಕೇಸಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ಟರೆ ತಪ್ಪಾಗುತ್ತೆ. The petitioner has challenged an order of suspension dated 23/9/2024, passed by the respondent number 3. The prime contention urged in support of the writ petition is that after the execution of the works, the Quality Control Division had certified the works on 15/3/2022, and the payment relating to the work was already sanctioned and released. Full stop.
Second bill is not released. Not the second bill is yet to be released, my lord.
First bill ಆಗಿದೆಯಾ?
ಅಷ್ಟೇ.
First and part bill ಅಂತ ಹೇಳ್ಬಿಡಿ.
Part bill.
First and part bill was sanctioned and released.
That was released by one Shantala, my lord.
Stop. The petitioner contends that after the completion of the work, it was handed over to the maintenance department. However, due to lack of proper maintenance of the MS gate by properly lubricating it, the gate that was rusted fell on a boy in the playground on 22/9/2024, leading to his death. Full stop. It is contended that the death was not due to any inaction on the part of the petitioner, but was solely due to the failure on the part of the maintenance department in not ensuring that the hinges attached to the gate are properly lubricated. Full stop. It is also contended that the petitioner is only an assistant engineer, while his superiors, namely the assistant executive engineer and the executive engineer, were not proceeded against departmentally. Full stop. Consider submissions made by the learned counsel for the petitioner. I have also perused the materials enclosed along with the writ petition. Next para. The order of suspension
Page 47.
comma, is in the light of the fact the petitioner was in charge of certain maintenance works.
Not
Sorry,
maintenance work.
in charge of construction of a, ಏನಿದು?
The development of the playground. my lord.
Was in charge of development of a playground. And therefore, he was bound to ensure that the gates are fixed with proper hinges. However, the hinges that were fixed, fastened to the gates had rusted, and on 22/9/2024 fell on a boy who was playing in the ground, resulting to his death. Full stop. It is not in dispute that the petitioner was the person responsible for the execution of the works, and therefore the prima facie finding of the respondents that the petitioner was responsible, cannot be doubted. Even otherwise, an order of suspension cannot be treated as an order of punishment, and it does not affect his service in any matter whatsoever. Therefore, there is no need to interfere with the impugned order of suspension. Hence, the petition lacks merit and is dismissed.
I may be permitted to make necessary representation to the authorities submitting my explanation, my lord.
It is always
Seeking
open.
review of the order of
It
suspension.
is always open for the petitioner to file necessary representation for review of the order if the law permits, please. Yes. We also have to respect public perception, sir.
Blood. That is not the issue, my lord. The issue is,
We
my lord,
also have to respect public.
the issue is, my lord, whether the person who is, my lord, has to be punished. He has been,
Point here, the inquiry, who is responsible?
let me
Point
submit
out.
the explanation to the authorities to show as to who is
Right.
responsible
In
for
the
it.
inquiry, you please point out who is responsible, then they will take action against the person responsible.
And that too, my lord, after almost 6 months, I have not been working. And the lubrication and other works have to be done by the maintenance department.
Error
I
was
was
the
not
gate
there.
with the answer.
I was not there.
No, within 2 years, if a gate gets separated from the hinges, we can imagine what kind of work that is executed.
Please.
40%, 30%, 60%. Just imagine our children, you and my children, going into that playground. Please think about it.
Please.
ಯಾರೋ ಮಗು ಅಂತ ನಾವು ಅನ್ಕೊಳಂಗಿಲ್ಲ, ನಮ್ಮ ಮಗು ಅಂತ ನಾವು ಅನ್ಕೋಬೇಕು.
My humble submission is that
Madam, it is dismissed, madam, sorry.
that I have come to know. I went to give that money and I was waiting.
Don't worry, it is
waiting for
dismissed
call.
already. Madam, it is dismissed. Petition is
No way to revive that fund, ma'am.
no way to revive. Yet there is a way, follow that way, file an application.
That he did not pay. I only went and pay. I can give
Madam,
it.
you said in the morning that Mr. Srinivas Gowda is going to pay and come.
Srinivas
You got
Gowda
it
is
passed over.
I
At
will
4:30 you are coming and say, no, sorry.
So, this I should not give it now, no?
This, if you already paid it, that's
Already
okay.
Paid. Today, I only went and paid. He didn't pay.
Correct, madam, that is for the last order.
I
That is over.
contested.
That is over. If you want to get your petition revived, file an application.
He could not appear.
Lord, very short point involved here. What is under challenge is the recommendation.
She is there.
My lord.
Lord, what was under challenge was the recommendation made by the internal complaints committee. The writ petitioner before your lordship was the complainant. Lord, ಇದು ಕೊಟ್ರಾ? Synopsis ಕೊಟ್ರಾ? ಇಲ್ಲಿ ಇಟ್ಟಿದೆ. ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ ಇಟ್ಟಿದೆ. One second. Lord, I prepared a brief synopsis. ಇಲ್ಲ ಮೇಲೆ ಇಟ್ಟಿದೆ.
You can keep it simple and short. She says that she is the complainant. The ICC has made some observations against her.
There is a remedy against.
So
No,
what is the remedy?
ICC makes two recommendations. One, it holds that the offense, the allegations against the respondent number 6 is not proved.
Yes.
That is under, it falls under section
Yes.
13(1). Then it makes one more recommendation that it comes to a conclusion that the complaint is false. And it was filed to cause harassment to R6. Therefore, it directs initiation of proceedings against her.
No, let
So
us see.
primarily there are two proceedings.
Pasha.
Please have a look at section. There is, the remedies are available at 18. If you have a look at 18.
Now let us see what the ICC can,
Yes.
what kind of report can the ICC submit?
Yes. What they please have a look at 13.
Yes.
Inquiry report. On the completion of an inquiry under this act, the internal committee or the local committee, as the case may be, shall provide a report of its finding to the employer, as the case may be, the district's office, within a period of 10 days from the date of completion of the inquiry, and such reports shall be made available to the concerned parties. Where the internal committee or the local committee, as the case may be, arrives at the conclusion that the allegation against the respondent has not been proved, it shall recommend to the employer and the district officer that no action is required to be taken. So the first part of the ICC report falls here, 13(2). Where the internal committee, or as the case may be, arrives at the conclusion the allegation has been proved. We can skip this minute because this is not what has happened.
Yes.
Then can we now move to 14? Punishment for false or malicious complaint and false evidence. Where the internal committee or the local committee, as the case may be, arrives at a conclusion that the allegation against the respondent is malicious, or the aggrieved woman or any other person making the complaint has made the complaint knowing it to be false, or the aggrieved woman or any other person making the complaint has produced any forged or misleading document, it may recommend to the employer or the district officer, as the case may be, to take action against the woman or the person who has made the complaint under subsection 1 of subsection 2 of section 9, as the case may be, in accordance with the provisions of the service rules applicable to her or him, or where no such service rules exist, in such manner as may be prescribed. So internals committee made two recommendations. One, it said the allegation R6 is not proved. Then it said it was a false complaint. Now, as against this, now, your lordship, now have a look at 18. 18 is the remedy. Appeal. Any person aggrieved from the recommendations made under subsection 2 of section 13 or under clause 1 or 2 of subsection 3 of section 13 or subsection 1 or subsection 2 of 14, where the present writ petitioner would fall, or section 17, or non-implementation of such recommendation, may prefer an appeal to the court or tribunal in accordance with the provisions of the service rules applicable to the said person, or where no such service rules exist, then without prejudice to the provisions contained in any other law for the time being in force, the person aggrieved may prefer an appeal in such manner as may be. The provisions of the CCS conduct rules have been amended to the recommendation made under 14.2 is treated as a misconduct. Lord, now at this stage, would your lordship take up the synopsis that we have filed? Kotra, sir, please.
Yes.
Citations. Citations.
No, citations quoted.
Lord, that is synoptic notice is citations. Supreme Court judgments also. Covering the issue.
Lord, there is one Supreme Court decision directly on this matter. Would your lordship take up the very first judgment? Medha Kotwal. Para 2 of that, page 2, para 2. Notice has been issued to several parties, including. Notice had been issued.
Page 2, para 2.
Yes, page 2, para. Ink page 2, para 2
Yes.
of Medha Kotwal judgment.
Yes.
Notice had been issued to several parties, including governments concerned, and on getting appropriate response from then and now, after hearing the learned Attorney General for Union of India, we direct as follows. Complaint committee, as envisaged in Supreme Court in its judgment in Vishaka case, will be deemed to be an inquiry authority for the purpose of Central Civil Rules, Conduct Rules 1964, and the report of the complaints committee shall be deemed to be an inquiry report under CCS rules. Thereafter, the disciplining authority will act on the report in accordance with the rules. Similar amendments shall also be carried out in so. So, idanna madidare. And then, if your lordships will see the Medha Kotwal, there is in the second judgment, beginning at page number 3, would your lordship straight away turn to 18? Mark Madiva. Page 8, my lord. Page 8, para 5.
Yes.
Disciplinary action. Where such conduct amounts to misconduct in employment as defined by the relevant service rules, appropriate disciplinary action should be initiated by the employer in accordance with those rules.
Yes.
Would your lordship have the Central Civil Service rules?
Central CCS.
So in 2014, a new section 3C was added to the Central Civil Service Conduct Rules. Central Civil Service Conduct Rules, if you lordship.
Can read. No, we don't have that. This is 2005 edition.
May I read for your lordship? 3C, prohibition of sexual harassment of working women. No government servant shall indulge in any act of sexual harassment of any human place. Every government servant who is in charge of a workplace shall take appropriate steps on such. Relevant. And then they define what is the following circumstances. So it that is to define the misconduct. The remedy. The appellate remedy is under 14, Rule 14. Rule 14 could be the same even in the old one.
No, if it is treated as a misconduct, then obviously the appellate remedy will be Rule 14.
Yes. Yes.
If this is treated as a misconduct,
Yes.
pre-penal misconduct.
Yes. Yes. No. ಅಲ್ಲ
ಓದಿ ಅದು ಇನ್ನೊಂದ್ಸತಿ ಓದಿ.
ಅದನ್ನೇ ಮಿಸ್ಕಾಂಡಕ್ಟ್ ಅಂತ ಅದ್ರಲ್ಲಿ 18 ಅಲ್ಲಿ section 18 of the POSH Act says that it will have to be dealt with as per the service
It
rules.
will be dealt with as per the service rules.
Making out a false case becomes a misconduct.
Is it a misconduct under this conduct rules?
Yes, yes.
ಓದಿ.
Yes. 3C ಅಲ್ಲ ಅದರಲ್ಲಿ ಸಾಹೇಬ್ರು ಇದನ್ನ ಮೇಕಿಂಗ್ ಎ ಫಾಲ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಅದು ಅದೆಲ್ಲ ಬರುತ್ತೆ.
14 itself. 14 of the POSH Act itself. It says.
Hello, section 18 itself says that an offense under 14(2) becomes a misconduct. 14(2) is lodging a false complaint. No, there is one judgment of the Honorable Delhi High Court where my Lordship Justice Kameshwar, as he then was, straight away, my Lord, on the same point, similar facts. Would your Lordship, in my compilation, take up page 18, division bench of the Honorable Delhi High Court. Please have a look at what the issues that write the first para, page 18. The issue which needs to be decided by this common order is the one which has been raised by the respondents on the maintainability of the writ petition stroke appeal, more particularly in of the objection taken by stating that the remedy of appeal under 18 of the POSH Act is not available to the petitioner as the action on the inquiry report submitted by the central level internal complaints committee needs to be considered and decided as per the central civil rules, CCA rules 1965. And then para 3. The plea of maintainability on behalf of the respondent can be seen from the short affidavit filed by the respondent in WP so wherein a reference has been made to rules of 1965 to state that in terms thereof the DA is to consider the representation made by the petitioner against the findings of the inquiry authority CLCC. Shri so-and-so, Additional Solicitor General appearing for the Union of India will submit that the misconduct relatable to sexual harassment being a misconduct under the service rules of 1965, the proceedings of CLICC are to be considered as the proceedings for the purpose of Rule 14 of the Rules 1965, and hence it is the procedure which is laid down under the Rules of 1965 which needs to be followed in as much as after the submission of the inquiry report, Rule 15 of the 1965 rules get attracted in a manner that ICC report was given to the petitioner for him to file his representation before the DA within 15 days. Ultimately, that submission is upheld. May now take your Lordship directly to para 46, where the Honorable Bench has discussed the law. May read from para 44 at page 29. Page 29, para 44, if you not.
Just read the relevant portion that is in.
Para 44 in the one more para. Suffice to state that Supreme Court in Dr. Malik did state that what has been noted above, but at the same time, the Supreme Court did not consider the issue in the context of what shall be the effect of provisions of rules of 1965 on section 18(1) of the POSH Act. Even otherwise, the provision of remedy of appeal, if seen in the context of 1965 rules under Rule 15(2) of the rules, the petitioner has a remedy to challenge the findings of ICC before the DA, which is not available under 2013 Act. Therefore, it is in such a context that section 18 contemplates a remedy of appeal in accordance with the provisions of the service rules. So it follows that 65 rules having provided the remedy to challenge the findings of the ICC, division bench in Dr. P.S. so-and-so held that the said requirement more than subserves the purpose of appeal under section 18. At this stage, it is also necessary to highlight submission of Mr. Rao that the remedy of an appeal before a court or tribunal as per the service rules stipulated under 18 of the Act has been provided with an intention to provide remedy outside the administrative process to an independent authority who, given the nature of misconduct, shall have to consider the issue fairly. Though the said submission of Mr. Rao looks appealing on a first blush, but on a deeper consideration, when remedy to challenge is provided in the service rules, within bracket representation, reading a further remedy of court/tribunal shall have the effect of providing a remedy of challenge in finding outside the realm of administrative process to a court or tribunal, which shall make Rule 15 of the rules framed under the proviso to Article 309 nugatory. In fact, there would be a conflict between Rule 15 and Section 18 of the Act, providing two remedies against the findings of ICC. So it follows that both the provisions must be construed harmoniously so that one provision does not defeat the other. Meaningfully read, it has to be construed that in an eventuality that the committee returns the finding against a government servant, the representation against those findings made by a charged officer as per the procedure laid down in Rule 15 thereof shall satisfy the remedy akin to appeal under Section 18 of the Act, which is applicable only where the rules concerned specifically prescribe court or tribunal as a remedy for filing appeal against the finding stroke recommendation made by the committee in a given case, or where there are no rules, the appeal may be preferred in such manner as may be prescribed. In other words, rules being in existence providing the remedy to challenge the findings recommendation of the ICC in the form of representation to the DA by harmoniously construing Section 18 of the POSH Act, which specifically provided that an aggrieved person may prefer an appeal before a court or tribunal in accordance with the provision of service rule. It must be held in cases like the present one, where procedure of representation against the finding is provided under rules of 1965. The remedy to challenge the findings recommendation shall surely lie before the DA as a higher and independent authority and not as a remedy of appeal under Section 18 of the Act. Therefore, my lord, a representation will have to be given.
Yes, madam. ದಯವಿಟ್ಟು ಇದನ್ನ ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಜಜ್ಮೆಂಟ್
ಕೊಟ್ಟಿದ್ದೀವಿ.
My lord, may I submit, my lord?
ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್.
My lord, Medha Kotwal, as a Land Council referred the Medha Kotwal judgment, and it was in 2012, my lord. And the POSH Act came into force in 2013, my lord.
Yes.
Though the above judgment, the Honorable Apex Court is deemed to be an inquiry report under rules, it is silent on appeal under Section 18 of the POSH Act, my lord.
Yes.
Further, my lord, the Kajan Singh case and other cases referred by are the cases referred by the perpetrator and not by the aggrieved woman, my lord. And it is not applicable to me, my lord. Further, my lord, the Kajan Singh judgment is challenged in the Honorable Apex Court, wide SLPC number 12397/2024, my lord.
What has happened to the before the Supreme Court?
My lord, wide its order dated 27/5/24, Honorable Apex Court held that any decision taken on the judgment of Honorable High Court of Delhi is subject to outcome of the said SLP. Further, my lord, if my lord permits, I will read the Rule 22 of CCA rules, my lord.
Yes. CCA rules ಕೊಡಿಲ್ಲ. ಕೊಡಿಲ್ಲ ಇಸ್ಕೊಳ್ಳಿ. Rule 20 is it?
Rule 22, my lord, appeals. CCA rules, my lord.
ಕೊಡ್ರಿ ಅದೇ ಕೊಡ್ರಿ. Yes.
Orders against which no appeal lies.
ಅಲ್ಲ ಸಾಹೇಬ್ ಇದೆ ಇದೆಯಲ್ಲ.
Yes, please go on.
My lord, Rule 22, Sub-Rule 3, my lord. Any order passed by the inquiry authority in the course of an inquiry under Rule 14, my lord. Further, my lord, Rule 23, orders against which appeal lies. It classifies, my lord. Shall I read, my lord?
Yes, yes.
An order of suspension made or deemed to have been made under Rule 10. An order imposing of the penalty specified in Rule 11 were made by the disciplinary authority or by any appellate or revising authority. An order enhancing any penalty imposed under Rule 11. An order which denies or varies to his disadvantages his pay, allowances, pension, or other conditions of service as regulated by rules or by agreement, or interprets to his disadvantage the provision of any such rule or agreement. An order stopping him at the efficiency bar in the time scale of pay on the ground of his unfitness to cross the bar, reverting him while officiating in a higher service grade or post to a lower service grade or post otherwise than as a penalty, reducing or withholding the pension or denying the maximum pension admissible to him under the rules, determining the subsistence and other allowances to be paid to him for the period of suspension or for the period during which he is deemed to be under suspension or for any portion thereof, determining his pay and allowance for the period of suspension. My lord, in the whole Rule 22 and 23, there is no provision to appeal for the ICC report, my lord.
No,
Hence, my lord.
No, if it is
My lord?
treated as a misconduct.
Yes, my lord.
Does it provide for an appeal? Which is the provision?
Those are all orders, my lord. Here we are only dealing with recommendation. Those are all orders. This is
Yes,
only
my
a
lord,
recommendation.
That is right. Even if it's a recommendation,
It is not an order.
14, section 14 makes a recommendation.
Yes.
If that is so, where does the appeal lie? 15.
Under 15,
15
she
of
has
what?
to give a representation. That will be treated as an appeal.
Which section 15?
Allah, rule.
Rule 15 of the KCC, CCA rules.
Yes,
CCA. Yeah, representation.
my lord,
Please wait. Yes. Yes, what is this representation?
It's like once the copy of the ICC recommendations are given, the aggrieved party has got a right to file a representation. That will be treated like an appeal.
How is that?
That's what the law is. That is the law.
No, but that can't be an appeal is what I am trying to tell you. It can't be an appeal.
Allah, that giving of the representation is treated like an appeal.
How?
That is what the law contemplates.
No. It can't be treated as an appeal.
No, that's how the service rules are contemplated.
No. It should be.
That is the remedy which is provided.
No. The ICC report is final.
No, it is a recommendation.
Final. It is final so far as the ICC is concerned.
Yes.
Correct. Now the report has to be, the representation has to be filed before whom?
The DA.
How?
Yes, because that is the authority which will decide whether to accept the recommendation or not. The ICC is only an inquiry committee. They don't decide finally whether the aggrieved party has to be punished or not.
Yes.
Please have a look at I have described this, my lord, in detail. Would your lordship take up my synopsis? Please have a look at page 5 of my synopsis. And synopsis shall be filed. But I have described the two possibilities. Page 5. Position of law on proceedings further to ICC report. Number 1. Regarding dropping of proceedings against the respondent in the complaint. There being no applicable service rule as per 18(1) of the POSH Act, the procedure prescribed to the central government in office memorandum dated 2/8/2016 would apply. Accordingly, the petitioner would have to make a representation before respondent number 2, the disciplinary authority, which would be treated as an appeal under section 18(1). Then number 2, regarding recommendation for initiation of proceedings against the petitioner for filing a false complaint. The act of the petitioner of filing false complaint of sexual harassment against respondent number 6 amounts to misconduct. Hence, action for misconduct of the petitioner is required to be taken as per the provisions provided under Rule 3C of CCS Conduct Rule 1964, read with Rule 14 or 16 of CCS CCA Rule. The disciplinary authority has furnished a copy of the ICC report to the petitioner. The petitioner has to now make a representation to the disciplinary authority against the recommendation of the ICC. This is the procedure, my lord, contemplated under the service rules.
Yes.
So the alternate remedy that is available to the petitioner of your lordship is to make a representation in either cases before the DA. And that procedure has been upheld by the Honorable Supreme Court as also the Honorable Delhi High Court.
No, the question would be, in a departmental inquiry, the disciplinary authority is entitled to go into the inquiry report, accept it or reject it.
Yes.
The report is fundamentally submitted by the inquiring authority to the disciplinary authority.
Yes. The DA then hands over a copy to the party aggrieved.
So the disciplinary authority is entitled to look into the inquiry report and say, yes, it is done, it is not done.
Yes.
It is
Yes.
proved, not proved.
Yes.
You can say, take
Yes.
an opinion.
Yes.
Now the ICC committee has given an opinion which is conclusive, so far as ICC is concerned.
As far as they are concerned, yes.
Correct.
Yes.
Now it is open for the disciplinary authority to take action on the report without even calling for.
No.
Now, where does the act say? Where does the act say that after the ICC report gives a copy of the report to the complainant?
Yes.
What is the action that has to be taken by the disciplinary authority?
Please have a look at 15. First, let me read 18 to your lordship. And then I will take your lordship to the service rules. Please have a look at this 18 of the POSH Act. My lord, any person aggrieved from the recommendations made under subsection 2 of section 13, we can skip the rest and go to
Yes.
section 14.
14.
So which means both recommendations are there. So and so may prefer an appeal to the court or tribunal in accordance with the provisions of the service rule applicable to the said persons or where no such service rule. So I will not go to where such no service rule because there is a service rule which is applied. And the division bench of Honorable Delhi High Court has said that court and tribunal does not mean an outside body. It says by your service rules.
Correct.
Service rules 14, 15, 16 very clearly lays down the procedure.
I'll consider that. Just on Monday.
Alla, once if
Alla, time ಆಯ್ತು, sorry. I thought you'll finish it early. ಅದಕ್ಕೆ ತಗೊಂಡು.
ಸೋಮವಾರ ಕಂಟಿನ್ಯೂ
ಇನ್ನೂ ಎಷ್ಟೊತ್ತು ಬೇಕು?
ಒಂದು 5 ನಿಮಿಷ 10 ನಿಮಿಷ. ನಂದಾಗಿದೆ ಸರ್.
Matter is now pending before the Supreme Court. She says that.
ಇಲ್ಲ.
That is intra party.
On some facts, my lord.
Inter parties are the question is the same.
No, but my lord, the settled proposition is mere challenge before a higher court does not render the bad law.
Absolutely right. Yes. You're absolutely right.
Then I don't know why she is quoting that.
But why should we, see, the matter is seized before the Supreme Court, and if the Supreme
No,
Court.
till then, Lord, till it is set aside, the order of the Honorable Division Bench holds the field. It's a very clear law laid down that the DA becomes the appellate authority and the party aggrieved has to file a representation. The representation is basically like an appeal memorandum.
It is not an appeal, is what I am trying to tell you.
That is what is ಈಗ representation ಅಂದ್ರೆ it is like a typically like a appeal memorandum. ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ ಅದರಲ್ಲಿ they will find out the ICC was wrong in so and so, this finding is wrong, they did not give me an opportunity, so the DA will consider it. So therefore, my lord, the writ petitioner Monday at 4:30.
Serial. Dictation.
Serial number 43, my lord.
Serial number 24. Dictation. All other cases are adjourned.
My lord, serial number 57, interim order may be extended.
All other cases are adjourned, please.
My lord, file on 1st October, my lord. 35, serial number 35, please.
Take date with whatever date you want.
My lord, serial number 57, interim order may be extended.
My lord.
Interim orders are will be extended. You need not even mention.
Grateful, my lord.
Serial number 43. 2710.
27. ಅದು ಯಾರು ಅಡ್ವೊಕೇಟ್ ಬರ್ಬೇಕು ಅಂತ ಹೇಳಿತ್ತಲ್ಲ. ಮಂಡೇಗೆ ಹಾಕಿ.
ಬೇರೆ ಡೇಟ್ ಕೊಡಿ, ಒಂದು 2 ದಿನ ಬಿಟ್ಟು.
ಮಂಡೇ ಮೆನ್ಷನ್ ಮಾಡಿ, 3 ಗಂಟೆಗೆ ಮೆನ್ಷನ್.
Kindly note, serial number 5 notes.
My lord, one submission is to my lord.
ಮಂಡೇಗೆ ಹಾಕಿದ್ಯಮ್ಮ, ಮಂಡೇಗೆ ಹಾಕಿದ್ದೆ.
My lord, ಅವರು ಸೂಪರ್ಡೆಂಟ್ ಅವರು ರಜಾ ಕೊಡ್ತಾ ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್, ಕಂಟಿನ್ಯೂಸ್ 3 days.
ಮಂಡೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಸರ್.
Yes, my lord.
28 ಕೊಡಿ.
35.
2810.
Kindly my lords.
Sir, wait.
Serial number 5.
Serial number 43.
Matter was argued, my lords, my lords, just wanted, my lords, to see the, my lords, vacancy position. This is directed, my lords.
ಅರ್ಜುನ್ ಆಯ್ತಲ್ಲ ಇದಾಗ.
ನಂದು ಆಯ್ತಾ?
List number 2, my lords, serial number 5.
ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ 2, serial number 5, it's adjourned. No representation.
Not I was here.
ಇಲ್ಲ ಯಾರು ಇರ್ಲಿಲ್ಲ, ಕೇಳಿ. Nobody. ಯಾವತ್ ಬೇಕೋ ತಕೊಳ್ರಿ. ಡಿಸ್ಪೋಸಲ್ ಕೇಳ 2024 ಸ್ಟೇ ಇದೆಯಲ್ಲ ಬಿಡಿ.
Can it be taken on Monday, my lords?
ಆಯ್ತದ ಯಾವತ್ ಬೇಕೋ ಕೊಡ್ರಿ. Take whichever date you want. In the how many times should I tell you? Please take a date of your choice. The calendar is there, court officer is there. Take a date of your choice. The petitioner has challenged an order dated 8/7/2024. Hearing number in fact, hearing number so and so dated 8/7/2024. And the subsequent order dated, and the subsequent modified order bearing number so and so dated 9/7/2024. By which the petitioner was directed to report at VC Farm Mandya.
Transferred.
Was transferred and directed to report at VC Farm Mandya as a professor
On OPG basis.
on OOD basis.
OPG, own pay grade.
On own pay scale. On own pay
OPG.
scale. Full stop. Next paragraph. The petitioner contends really, notes ಮಾಡಿದಲ್ಲಿ petitioner contends that he was initially appointed as a field officer under a comprehensive scheme for studying the cost of cultivation for principal crops in India in the cadre of assistant professor in the respondent university through direct recruitment on 18/1/2006. Full stop. He contends that he was specifically appointed to the post of field officer under the aforesaid scheme, which was fully funded by the Ministry of Agriculture and Farmers Welfare, Government of India. He was thereafter promoted to the post of associate professor under the Career Advancement Scheme, with order dated 1/2/2022. Full stop. He took charge of the post of associate professor on 2/2/2022.
As field officer.
Full stop. However, he continued to be a field officer under the aforesaid scheme. When things stood thus, the petitioner was transferred and posted as an assistant professor at VC Assistant Professor Agricultural Economics, VC Farm Agricultural University Mandya, on his own pay scale.
Pay and grade.
And Ms. Dr. Moheen Sharif was placed in charge of the post held by him, with order dated 31/5/2023. The petitioner questioned the said order before this court in WP number 11/6/26 of 2023. Full stop. He contends that during the pendency of the writ petition, the additional economic advisor, bracket CS, bracket close, Department of Agriculture and Farmers Welfare Economics and Statistics Division, New Delhi, emailed to the respondent university regarding the transfer of the petitioner from the cost of cultivation scheme Karnataka, and stated that the post of field officer cannot remain vacant. The petitioner who is already working under the scheme may be retained and allowed to continue to work as a field officer. Full stop. The petitioner contends that this court, after noticing the aforesaid and also after holding and also the fact that the petitioner, who was an associate professor, would not have been posted as an assistant professor, allowed the writ petition in terms of the order dated 6/7/2023, and held that since there was no sanctioned post of associate professor of agricultural economics at College of Agriculture, VC Farm Mandya, no transfer could be made. The petitioner could not be transferred to an unsanctioned post, that too to a lower grade. Full stop. Next para. The petitioner contends that the Economic and Statistical Advisor, Ministry of Agriculture, Department of Agriculture, Cooperation, Directorate of Economics and Statistics had written a letter to the then Vice Chancellor of the respondent, addressing his concerns with regard to posting of the staff outside, posting out the staff of the comprehensive scheme for studying the cost of cultivation of principal crops without any intimation to the directorate. Full stop. He further stated that if the personnel engaged in the scheme is posted outside the scheme, the entire training would go waste and the interest of the scheme would be affected adversely, and therefore requested to ensure that the staff in the scheme are not posted outside the scheme without consulting it. He further contends that the comprehensive scheme for studying the cost of cultivation of principal crops is a continuous scheme run by the Government of India in order to ensure that field data is collected and compiled annually on cost of cultivation and cost of production in respect of various agricultural crops, and to generate crop-wise and state-wise estimate of cost of cultivation and cost of production of the selected agricultural crops. He claims that the ministry on 20th of March 2002 addressed a letter to all the implementing agencies of the scheme for strict compliance with the directions issued regarding filling up of sanctioned posts along with the details of the implementing agency-wise list of staff strength for the main component under the comprehensive scheme for estimating the cost of cultivation of principal crops in India. Full stop. He contends that time and again, the ministry through the directorate has addressed letters expressing difficulties faced by the directorate due to the shortage of regular staff and engagement of staff on contract basis. The petitioner contends that he is a regular employee specifically appointed under the scheme through the direct recruitment in the year 2006, and he has been trained to work as a field officer in the scheme. Full stop. He further contends that the directorate and the respondent have entered into a memorandum of understanding for implementation of the scheme. Full stop. The memorandum of understanding clearly sets out that the employees under the scheme may avail promotion/higher scale as per the rules and regulations of the university. However, the posts will be reverted back to the original approved scale as and when the person retires. He therefore contends that soon after the petitioner retires from service, the post to which the petitioner was appointed would stand reverted. Full stop. He further contends that the respondent university issued the abstracts of the staff position at the College of Agriculture, Mandya on 23/6/2023 in the cadre of associate professor and assistant professor. This extract clearly indicated that there was no post of an associate professor at the VC Farm, Mandya. Nonetheless, the respondent university passed the impugned order dated 8/7/2024, whereby the petitioner who was working as a field officer and the head of the scheme of cost of cultivation, was transferred and posted to the vacant post of Professor Agriculture Economics, VC Farm Agricultural University, Mandya, on his own pay scale and directed to hand over full charge of the previous post to one Dr. Mohin Sharif. Later on 9/7/2024, the impugned order dated 8/7/24 was modified, whereby the word scheme head was removed and the same was ordered to be read as Dr. Jagannath Olekar, Associate Professor and Field Officer, (Assistant Professor grade). Full stop. The petitioner contends that this order transferring him is one without authority of law, as he was specifically appointed to the post of a field officer under the comprehensive scheme referred above. He also contended that the impugned order is passed without consulting the Ministry of Agriculture as per the memorandum of understanding entered into between the respondent and the Directorate. Full stop. Referred supra. Directorate referred supra. He contends that as per the letter dated 6/6/1996 addressed by the ministry, persons who are working under this scheme cannot be transferred out, as that would adversely affect the interest of the scheme, which is implemented all over the country. Full stop. The petitioner therefore contends that the impugned order transferring him to a post, transferring him and posting him as the professor at VC Farm Mandya is not only illegal, but also in violation of the various directives issued by the Government of India, as well as the memorandum of understanding entered into between the respondent as well as the Directorate. Full stop. Next para. The learned senior counsel representing the petitioner raised the following contentions in support of the writ petition, small Roman I, that the impugned order dated 8/7/24 is one without authority of law, and the same is in violation of the scheme under which the petitioner was recruited. He invited the attention of the court to the order of appointment of the petitioner and contended that he was appointed to the scheme, and therefore, for all practical purposes, he continued in the scheme. Full stop. He contended that once he was recruited directly to the post of field officer under the scheme, the respondents were bound to fall in line with the instructions issued by the Government of India from time to time. He submitted that when the issue regarding transfer of the petitioner from the scheme came to the knowledge of the ministry, a communication was addressed to the respondent, directing the respondents not to transfer the petitioner out of the scheme. Full stop. He contends that when the intention of the respondent was to recruit the petitioner to the post of a field officer under the scheme, the respondents cannot now turn around and claim that his appointment was to the post of an assistant professor and not to the post of a field officer. Full stop. Number 2, that the petitioner who holds a post of an associate professor, cannot be transferred to the post of a professor at VC Farm Mandya, that too on his own pay scale. Full stop. Number 3, that the transfer of the petitioner from the scheme would result in a vacancy in the scheme, which is abhorred by the Government of India from time to time by issuing various circulars and directions and guidelines and directives. Full stop. He contends that the Government of India had specifically directed the respondent not to transfer out any personnel appointed under the scheme without its permission. Therefore, comma, the transfer of the petitioner is improper and is designed to harass him. Full stop. Besides this, he contended that when there is no sanctioned post of associate professor at VC Farm Mandya, comma, he could not be transferred to a non-sanctioned post or a non-existing post by transferring him to the post of a professor on his own scale. Full stop. He also contends that there is no serious public interest involved in transferring the petitioner to VC Farm Mandya. Besides this, comma, he contends, in addition, comma, he contends that the petitioner is transferred to VC Farm as a professor to teach agricultural economics, huh?
Yes.
To teach agricultural economics
For undergraduation.
for undergraduates. He contends that since the year 2006, comma, he has been a field officer under the scheme and has barely taught the students. Therefore, he contends that transferring the petitioner to VC Mandya, VC Farm Mandya,
Professor post is vacant from 2009 and 10 onwards.
did not serve any purpose. He also contended that the post of professor at VC Farm Mandya was vacant since
From 2009, that's 10 onwards.
2009 and 10 and onwards. And the respondents have managed the teaching activities at VC Farm from then on. Therefore, he contends that there is no unearthly need to post the petitioner as a professor at VC Farm Mandya. Anything else? Any other ground?
And it is opposed to my lord, order of this court in earlier occasion, page 55.
How is it opposed? It's not a lower post, it's a higher post.
Maybe higher post, but court says non-sanctioned post madbardu.
He also
There are two
contends,
grounds.
he also contends that this court had noticed that this court in WP number so and so had held that the petitioner could not be transferred to a non-sanctioned post. And since there is no post of associate professor at VC Farm Mandya, comma, the petitioner could not be transferred against a non-sanctioned post.
And their own transfer guidance is not, if it's a post under the scheme, they are exempted from this transfer.
Full stop.
Unique posts are exempted from.
Where is that?
Our reply ನಲ್ಲಿ transfer guidance ಹಾಕಿದ್ದಾರೆ.
He further contended that as per the transfer guidelines prepared by the transfer guidelines formulated by the respondents, comma, those employees,
Page 72, my lord,
those 72 of
of the reply.
Of the reply,
Yes, transfer guidelines.
page 72.
UAS Bangalore transfer guidelines.
One. Page 72 ಅಲ್ಲ?
Yes, ma'am. ಖಂಡಿಸಿ. However,
ಇಲ್ಲಿದೆ ಒಂದು ನಿಮಿಷದ
third clause,
ಅಲ್ಲ ಒಂದು ನಿಮಿಷ
third clause,
page 72 of your rejoinder.
ಅಲ್ಲ, reply statement. ಅವರೇ policy of transfer.
ಬಂದೆ.
Yes.
Statement of objection filed by me, my lord, page 73, annual general transfer.
72.
70.
ಖಂಡಿಸಿ. 72, then what? Clause 3, then 1.
where they are working at a specialized post unique to Bangalore. They are exempted.
He contends that under the transfer guidelines formulated by the respondent, comma, employees who are working against specialized posts, which is unique to Bangalore, are exempt from the applicability of the transfer guidelines. He contends that the petitioner, being a field officer, was holding a specialized post, and therefore he was
And page 73 clause 4 also. Page
and
73 clause
therefore
4.
he was exempt from being transferred.
Page 73 clause 4 also.
Ah,
Request of transfer will not be entertained from teachers or employees who have been appointed against a single specialized post for more than 5 years, so that continuity work is maintained.
the
Even the
request for
request also they can't.
5 ವರ್ಷದ ಮೇಲಾಗಿದೆಯಲ್ಲ ನಿಮ್ಗೆ?
ಹೌದು ಮಾಡಬಾರ್ದು ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರು ಮಾಡಬಾರ್ದು ಅಂತ ಸ್ಪೆಷಲೈಸ್ಡ್ ಪೋಸ್ಟ್ ಇದೆ.
The request for transfer will not be entertained from
Teachers,
who have been
employees,
appointed against a single specialized post for more than 5 years.
so that their continuity work will not is maintained. ಒಂದು ಸ್ಪೆಷಲೈಸ್ ಸ್ಕೀಮು ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಸೇಸ್ ನೋ ಡೋಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್. their own transfer guidelines ಯೂನಿಕ್ ಪೋಸ್ಟ್ ಮಾಡಬಾರ್ದು.
5 years ಆದ್ಮೇಲೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಬೋದಲ್ಲ?
ನಾನು ಎಂಟರ್ಟೈನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ ಅವ್ರು ಆಗ್ತಾರೆ.
Request for transfer
will not be entertained from teachers.
From teachers. From teachers.
From teachers.
ಇದು ಆ ತರ ಅಲ್ವಲ್ಲ?
ಈ ತರ ಅಲ್ಲ. ಇದು ಫೀಲ್ಡ್ ಆಫೀಸರ್ ಪೋಸ್ಟ್. ಅದು ಕ್ಲಾಸ್ ಈ ಕ್ಲಾಸ್ ಅಪ್ಲೈ ಆಗುತ್ತೆ. ಯಾವುದು ಹಿಂದಿಂದು. That is page 72.
Full stop.
Because it is a specialized post to post unique in Bangalore.
5 ವರ್ಷ ಕೇಳಬಾರ್ದು ರಿಕ್ವೆಸ್ಟ್ ಅಂತ ಅದರ ಅರ್ಥ.
Per contra, the learned counsel for the respondents contend that the petitioner was appointed as an assistant professor on 18/1/2006 and posted as a field officer under the cost of cultivation scheme. Full stop.
Pursuant to the notification dated 13 December 2004, please.
Pursuant to the notification dated 13/12/2004.
ಹೇಳ್ತಾರೆ ICAR scheme ಅಂತ.
ಬಂದೆ. He claims, they contend that in the said appointment order, it was clearly mentioned that the petitioner is liable to be transferred within the jurisdiction of the university in the interest of the university work. And his conditions of service shall be governed as per the regulations of the university as amended from time to time. It contended that the university has several campuses and various research stations at Bangalore, Mandya, Hassan, Chintamani, and Chamarajanagar, where activities of teaching, research and extension are required to be carried on by the teaching staff only. Therefore, it was expected of the petitioner to work to teach, involve in research and extension in the university as per section 33, 34 and 35 of the Agricultural Universities Act. Full stop. The respondents further contend that the petitioner was transferred and posted as the professor at VG Farm.
VC from Mandya.
From Mandya.
Against the post of.
Against the post of a professor, only for drawing salary.
Please.
The professor on his own pay scale, only for the purpose of drawing salary However, for all practical purposes, he would be treated as an associate professor. It is contended that there is no bar in law to transfer and post the petitioner to a higher cadre. Full stop. It is contended that the petitioner was promoted under the Career Advancement Scheme 2006 as an associate professor as per the order dated 1/2/2022. And ever since he has been working as an associate professor. Full stop. ಅದೆಲ್ಲ ಇದು ವೇಕೆನ್ಸಿ ಪೊಸಿಷನ್ ಎಲ್ಲಿ ಹೇಳಿದ್ರು ಅದು?
ಯಾವುದು?
ವೇಕೆನ್ಸಿ ಪೊಸಿಷನ್
Please.
126 ಸ್ಟಾಫ್ ಏನು ವೇಕೆಂಟ್ ಇದೆ.
Milord Anisha. R23, Milord.
R23.
How many teachers have been retired from 2019 onwards? Total 126, please.
Page number?
100.
Page 23. Page number 100, Anishar
100.
R23.
Oh.
23 to.
It is also contended that between 2019.
Milord, 31st January 2019, column number 6, please.
31st January 2019.
19. To 24.
From January 2019 till November 2019. There are ಎಷ್ಟು?
Milord, all these, Milord, every year wise, Milord, I produce up to Anishar R28 till Milord July 2024.
November 2019, January 2020.
But not this subject, not this subject.
January 2020 till 31/12/2020.
Till 31/12/23, my lord. My lord may say so.
Till 31/12/23.
Various subject,
Several
not this subject.
assistant professors and professors
Yes.
have retired from service. And that the VC farm at Mandya is functioning with skeletal staff, which has resulted in overburdening the staff.
ಅಲ್ಲಿ ಬೆಂಗಳೂರು ಹೆಚ್ಚಿದೆ.
Full stop.
ಬೆಂಗಳೂರು ಹೆಚ್ಚಿದೆ, ಮಂಡ್ಯ ಅಲ್ಲ ಅದು, ಬೆಂಗಳೂರು.
ಮಂಡ್ಯ ಅಂತ ಹೇಳಿದ್ರು.
Page number,
ಖಂಡಿತ my lord.
one minute.
ಅಲ್ಲ,
Page number.
R23 ನೋಡಿ ತಾವು.
ಅಲ್ಲ, confuse ಮಾಡಬೇಡಿ, ಒಂದ್ ನಿಮಿಷ. Milord, the last order, Milord,
R23 ನೋಡಿ ಸಾರಿ.
R28, serial number 1. Milord, ಅಧಿಕಾರಿಗಳು ಆದಮೇಲೆ ಬೋಧಕರು ಶ್ರೀ ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಎನ್ ಸಹಪ್ರಾಧ್ಯಾಪಕರು, ಅಸೋಸಿಯೇಟ್ ಪ್ರೊಫೆಸರ್, ಕೃಷಿ ಅರ್ಥಶಾಸ್ತ್ರ ವಿಭಾಗ, date of retirement 31/1/2024 in the same department. Again, Milord, serial number 6 also. Then serial number 7 also Mandya. Now we appointed 26 staff on contract basis, all these, Milord.
It is therefore contended that the respondents have felt that the petitioner, being a qualified teacher in agricultural economics, felt the need of the petitioner as a teacher of agricultural economics at VC farm Mandya. Full stop. It is also contended that the petitioner has rich teaching experience in as much as the petitioner has guided many postgraduate students, PhD students, and also and has also taught undergraduates.
Teaching undergraduate, only guidance postgraduate.
Has also taught.
Semester, one semester
He
needs
has also taught
42 hours in a year.
Taught undergraduates, guided postgraduates and therefore has all the potential to continue as a teacher at VC Farm Mandya.
Produce what has been done by them.
Stop. It therefore contends that it is therefore contended that the impugned order of transfer does not foul of any provisions of law. Insofar as the contention that the petitioner was appointed under the scheme and that there are several directives issued by the ministry as well as the directorate, the respondents contend that. What is your answer to that? What is your answer to all these letters issued by the government of India?
That government of India, that is his appointment is 2006. 1996, my lord, address. For the present, don't transfer it, any of this stuff.
2017
Now,
ಮಾಡಿದ.
letter
there is no direct recruitment for the schemes, only by deputing by the university staff. Execution of research by the teaching staff only. It doesn't mean that, my lord, they have been requested me not to transfer any of the employees. My lord, it is my discretionary.
Page
to-
62,
Annexure L2.
L, page 62,
ಇದೆಯಲ್ಲ ಅದಕ್ಕೇನ್
L, L1, L2,
ಡೈರೆಕ್ಟರ್ ಇದಾರೆ, ಅವರು ಮ್ಯಾನೇಟರ್ ಮಾಡ್ತಾರೆ, ಇವ್ರೊಬ್ರೇ ಅಲ್ಲ.
18.
ಫೀಲ್ಡ್ ಆಫೀಸರ್, ಡೈರೆಕ್ಟರ್ ಇಸ್ ದೇರ್, ಅದರ್ ಸ್ಟಾಫ್ಸ್ ಆರ್ ದೇರ್.
ಅದರ್ ಸ್ಟಾಫ್ ಫೀಲ್ಡ್ ಆಫೀಸರ್ ಒಬ್ರೆ.
ಒಬ್ಬ ಒಂದೇ.
ಫೀಲ್ಡ್, ಒಂದ್ ನಿಮಿಷ, ಫೀಲ್ಡ್ ಆಫೀಸರ್ ಒಬ್ರೇ ಇದ್ರು ಸಹ ಅದೇ ಪೋಸ್ಟ್ಗೆ ಇನ್ನೊಬ್ಬ ಪ್ರೊಫೆಸರೇ ಹೋಗ್ಬೇಕು, ಬೇರೆ ಯಾರು ಹೋಗಕ್ಕಾಗಲ್ಲ.
ಪ್ರೊಫೆಸರ್ ಹೋಗ್ಬೇಕು.
ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಅಂತ ಏನಿಲ್ಲ.
Associate professor.
ಇಲ್ಲ, ಯಾರಾದ್ರೂ ಹೋಗ್ಬೋದು. ಟೀಚಿಂಗ್, ರಿಸರ್ಚ್ ಅಂಡ್ ಎಕ್ಸ್ಟೆನ್ಷನ್, ಅದರ್ವೈಸ್ ನೋ ಪ್ರಮೋಷನ್ ಫಾರ್ ದೆಮ್.
So therefore, what about that vacancy in that scheme?
That scheme vacancy person, my lord, Mohiddin, he has already been, my lord, given additional charge. Along with, my lord, he has to work with the director. Director is the supreme.
ಎಲ್ಲಿದೆ?
Please, my lord.
But ಖಂಡಿಸಿ same person is posted. ಖಂಡಿಸಿ my lord, earlier transfer order. ಅಂದ್ರೆ ಅವರು ಬಲಫಿಡೆ ಇಂಟೆನ್ಷನ್ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ತಮಗೆ.
What is there to show that this Mohit?
Kindly take page 50, earlier transfer order. Same person is posted again.
Correct.
Deliberately. He is assistant professor.
ಮೋಹಿನ್ ಶರೀಫ್, ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರು, ಕೃಷಿ ಅರ್ಥಶಾಸ್ತ್ರ ವಿಭಾಗ,
Assistant professor.
ಕೇಂದ್ರ ಸೋನ್ಸ, ಇವರ ಕರ್ತವ್ಯದ ವರದಿಯನ್ನು
He is not associate professor.
ಅವರನ್ನು ಟೀಚಿಂಗ್ ಮಾಡ್ಬೇಕು, ರಿಸರ್ಚ್ ಮಾಡ್ಬೇಕು. ಡೈರೆಕ್ಟರ್ ಇಸ್ ದೇರ್. ಡೈರೆಕ್ಟರ್ ಇಸ್, my lord, the supreme.
He is not a field officer, my lord. He is not a field officer.
No.
You are also not a field
Annexure
officer.
P says,
Yes.
ಜಗನ್ನಾಥ್ ಓಲೇಕಾರ್ ರವರು ಕ್ಷೇತ್ರ ಅಧಿಕಾರಿ, ಬೆಳೆಗಳ ಬೇಸಾಯ ವೆಚ್ಚ ಯೋಜನೆ, ಕೃಷಿ ವಿಶ್ವವಿದ್ಯಾಲಯ ಬೆಂಗಳೂರು ಹುದ್ದೆಯ ಸಂಪೂರ್ಣ ಕಾರ್ಯಭಾರವನ್ನು ಮೊಹಿನ್ ಶರೀಫ್ ರವರಿಗೆ ವಹಿಸಿಕೊಡುವುದು.
ವಹಿಸ್ಕೊಡ್ಬೇಕು. ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಕೊಡ್ಬೇಕು.
ಈಸ್ ಆಲ್ಸೋ ಫೀಲ್ಡ್
ಇಲ್ಲ,
ಆಫೀಸರ್
ಅವ್ರು ಫೀಲ್ಡ್ ಆಫೀಸರ್ ವರ್ಕ್ ಮಾಡೇ ಇಲ್ಲ ಯಾವಾಗ್ಲೂ. ಹಿಂದೂ ಹಾಗೆ ಆಯ್ತು.
ಮಾಡಿಲ್ದೇ ಇದ್ರೆ ಬೇಡ, ಬಟ್ ಅವ್ನಿಗೆ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ
ಎಡಿಷನ್ ಚಾರ್ಜ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದರಿಂದ ಸ್ಕೀಮ್ ಎಂಪರ್ಡ್ ಆಗುತ್ತೆ, ಸ್ಕೀಮ್ ವರ್ಕ್. That is why the central government says, no, don't do it. Continuity will fall down.
Now, my lord, if any letter is addressed by them 2023-24 by the Ministry of Government of India, my lord, I will agree. Somewhere, my lord, when the scheme was introduced, because at that particular point of time, for the present, don't transfer it.
Annexure
This is
L2 ನೋಡಿ, L2 68. ಆಮೇಲೆ
you are not there by that time. Why are you relying upon those?
ನಾನು ಹಾಗೆ
letters?
ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದೇನೆ ಅವಾಗ ಫೀಲ್ಡ್ ಆಫೀಸರ್ ಆಗಿ. L1, L2 ರೀಸೆಂಟ್ ಲೆಟರ್ ಇದೆ,
ಏನಾಯ್ತು?
July 18. ಆಮೇಲೆ
contend that another assistant of associate professor or assistant professor?
assistant professor.
Assistant professor.
Another assistant professor, Mr.
Mohin Sharif, who was posted earlier transfer order, which was quashed by this.
Sir Mohin Sharif.
Yes.
He is appointed to.
ಅಲ್ಲ, ಅಡಿಷನಲ್ ಚಾರ್ಜ್ ಅಪಾಯಿಂಟ್ ಆಗಿಲ್ಲ ಸರ್.
Is
Already
handed over additional charge
ಅಷ್ಟೇ.
of the post of field officer under the scheme.
ಅವ್ರಿಗೆ ವಹಿಸ್ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ.
No. Already
It is
relieved.
further contended that the letters which are relied upon by the petitioner were all long prior to the petitioner being transferred out of Transfer to VC from Mandya.
Contingent.
No, appointment.
2017-18 ಎಲ್ಲ ಇದೆಯಲ್ರಿ?
17-18 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅವರು.
ಮತ್ತೆ 17-18 ಇದೆಯಲ್ಲ?
L ಇದೆ, L1 ಇದೆ, L2 ಇದೆ.
Full stop. It is however, it is also contended.
It's a request letter
that
for fill up the post,
The
please.
appointment of the petitioner is by the respondent. And therefore, the respondent is entitled to deploy the services of the petitioner depending upon the need at its various campuses. Full stop. I have considered submissions made by the learned senior
How-
counsel for the petitioner.
Sorry to interrupt you. Page 71 of a rejoinder. My lord will find the certificate issued by the head of the scheme.
70?
Page 71 of rejoinder. Affidavit ಜೊತೆಲೂ ಇದೆ. ಲಾಸ್ಟ್ affidavit ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅದರಲ್ಲೂ ಇದೆ.
Yes.
ಲಾಸ್ಟ್ affidavit ತಾವು ಎಷ್ಟು ಟೀಚಿಂಗ್ ಮಾಡ್ತಾ ಇದೀರಿ ಅಂತ ಕೇಳಿದ್ರಲ್ಲ ಅದಲ್ಲ.
Page 75.
71
71.
last annexure.
Yes, please.
This is certified that Dr. Jagannath Olekar, field officer, working in the comprehensive scheme studying cost cultivation, principal of Karnataka, Agriculture University Agriculture GKVK, funded by Ministry of Agriculture, Farmers Welfare Department of Agriculture, Cooperation, Farm Welfare, Direct Economics, Statistics, Government of India. He is offering UG course occasionally, and he is 100% engaged in the field officer work as mandated duties of the scheme.
The submission of the
now
senior
got
counsel
the-
for the
The director, my lord, of
as
this
well as the
scheme.
learned counsel for the respondent. The petitioner, it is undisputed that the petitioner is qualified in agricultural economic subject. It is also not in dispute that the petitioner was appointed as an assistant professor
Field officer.
by the respondent, and field officer post ilvalla idralli elliде
ಆ scheme ಅಲ್ಲಿ ಇದೆ. ಹಂಗಾಗಿ ನೋಡಿ
scheme ಅಲ್ಲಿ ಇದೆ, but ಇದ್ರಲ್ಲಿ respondent ಇಲ್ಲ.
ಎಲ್ಲಿ?
Respondent ಅಲ್ಲಿ it's not a sanctioned post.
It is sanctioned post under the scheme.
Under the scheme, not by the respondent.
ಇಲ್ಲ. ಅದಕ್ಕಾಗಿ field officer post upgraded the field that post also. ಅದು ಹಾಕಿದೆ.
Respondent. And was posted as the field officer under the scheme. Full stop. The petitioner cannot claim that he did not have any teaching experience on the ground that his position as a field officer required him to spend substantial time in the field. Full stop. The documents furnished by the petitioner while claiming the career advancement promotion of the career advancement scheme indicates that the petitioner had taught the undergraduate students and also guided the postgraduate students. That the teaching ability and the acumen of the petitioner was one of the criteria that compelled the respondent to promote the petitioner as an assistant professor. Despite the petitioner being promoted as an associate professor, he continued to work as a field officer under the scheme. No doubt, there have been innumerable communications innumerable communications addressed by the Government of India as well as the Directorate, requesting the respondent not to disturb the staff deputed under the scheme. so as to maintain continuity and not to affect the scheme. However, not to affect the scheme, full stop. It is also not in dispute that the petitioner, that the respondent had entered into a memorandum of understanding with the directorate, whereby the respondent had agreed not to transfer any employees deputed under the scheme. However, there is nothing on record as of now to establish that the transfer of the petitioner from out of the scheme would affect this scheme in any manner whatsoever. As rightly contended by the learned senior counsel for the petitioner, the transfer of the petitioner from the scheme would result in a vacancy in the scheme. But this contingency is taken care of by the respondent in handing over additional charge of the post of field officer to Mr. Moin Sharif. Full stop. There. Full stop. Having regard to the contention of the respondent that there have been several several persons have retired, and that the respondent is compelled to take teachers, take assistant professors / associate professors on contract basis, gives an impression that the studying of the students in the university is affected seriously. Full stop. The fact that since it is not disputed by the learned senior counsel for the petitioner that the post of professor at VC Farm Mandya is vacant since the year 2010, 2009-10, gives a stark picture about the quality of studies that the students are undergoing in VC Farm Mandya. Full stop. The contention of the learned senior counsel for the petitioner that the petitioner would not be transferred to a non-sanctioned post, is though appealable at the first blush, but on deeper examination, it shows that the petitioner has been posted as a professor only for the purpose of drawing salary and does not in any way affect his position as the associate professor. Full stop. The finding recorded by this court in WP number so and so is in the context of the petitioner being an associate professor, being transferred and posted as an assistant professor, which was lower in grade. The learned senior counsel for the petitioner was unable to point out any prohibition in law in posting the petitioner as against a higher cadre and a higher post. Full stop. In view of the above, this court is of the opinion that the transfer of the petitioner was to meet a pressing need at VC Farm Mandya, and the petitioner cannot spurn this PURN, spurn the attempts made by the respondent to relieve the teachers who have been burdened at VC Farm Mandya. Full stop. In that view of the matter, this court does not find it necessary to interfere with the order of transfer of the petitioner. Hence, the writ petition is dismissed. Sorry.
Son. Whatever my lord finds it. My lord may to continue the entry mod for a period of 1 week at least. Order copy is available.
No, once.
Because there's an entry mod. ಸ್ಯಾಲರಿನೂ ಇಲ್ಲ ನನಗೆ. 1 ವೀಕ್ ಅಥವಾ 10 days ಸ್ಟೇ ಮಾಡಿ ಅಷ್ಟ್ರೊಳಗಡೆ
ಒಂದ್ ವಾರ ನಾನೇ ತಳ್ತೀನಿ ಬಿಡಿ.
ಅಲ್ಲ,
ಒಂದ್ ವಾರ
ಅಲ್ಲ ತಾವು 10 days ಸ್ಟೇ ಮಾಡಿ
ಇಲ್ಲ.
ಎಂಟ್ರಿ ಮಾಡಿ ಇದೆ.
After
Otherwise
vacation,
ಬರೋಣ ಅಪೀಲ್ ಹಾಕ್ಲಿಕ್ಕೆ.
certified copy after vacation.
ಯಾಕಂದ್ರೆ ಒಂದು 10 days ಸ್ಟೇ ಮಾಡಿ. Wait.